Good morning. Welcome to the Michigan Court of Appeals on behalf of myself, Judge Redford, who will be joining in a minute, Judge Feeney and Judge Letica. This is panel 6 for the July 2026 case call session. We've read your briefs and other submissions and are well acquainted with each of the cases. You do not need to rehash the facts or the applicable law. Oral argument is an opportunity to highlight something beyond what is in your brief or to clarify any point that may not have been as clear as you intended. By court rule, each party is allowed a total of 30 minutes for argument if opposed, or 15 minutes if only one side is endorsed. We do not anticipate that any of you will need the full allotment of time this morning. If you plan to divide your argument time with another endorsed attorney, please advise us of that at the outset. If your clients are present, please inform us so we may welcome them to the court. Because arguments are recorded and published publicly on YouTube, we caution counsel not to mention the name or location of any minors or other vulnerable people. We will now call item number 8, docket number 37922, MWS Ottawa LLC v. Protocam Inc. And I believe we only have one endorsed party for this case. Whenever you're ready.
Thank you, Your Honor. May it please the court. Judge Ackerman, Judge Letica, Judge Feeney, John Moothart on behalf of the defendants in the case. I want to start with something that wasn't, perhaps was alluded to, but wasn't really briefed, and that is the issue of the statute being in derogation of the common law. This came up only briefly in the trial court, but
before we get there, just maybe we could start with mootness.
Yes.
Why is this case not moot?
Right, and I guess I would say there are several things about that. One is that there were 2 motions filed during the course of the pendency of the appeal to dismiss the case on mootness. Both of those were denied. The denial orders were just pro forma. They didn't indicate any basis for the denials. So we are left to guess what the motion panels might have been thinking. But it is the case that this issue has been considered by the court and has been
But in terms of the substance, what is still at stake? There's temporary license that didn't end up being used, and what else? What impact will any decision make at this point?
Well, that taketh and giveth away, Judge Ackerman, that issue, because the fact that the license was issued by the trial court. It was set to commence on July 1st, 2024, and then this court issued a stay that same day. Means that the license was never used. And the motions to dismiss based on mootness suggest that there was
some constructions done and the license wasn't used, which makes me wonder exactly the point of what's in front of us.
That's the taketh part. The giveth is that we intend to, in the event that there's a reversal here, go back to the trial court and request attorney fees, because it's our position in the appeal, and it was our position in the trial court, that necessity is an absolute condition of the operability of the statute. It's a but for there's a gate that one must pass through in order for the statute to be applicable, and that is there needs to be a demonstration of necessity. And here we've got the opposite. We've got a demonstration of no necessity. I mean, the entire project was completed without the license, which to me says, and this is our position, that the case was frivolous, and we intend to go down and ask for sanctions.
Our ruling wouldn't indicate that it's necessarily frivolous. It would just say that it lost.
Correct.
So I don't think we
absent your ruling, though, Your Honor.
Maybe be theoretically helping you a little bit, but not changing
well, certainly the ruling, absent the ruling, we are left with just having had this license imposed on us, this court staying it, incurring all the costs of all of that, and then the license never getting used because it was never necessary. There certainly is absent this court's reversal of the trial court's order, we're not going to be able to go down there and say, don't you really think that now, Your Honor, the Judge Benson, that you should give us award us sanctions? Because I mean, after all, they never used this license, and I mean, presumably the trial court will say, well, that's just because there was a stay. I still believe that, that the license was properly granted, and no, you don't get sanctions. You can't, as a matter of fact, your request is sanctionable potentially. So there's that. And
The license was granted because Judge Benson thought that it was necessary to grant it and appropriate to grant it.
well,
So how does that go to your argument of frivolousness, though?
well, it goes to the argument of frivolousness is because it's been demonstrated that it was never necessary. It was never used. And the entire project was completed without the license. So it can't possibly have been necessary. If the license had been necessary, the project would still be sitting there today, undone.
At most, we'd be ruling in your favor that it wasn't necessary. We wouldn't be ruling that it was frivolous, and you'd still need to go to the trial court.
That's correct.
Yeah, so I just don't really see how this isn't moot.
Well, secondly, this is a case, and Judge Letica had a case recently from the people. It just happened to be a criminal case. I tried to find the most recent statement of the issue. If the issue is one of public significance and one that's likely to recur yet evade judicial review.
This was stayed, so it didn't even evade review in this case. In theory, we could have reached it. I think that the capable of repetition yet evading review is typically where there's some structural reason we can't reach it. An abortion case because pregnancies have an inherent timeline, or election cases that are on a specific timeline. This case is construction. We granted a stay specifically so it could reach here. It evaded review because they completed the construction project without it, and that's not. There's no exception. There's no necessary unique exception based on some structural timing in that situation.
Well, I mean, Judge Ackerman, what you have here is it's a case in which people are citing New York precedent because there isn't any in Michigan. There's one case that.
But it's not, okay, so maybe it's capable of.
It's evaded review up till now.
It wouldn't evade review because we could grant a stay on construction, and there's no inherent structural timeline like there is for an abortion or an election or a bail proceeding. I went through all the cases I could find that had that exception, and I couldn't see anything that would seem to apply to this situation.
Oh, I mean, you're going to rule how you're going to rule, but I will say that it is difficult from this side of the bench, obviously, to brief and argue cases in which there is just no precedent in Michigan for the case, for the situation.
Understandably, but I think I'd be especially weary of doing that where it has no real world impact because the license has already been, the construction's already been performed. The license wasn't used while the stay was ongoing. So I think if there was something, a claim that it's frivolous, I think that's something that you'd have to go to the trial court for or not.
Right. And absent this court's reversal, I wouldn't even try, is the point. Right. Because I mean, the trial court has determined that this wasn't the trial court has determined as a structural matter that necessity is not a prerequisite to the consideration of the balancing of the parties' interests, which is directly in derogation of the common law. And I've got a couple of cases on that I would like to talk about. And so absent some sort of ruling by this court, I mean, we're just stuck with all of the litigation expenses to combat a license that was never used and was never necessary. And we have no remedy for that at all. And this is our property.
I think Judge Letica is
trying to ask a question. Well, you keep saying that they didn't use the license and that means it wasn't necessary. We don't know what modifications they may have made just as a matter of a business decision to push forward.
We actually do know, Judge Letica, what modifications were made. There weren't any made because Mr. what's the fellow's name? Ryan Ramey, who was one of the plaintiff's representatives, testified. He's the Rockford construction project manager. Didn't even know Walbridge, that this license area, this Walbridge Street, was even an option when the contract was signed. That budget was based on access from Ottawa Avenue only. So they made no changes. They just went with the original plan. They had a plan to come in through Ottawa, and they said, gee, wouldn't it be more convenient and cheaper and easier to come in off of Walbridge we'll go convince the circuit court that this is necessary. Did that based on the second part of what all the New York cases say, the analysis, which is it more convenient for the person that needs the license to do this, and is it not too disruptive to the property owner? And so that was the trial court's ruling, but then there was never any use of that at all. There was no change in the way they did things. They did it exactly the way they budgeted and planned it from the beginning.
Again, I just don't see how like a finding that this is moot because the construction is completed and it wasn't used would negate an argument you could potentially have at the trial court. But I also don't think that's for us to decide. It's just there's no impact for our opinion. So.
Well, the other thing I'll say about it seems as though your mind's made up, Judge Ackerman, and I don't want to be perceived as arguing with with the court. There's also the fact that this court didn't evade judicial review here. Yes, that's true, but no guidance for future cases is created. I mean, the mere fact that this court has, for example, stayed the trial court's ruling and then not ruled whether it was correct or not, simply said stop now, is not really judicial review. That's just putting one's finger in the dike until, I guess, everything expires, and then well, there's no need to decide it now. I mean, that's not an effective, I believe, I would submit, not an effective way of moving forward with this statute being used the next time. We still don't know there's an essential difference between our perspective and the perspective of the trial court, which is the trial court says, I've decided this is necessary because it makes it easier for the petitioner, which is not what the New York cases say and not the intent of the statute, I believe.
But wouldn't you agree, though, that given the circumstances, so the stay was made, the project is complete, the lease is never used, if we start talking about the statute itself, isn't that just going to be dicta? I mean, taking your line of reasoning.
I don't believe so, because the principle of if the issue is one of public significance and one that's likely to recur yet evade judicial review, and I mean, I understand this isn't like a set timeline, but typically construction projects do have budgets, they do have timelines, and they do have to move forward within specific parameters. And so I think this is a situation in which it would be beneficial to the bench and the bar to have a ruling about what is I mean, there's only been one case in Michigan jurisprudence that's ever even mentioned this statute.
Wouldn't that cut against likely to recur? The fact that it hasn't come up, wouldn't that mean it's not like a situation that the statute isn't used often? Okay, well, all the more reason we shouldn't issue an advisory.
We don't know that. I mean, it could be the case that the times in which the statute has arisen are ones like this, where there's a resolution that just happens because due to the passage of time, and there's no precedent established. This case will establish nothing in terms of guidance for the bench and bar going down the road. I mean, it resolves this case, I guess. I mean, as to this issue for the time being, assuming that there's not yet another request to use our property in the future for some other issue in the same area by the same parties. But it doesn't help anybody do anything from here on out. And I do believe, like I said, that the fact that we have been incurred all these fees just to stand here now before you and say, well, I guess it's moot, so none of it matters, is there's something about that seems unfair, and this statute is in direct derogation of the common law, should be construed. I mean, absent this statute, we have cases like cruise die casting. Then this is not in the briefs, so that's why I wanted to talk about it. It's a 1963 case at 369 Mish 541.
Wait, 369 Mish?
Yes,
Yeah.
Mish 541. Yeah.
Okay.
And this is not, as in this case, an exclusive easement. This is just a regular garden variety, ordinary everyday easement that the court was dealing with. And the point of this is that easements are equally as sacred as fee interests. They're not less important than fee interests. The court at page 544 says the neglect of the grantee of the easement to enjoy the easement would be no more significant in its bearing upon his rights than the neglect to enjoy the freehold to which the easement was appurtenant. This is a situation where there was an allegation that the easement had been abandoned, and the Supreme Court said, well, you can't abandon an easement unless you do it. There are standards for doing that, but the mere non-use, it's, my kids have left, they've gone to college. I've got an extra bedroom. Doesn't give my neighbor the right to come in and say, geez, it'd be convenient for me to use that. It's the same thing with an easement. Whether you use it or you don't, or whether and to what extent it's critically important that you have full use of it, does not justify absent this statute, the invasion of your property rights by your neighbor. The other case I wanted to mention is and these are sort of classic cases, Ives v. Edison at 124 Mich 402, 1900 case. And there was a building on the corner of Lion and Canal here in Grand Rapids. There was a stairway. The plaintiff had an easement within the building, and he wanted to move this stairway to better suit his goals. And the Supreme Court again said the title in fee, which he had permission from the fee owner, but he didn't have permission from his co-easement owner, was no more sacred than the easement held by the complainant. And Justice Moore, the quote from the case,
only one side is endorsed. Maybe after this, we'll wrap it up.
You bet. Says, I know of no law which will justify such an invasion of the rights of property. And again, this is an easement belonging to one person to serve the convenience or necessities of another. That's the common law. That's the rule absent this statute. You can't invade somebody's property rights to conserve either the convenience or the necessities of another. It's the duty of the courts to protect persons in their right of property, even though the holdings may be small, instead of justifying a trespass or compelling the owner of the property to accept something else in the place of it. And so that's why this statute, being what it is important for it to be construed strictly, for it to be construed carefully, and to the extent that we're looking at New York law to be construed in accordance with those cases, which, as we briefed, every single one of them requires a finding of necessity first, and then the balancing of the equities and conveniences and all the other matters after that. And so the court determines not to issue an opinion on this, not to rule on the meaning of this statute, then it's predictably this is going to reoccur, and it's difficult to get here. And motions for immediate consideration were filed, and all that. And I'm not criticizing anybody. I mean, we're all busy, and y'all got to make the decisions based upon your docket, all of your honors, and appreciate that. But we would ask that you do actually issue an opinion on this and rule on this, so that we can proceed with the rest of our case in the trial court, and also for guidance of the bench and bar. Thank you.
Thank you as well, argued. We'll take a brief recess and then return with Judge Redford shortly. All right. Thank you all for your patience. We'll continue with item number 1, docket number 368551, People v. Logan.
Good morning, Your Honors.
Good morning, Ms. Owens.
Morning.
May it please the court. My name is Mary Owens, and I'm here on behalf of the appellant Ramon Logan. This is an appeal from a resentencing. So accordingly, the issues relate strictly to the resentencing. And it was 2.5 years ago that I wrote this brief. And since then, the law has changed a little bit. The issue that we raised on appeal was that the resentence also imposed by Judge Trusak was disproportionate and unreasonable, given the fact that my client, Mr. Logan, was under 18, a minor, at the time that he committed this offense. He was either 16 or 17. And when he was resentenced, of course, and this court initially vacated the sentence and remanded for Judge Trusak to articulate the reasons that he exceeded the guidelines. The guidelines were up to 31 on the maximum, and he went up to 38. So on resentencing, all Judge Logan did was take 7 years off the minimum and essentially impose the same sentence, 31 within the guidelines, plus 2 for the gun, up to 100 years on the maximum. And this is for a conviction for second-degree murder, not first-degree murder. And as we in the criminal defense community are highly aware, the law regarding sentencing juveniles has greatly changed in the past 10 years. And interestingly enough, 2 cases that did not make it into my brief, because brief was written 2.5 years ago, have been decided within the last 9 months, People versus Eads and People versus Campbell. And I think, Judge Feeney, that you were on the panel that decided People versus Eads, if I'm not mistaken. That doesn't sound
Were you
familiar?
on, Eves?
Okay, well, maybe it's not you then.
Possibly, but and that, to tell you the truth, that is one of the things that strikes fear into our hearts when counsel mentions, I think you're on that panel. I'm going, so because I'm my brain is all full of these cases that we're
Okay.
hearing today and tomorrow. So I don't doubt what you're saying, Ms. Owens.
Well,
And
I'm going to tell you what it's about.
okay,
anyways,
good.
Okay.
Thank you. I appreciate that.
I don't
Um,
think any of the 3 of us were on it. I think
Okay,
Judge Borello, Judge Mariani, and Judge Murray.
okay.
Thank you.
Judge, the Eads case involved a defendant who was also sentenced for second-degree murder and he was given a term of years. He was not given a life sentence. He was given 50 to 75. And this Court of Appeals not only held that it was disproportionate and unreasonable, given the fact that he was a minor, but that it was unconstitutional. Under recent developments of the Michigan Supreme Court, I think it was the Taylor and Sarnecki cases, which were decided in the past year and a half. And then and I believe Eads is on appeal to the Supreme Court. So we don't have a final decision with regard to that. But the People versus Campbell decision, which came out after Eads, essentially says the same thing, that when you give a huge long term of years to a juvenile, it can rise to the level of unconstitutionality. And that's what we're arguing, in addition to the disproportionality and unreasonableness of the sentence that Mr. Logan was resentenced to. We think it's unconstitutional to have him sentenced to 100 years on the max. He could be flopped every few years after 30 years, the time when he's first eligible for parole, and to exceed even the term of years set forth by our legislature in 769.25 when you're sentencing a juvenile convicted of first-degree murder. And that statute says it's no more than 40 on the minimum and no more than 60 on the max. So unfortunately,
How is that not, counsel, a function of the legislature? When, as far as placing an indeterminate sentence, what the highest number a court can have, how is that not, if the legislature obviously knows how to do it, they've done it. If they chose to do it in another setting, if they haven't yet chosen to do it in another setting, how is it a proper function of this court to indicate that that is in and of itself unconstitutional?
well, Your Honor, the courts always act independently of the legislature.
Yeah, I'm
And
well aware of
according
that.
to-
I remember, I remember even in law school, there's 3
Yeah,
branches of the
yes,
government and
yeah,
in
you're right.
civics.
And
So,
that's
yeah,
a-
I get
that's a
that. But I
truism.
mean, it's in all seriousness. I mean, if the legislature has said, you know, they've reexamined this, it's the 40 to 60 is the most that can be given to a juvenile who's convicted of first-degree murder. Is it the role of the judiciary to say that we're going to change the law in every case. It has to be this.
Well, isn't that exactly what happened after the Miller decision? Right? The Miller decision, of course, that involved the United States Supreme Court saying that you can't give natural life to juveniles. And then following that, the Michigan legislature acted.
Right.
And there's no reason to think that that our legislature cannot and will not act.
No,
in the
they
same
absolutely
sense.
can.
And these two
can.
these two decisions have just, they're recent, just within the last 9 months. For all I know, that issue may be wending its way through the legislature. But I don't see how you are forbidden or foreclosed from declaring it unconstitutional. And as a matter of fact, as I mentioned, those two cases have already said that it is. So even if we accept that 30 years,
In each, what was the low number?
50,
This is 31.
well, the maximum is way exceeding.
I understand
each
that.
case.
I mean,
I think that sort of brings the whole sentencing into question. And it does also, affect what Judge Trusock actually did. He didn't really acknowledge any of the snow factors. He just said, well, I'm familiar with the Miller factors. And I think it's clear what he did. He just didn't want to have to,
boy, he eliminated 8 years of incarceration.
well, plus 2 years for the gun. I
Well,
mean,
that
so
was
he's still
there.
got- That's a lot of
Come
time.
heck or high water, that was going to be there.
That's
right?
a lot of time.
I don't
for a
disagree. I wouldn't want to
17-year-old.
do 3 minutes, let alone 31 years plus 2. Every sentence is enormously impactful on the defendant and the defendant's family. I understand that. Every day is difficult to be away from those you love and care about. But the 2 was going to be there. And so it was a reduction of in excess of 25%.
Well, he didn't take 8 years off. He took 7 years off. Not, okay, so that's, battling over.
I'm not going to get out my phone with the calculator function and do the percentage.
Well, anyways, Judge,
Anyway,
that's
okay.
that's our
Yep,
argument.
nope, understood.
That once you get to the point of giving 100 years on the max, it becomes unconstitutional, even if it's only 30 years on the minimum. Once you get into that, I don't see how you can give him 100 years on the max. I mean, you could invalidate part of the sentence. I don't see any reason why you couldn't do that. But we think that the two cases that I've brought up today really call for some scrutiny of his sentence. And we believe that he should be entitled to have this safe sentence also vacated and have him rebanded for resentencing again. And that's my argument.
Thank you.
Thank you.
Thank you, Ms. Owen.
Thanks.
All right. That matter has now been submitted. We will now call item number 2, docket number 368095, People v. Golden.
Good morning, Your Honors. My name is Natalie Rosenblatt on behalf of Mr. Derek Golden. I'm from the State Appellate Defender Office, and I'll be handling this matter for my colleague, Jason Eggert. I'd like to spend my time focusing on the search that happened in this case, as well as the 404B other acts evidence. Mr. Golden was painted as a drug dealer at every step of this case. He was convicted and searched based on his past and not based on the present facts before us today. I'd like to start by turning to the search warrant affidavit and the 3 things that were relied upon to issue the search warrant. First being allegations of Mr. Golden's prior drug-related conduct, which was from 6 to 20 years ago. The second being a small baggie that was found in an unrelated second location. And the third being officers' training and experience, which had no particularized relevance to this case. Because of this, the search warrant was invalid and the evidence should have been suppressed. So turning to the first allegations of Mr. Golden's prior drug-related conduct from 6 to 20 years ago. The Sixth Circuit in the United States versus Brown, as well as the Michigan courts, have ruled that drug dealing alone, absent other evidence, such as additional investigation or surveillance, is not enough to establish probable cause that drugs or evidence to be sought would be found in the place to be searched. Here, the officers cited to Mr. Golden's prior drug-related conduct, but they did not provide any concrete specified facts that would establish that criminal activity would be found in his girlfriend's home. We have the small baggie that was found at Mr. Golden's feet near the patrol vehicle, but this was miles away from Mr. Golden's girlfriend's home, and there were no specific concrete facts stating that this small baggie indicates that evidence would be found within his girlfriend's home. We also have officers' training and experience where they stated that it is common under officers' training and experience that drugs are found in a second location. However, in cases like People v. Bugs, and again, the Sixth Circuit in the United States versus Brown has stated that officer training and experience without additional evidence does not satisfy probable cause.
I just want to go back factually because we have a situation where his girlfriend's daughter got pulled over driving his Charger, correct? And then that linked him to the girlfriend's home. And then I think it was We Met. Yes, We Met was, attempting to locate him on an unrelated misdemeanor warrant. All right. So that one, we're all set. So they were able to track the fact that girlfriend's daughter was driving his car. So then they went and watched girlfriend's house. And then they saw him coming away from girlfriend's house. They did the stop. They pulled him out of the car. The baggie dropped at his feet. But then he had, $2,000 in small bills on him. And then I've never heard of it before, but apparently they take lotto tickets and they fold them up. And
Oh,
they're
yeah.
called,
I
Bindles.
saw that a lot in my previous life.
really? Okay.
Yeah, it's
Yeah, they're called
it's called a
bindles.
bindle.
Yeah, we're in the car.
I'm not an
So
expert, but
it- And you don't think that that's enough? I mean, we got the bag of drugs that falls out of his pocket, the fact that he's coming from the girlfriend's house, he's letting the girlfriend's daughter drive his car. He's got a big wad of bills, because 2,000 bills in small denominations is a pretty large chunk of bills, and the bindles all over the car. You didn't think that was enough?
Your Honor, a few answers there. The search warrant affidavit only cited to the fact that the girlfriend was pulled over in Mr. Golden's car, and therefore that they connected his ownership to the fact that that car was parked in his home. But they didn't provide any facts, specific concrete facts that his vehicle being parked in his girlfriend's home indicated with a fair probability that evidence of drug trafficking would be found within this home. Additional evidence could have been that vehicle pulled out, and then the officers, after following him, observed him stop somewhere and do a drug exchange. It could have been that while observing that vehicle in the home, they observed people walking up to that vehicle and doing some sort of drug exchange. There could have been a confidential informant. But a magistrate can't make inferences based off of these generalizations. And then as to the items that were found with Mr. Golden during the traffic stop, again, the traffic stop was conducted on an unrelated misdemeanor domestic violence warrant. All of the observation of Mr. Golden beforehand was related to that misdemeanor warrant. And so they weren't collecting evidence regarding any dealing with drug activity, nor did they see any. The fact that they
well, there's
did
a bag of
find-
drugs underneath his feet. And didn't the officer then go look at his cruiser's dash cam? There was no bag of drugs before it started. And when your client is out there, then there's a bag of drugs, right?
Correct, they did.
Oh, okay. So we know that the issuing judicial officer has affirmative evidence that there are controlled substances in the immediate vicinity of your client that were not present before your client was there. Can you take any inferences from that?
Judge Redford, the fact that the baggie was found, and it wasn't there before, of course, we have the inference that this baggie came from his body, but there's no evidence that there was no citing to concrete specific facts that this baggie means that there would be evidence of drug trafficking within Mr. Golden's girlfriend's home. In People v. Bugs, for example, the search warrant affidavit cited to very similar facts, very vague assertions. It cited to the fact that officer training and experience, for example, where there is drugs found in one location, it is common that there will be drugs found in another location. In that case, the court stated that that's still not enough. The fact that this evidence exists and that officer training and experience indicates that there could be drugs elsewhere is not enough to establish that evidence of drug trafficking would be found in this second unrelated location.
But also, I want to take you to the fact that your client argued in the motion to suppress that there was no evidence that he lived there at the girlfriend's house on Huizinga, right? And he argued that there was no proof of residency of anything on his name, such as electric bills, gas bills, nothing regarding it tying him to the residence. But then after the court denied the motion, then he argued for purposes of the suppression motion that there was evidence that he did reside in the house because there was a letter addressed to him at the house, clothing of his size 5X, which is not usual clothing that you have sitting around. And the trial court asks, is your client saying, it's not my house and I didn't live there and nothing's mine? And then counsel said, yes, he's not admitting that it was his house or his clothing, but they said he lacked standing to challenge the search because you can't say I was living there and I wasn't living there and still have standing to challenge the search.
To clarify your question, Judge Feeney, you're asking about the motion to quash
Yes.
versus the motion to suppress. Regarding the motion to quash, Mr. Golden wasn't arguing that he wasn't denying the existence of evidence. He was just arguing that for the purposes of this motion to quash, the evidence that was offered at the preliminary examination was not sufficient to justify binding the case over. And then regarding the motion to suppress, whether Mr. Golden denied his connection to the home doesn't have much bearing here because when the trial court denied the motion to quash, the trial court stated on the record that it found the facts sufficient to establish that Mr. Golden was connected to the home. And so when the judge then moved to the motion to suppress, there should have been and there was no need for any factual finding. This was a legal determination. And when we looked at the four corners of the warrant to determine whether the motion to suppress should have been granted and whether Mr. Golden had a reasonable expectation of privacy and therefore standing, all of the evidence the trial court needed and had was already established through the preliminary examination. And so I argue that Mr. Golden did have standing. Mr. Golden certainly had a reasonable expectation of privacy
How
within.
do you have reasonable expectation of privacy under our laws when you say it's not mine? How do I get to have the ability to say, this is not mine? It is, I don't own it. I have no possessory interest. I have no privacy interest. How do I have standing to say you can't do something, governmental agent? What case stands for that proposition?
Your Honor, to your question about reasonable expectation of privacy first, United States v. Olson, for example, states that an overnight guest, a person who doesn't even have a legal ability to invite someone in, for example, may still be considered an overnight guest, and therefore overnight guests have reasonable expectations of
Your
privacy.
client asserted it wasn't his, right? And he didn't live there. He said that. Is that correct or incorrect?
My client, whether my client asserted.
That's just a straight question. Did your client assert that this was not his residence and that he did not live there? Yes or no?
Yes, but
Okay.
But we also have facts placed on the record that Mr. Golden's clothing was found there, that Mr. Golden spent 3 to 4 nights a week there.
But he's telling the court that he didn't live there. So how does he have standing to say you can't search it when he's a stranger to the premises, according to his own averment to the court?
Well, whether Mr. Golden lived in the home, whether Mr. Golden asserted that he had no connection to the home doesn't impact one's ability to challenge a motion to suppress. The facts before the trial court were that Mr. Golden spent 3 to 4 nights there. We have testimony from his girlfriend stating the same. We have testimony that Mr. Golden had key to the home. Mr. Golden had the right to present defense. He was arguing that for the sake of the motion to quash, there was not enough evidence to establish that there was probable cause to continue this case forward. Regarding
I just want to give you a warning because there's only one side endorsed. We only have a couple of minutes if you want to, 2 minutes if you want to.
Thank you, Your Honor. I will move on then just to the 404B acts. I just want to address prejudice there. The prejudice here is that Mr. Golden's defense at trial and his defense theory was that the drugs were not his and that there were other people, there were other probable suspects that these drugs could have belonged to. We have testimony that people were going in and out of the house, that Mr. Golden's girlfriend's daughter and child lived there. And when propensity evidence that Mr. Golden was a drug dealer 20 years ago, that he was engaged with drugs 6 years ago, and that drugs were found now, it made it impossible for that theory to be credibly delivered to the jury. Additionally, the drugs that were found at the patrol vehicle were charged with the drugs that were found within the home. And so there was no ability to disentangle that evidence. And so even if we had a jury instruction or limiting instruction, the jurors received information, propensity evidence that Mr. Golden was a drug dealer. And the fact that this case was largely circumstantial and the fact that there was no evidence that Mr. Golden had been observed dealing drugs, there was no surveillance that Mr. Golden made an exchange, there was no confidential informant. The fact that the jury heard propensity evidence that Mr. Golden was a drug dealer bolstered that circumstantial evidence. So I ask that this court grant Mr. Golden a new trial. Thank you.
Thank you. The matter has now been submitted. We will move to item number 3, docket number 367672, People v. Udell. Both sides are endorsed, but only see one, so.
Waived argument last week.
Oh,
Okay.
right.
Good morning, Your Honors. Nick Bostic on behalf of Mr. Udell, the appellant. My client's wife, his daughter, and her significant other made the trip down from Muskegon. They're in the first row over my left shoulder. Initially, I want to clarify something in my brief. I think I flopped back and forth between count 1 and count 2 in my issue 1. So my issue 1 addresses count 2 of the information, which happens to be the first listed count in the amended information. I don't know why they did it that way, but my issue 1 is count 2 of the information. The briefing indicates that Mr. Udell should prevail on this issue because of People versus Johnson and the express language of the statute. I think that's really all I need to say about the legal merits on that. But I was curious as to how, with the testimony of the young man the jury could find penetration. So I went back and looked to see if they were given an option for CSC second degree. They were not. It was not on the verdict form. It was not in the instructions. And trial defense counsel agreed. He did not object to the instructions when given the opportunity. So then I looked at the actual instructions, and the trial court gave option 2B and option 2C of 20.1. Well, that's the problem. 20C is for cunnilingus, and the notes, the use notes, make it very clear that's what it's for. It does not include a repeat of the requirement of penetration, however slight. And so the trial court obviously didn't, they read it verbatim. 2B is to be used for fellatio, according to the use notes, and it was given, and of course it requires penetration. But the very next paragraph in the instructions included the definition for cunnilingus. So I think that's part of the reason the jury was able to find him guilty, is because that instruction was incorrect and it should have been objected to. I don't think I briefed that. I was just curious as to, when I was doing my prep, and I ran across that. Moving on to the way to analyze this, I get credited a lot in these cases for doing all my analysis in hindsight. But what I want to point out that, the test obviously is we don't use hindsight. We look at the strategic choices that led up to the presentation and the strategy, if there was one, for the defense. So what I really want to do is use sort of a visual. I have placed in my brief in one bucket a lot of things where I complain about what trial counsel did. I've placed a lot of things in another bucket about things that I claim he didn't do but should have done. Now picture a plank along atop those two buckets, and counsel stands on that plank at the end of the trial and says, that was my strategy, so I was not ineffective. And that's what the trial court did. But that truly is hindsight. We have to go back one more step. So now the visual changes. Instead of the plank on top of the buckets, put the buckets on top of the plank. Supporting the plank on one end is his choice to use this calendar process of having the family testify that the two people could never have been in the home over a 17-month time span with only the two of them there. That's unreasonable. It was convoluted. It was a mess. The transcript shows how it was presented. The exhibit should be in the trial, in the file, and it's a mess. To show that over 17 months with my client unable to drive, the child's mother unable to drive, is simply too much of a stretch. On the other end of that plank, holding up those two buckets, is his choice not to use the testimony about erectile dysfunction. So his entire approach rested on those two strategic choices made before the trial started. And of course, at the Ginther hearing, he explained that the choice not to use the erectile dysfunction was based on a single report, anecdotal report from a single juror who may or may not have been speaking on behalf of just himself or other jurors, who said that they didn't think that erectile dysfunction information was believable.
But come on, how often do you have any inkling from any juror that the way that you were intending to present your case or not present your case was good or bad? One of the great parts about the Hillman Trial Advocacy Clinic that we have here in Grand Rapids that Doug Hillman started years ago was for the advanced session, you can watch jury deliberations. That is the only time you can see what's going on. And in this case, counsel had that comment from the first case, right? So you're asking us to fault him for possibly considering something that one of the jurors mentioned? That it stretches
Yes,
Fidelity.
I am not afraid to stretch things. Yes, that's exactly what I'm asking.
But I was struck, so the first trial ends in a hung jury.
And he did present erectile dysfunction.
Okay, right. And he talked, he somehow, is there communication after the jury is discharged between the lawyers, the court, and the jury that's discharged?
You're talking about after the first trial?
Yes.
Yes. He testified, if I'm recalling correctly, I know this is all from the Ginther hearing, so I'm picking my memory here, but I don't think it was like a formal, okay, come in and let's have a chat. It seemed to me like it was just sort of ad hoc, if I'm recalling his testimony correctly. And it was a one-on-one, it was my recollection.
With a juror.
A juror. And the juror, I think his testimony was, we didn't think. So whether the juror was actually speaking on behalf of more than himself or not, I mean, it was just an informal conversation. And Judge Feeney, your point is very well made, because I would love to be able to stand here and say to you, well, he used it at the first trial and it was hung. Therefore, it was a mistake to not use it at the second trial. But we all know it's not that direct. It's never that direct.
Yeah.
And I think your point has an additional aspect to it. And that is, not only do we sometimes get to talk to jurors after a trial, how often in a career do you get to talk to a juror after a trial, knowing you're going to turn right around and try that case again? That almost never happens. That is
I
extremely.
can tell you the number of times it happened in hung juries when I was presiding.
Me too.
And the
Well, no, I didn't
number
preside.
is zero.
Right. I didn't
know.
preside anywhere, but
Yeah.
all my trials, never.
Yeah, I was very surprised that there was an opportunity to talk to a juror without a verdict.
And that's why I think it was ad hoc. That makes
Okay.
sense. The reason I think I can argue that it was an unreasonable strategy is because what one juror says anecdotally is not a substitute for an attorney's professional judgment about preparing for a trial.
But that's what he said. That's what he explained at the Ginther hearing was the basis for his decision. So can we say that it's so wildly unreasonable? I don't think that we can, because when the attorney's sitting there saying, this is why I chose this path. These are the decisions that I made. And we can't do it. All the cases say we cannot look at that testimony with the benefit of 20/20 hindsight,
Right.
because we all know now what happened then. And so, if ifs and buts were candies and nuts, every day be Christmas. So,
I think what my visual has done is I've shot myself in the foot because I've focused too much on these two things. Because we have to remember, this is all in the context of a conflict of interest. So the real issue, there's a third pillar supporting this plank that's just as weak as the others, and that is the conflict of interest. Going into this trial, the second, well, from the moment the representation started, frankly, and all that detail, I don't need to rehash it to the panel. All that detail's in the brief. It's in the record. So I'll leave it at that. But I really do think that it is possible, and it is plausible in this case to say that simply relying on that one juror statement, it was not reasonable, but in context of everything else, not just standing alone. So I think I need to make that clear.
well, and with respect to the conflict, and tell me if I'm wrong, because I've got so many cases swimming around in my head, that he did not work on the prior case, right?
To his best recollection, he did not.
And like Chinese wall, or whatever you want to call it, that they used to call it, you build that wall so that nobody's talking to each other and had nothing to do with the case or the representation. And then the file, that it didn't even really seem that much was taken from that file. So the conflict of interest argument doesn't really impress me as being as strong as it could be.
Well, and Mrs. Udell testified that she gave him information all along about the problems that were ongoing in the household and the reasons for CPS involvement. He was the last one to check the file out, according to the public defender records, and that's in the Ginther hearing record.
The social file
Trial
as well?
counsel was the last person to check the file out of the public defender's office. He had the file. He was the last one with it, and it was missing at the time we made our requests. The only reason we pulled those even numbered pages into those records was because the prosecutor's office happened to still have what trial counsel sent him prior to trial. So we were able to get a complete set of those quarterly reports. So I'll move on to the last thing is sentencing. It's almost moot, but of course, if some of these CSC 1 cases get reversed or vacated, it'll matter. And that was OV 11. Any one of these counts, there was only one penetration of count 2 and 4. So OV 11 was improperly scored at 50 points. I will rest on that unless the panel has questions.
I want to circle back to the jury instructions, if that's all right.
Yep. Okay.
You indicated in the instructions to the jury, standard instruction 20.1, subpart 2, subpart B, and subpart C were given. Is that correct?
Volume 2, page 197.
And so in the instruction, it reads, defendant is charged with the crime of first degree criminal sexual conduct. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant engaged in a sexual act that involved, under 2B, entry into the victim's mouth by entry into
For that count,
Yeah.
it'd be defendant's mouth.
the defendant's mouth by the victim's penis. Is that right?
Yes,
Any entry, no matter how slight is enough, does not matter whether the sexual act was completed or whether semen was ejaculated.
that was given.
Okay. And then also sub C was given, which says touching of the victim's what?
Genital organ.
All right. With the defendant's mouth or tongue. Okay. I see.
But look at the use note.
No, I see the use
Yeah.
note.
That's the problem. C is for cunnilingus only. And of course, the instructions are not authoritative law, but that's
Correct.
part of the problem is that when they wrote this, they split it for those two types of oral sex and both were given. So that's where I caught that when I was prepping last week. And then on, let's see, volume 2, page 205, defense counsel had an opportunity to object. He did not.
If you didn't object, how is it not waiver? When you agree to jury instructions and you're specifically given the opportunity to otherwise indicate you have a problem with it and you say, no, we're satisfied, how does that not resolve the issue?
Ineffective assistance of counsel.
But that was not found. Fair?
Fair. Plain error.
Karen's. Right? Tough standard.
They all are.
Not impossible.
They all are.
No, I don't, yeah.
They all are from where I'm standing.
No, I understand. And that's a fair statement. All right. Thank you. Thanks for taking the assignment.
Thank you.
Thank you.
Thank you very much.
The matter has now been submitted. We will now call item number 4, docket number 372353, People v. Smith. Again, one side is endorsed.
Stanley, nice to see you.
Your Honor, it's great to see you, sir. And I think
Been well, I hope.
I've been well, thank you.
Good.
I thank the court, Attorney Frank Stanley appearing on behalf of the appellant defendant Wyatt Smith. I certainly commend the panel. I'm not surprised by everybody's preparation for the previous cases, so I'll try to be succinct and specific. If there's questions I can answer the court, I'd certainly like to do that. Since I think all of my arguments basically are cumulative of evidence that was admitted, what I believe erroneously on 768.27A, I'd like to start with the first argument in my brief. I acknowledge this is a higher standard because the standards of abuse of discretion. That is the review that's required here, but I would point out in the Duncan case cited in my brief, an error of law is always abuse of discretion, and I believe this issue was fully preserved. Prior to trial, notice was provided by the prosecutor of intent to admit other acts evidence pursuant to 768.27A. Paragraph 3 of the government's notice in part stated that people intend to offer other acts evidence at trial pursuant to 768.27A. Paragraph 3A on the second page of the notice, the people intend for the jury to hear all the acts perpetrated against the victims by the defendant through the time frame and to consider them pursuant to MCLA 768.27A for any matter which they may be relevant, including but not limited to sexual purpose and propensity. I quote the language on page 20 of my brief of 768.27A, and it is acts that are committed and other acts that fit within the definition of sexual misconduct. That is the relevant point here, and the analysis probably begins with People versus Pedersen, 2276 Mishap 613, allowing a prosecutor to introduce evidence of the defendant's uncharged sexual offenses against a minor without having to justify their admissibility under 404B. People versus Smith, also cited in my brief, the analysis is the proposed listed offenses against a minor and make a determination whether the listed offenses are at issue relative to the crime charged. And if the listed offenses at issue, the analysis begins and ends with 768.27A. I do go through analysis in my brief, and I'm not going to belabor the court. We all know the analysis under 404B pretty clearly, but that is in essence a much different standard where the court has to go through analysis of a proper purpose versus a prejudicial impact. And it also discusses that we create the real possibility that an individual is going to be convicted because they appear to be a bad person, a propensity to commit a crime versus the evidence at issue. Beginning on page 25 of my brief, I detail the categories of bad acts, but it's not a specific crimes against the considerable time and detail. In essence, what happened in this trial is a considerable amount of trial, probably the majority of the trial, was spent talking about other acts that occurred. This is what the prosecutor was trying to introduce through 768.27A. It included tickling, lifting of a crop top, but not exposing the breasts, and there was no touching, barging in on the girls' bedrooms without announcing himself, a one-time shoving donuts into two of the girls' mouths, a one-time brushing of sand off at a girl at a beach, one incident where two of the girls had towels on them when they were talking to him, the defendant one time looking at adult women on his phone in bathing suits. They were not nude and they were of age, and putting his nose up close to one girl and saying a comment to the effect, "You smell like fish." And the details of all these I do provide in the brief and the page numbers to it. It's the appellant's position that none of this testimony was admissible under 768.27A. None of it is. It's simply not listed specific offenses. The analysis should have been under a 404B notice. 404B notice is a mandatory notice that has to be provided by the government to the defense, and it was not done prior to trial, nor at any time during the trial did the government attempt to offer it under that guise. Even if the court were to consider its admissibility under 404, it should not have been admitted. The people made no attempt to articulate a proper purpose for it. The people chose to only offer it under 768-27A. The purpose, the proposed result was to paint him as a bad person. There's no analysis that was done of the propensity to commit a crime. The trial court responded to the defendant's objection by commenting to the evidence applied to the sexual gratification element of the charged crime. That's on trial transcript 3, page 43. But that makes the assumption that the evidence is even admissible, since the actual purpose of the defendant under specific acts under Fisher is not really relevant. It is the reasonable man test. It's not even proper for that purpose. The error is not harmless. This is almost exclusively a credibility trial. There was virtually no, when I say virtually, there was one incident, one girl at the beach saw the other girl having the sand brushed off her. So that perhaps is an
Why
argument.
couldn't that specific act be a CSC4?
It arguably could have been.
Well, and she said that, I believe that her bikini top came untied right after he did that. So the girl had to retie her top.
She was on her stomach.
Yes,
When he's brushing off her back.
yes,
She felt at that time that the top became untied.
yes.
There was never an argument that it was, she was exposed or touching him properly. But to Judge Redford's point, there was touching of other areas that could have been construed as CSC4. I'm only arguing that because under Gursky, when we have a case that is basically a credibility case, that's the only area where there's any corroboration of anything of a sexual nature that could have been a listed offense talked about, the court is clear. If it's a credibility contest, then the error, the harm is much greater. If it's not primarily a credibility contest, then the error perhaps is not as, is perhaps more harmless. But it's our position that the majority of the trial spent talking about this other act's evidence that did not constitute a listed offense, and a considerable amount of time was spent on that. And then I'd like to add into that, at the end of the trial, the prosecution produced the government's expert witness, Barb Wilkie, who had never interviewed the witnesses, who had never read any police reports, and she was there to talk about grooming. And then extensively, and in my brief, I won't go into it in detail, but there's several citations in the prosecutor's closing argument where she was talking about grooming, and that proved his intent. And again, that's just compounding the error because we have a lot of conduct that is not specifically covered by 768-27A that is being talked about now as if it's a crime. It creates a very circular argument where the prosecutor gets into evidence that shouldn't have been admitted. When that evidence is admitted, then she's building her argument that proves his sexual intent, when that's not even a proper purpose of it. So for all those reasons, I think it was an error of law to admit that evidence, to not go through analysis. As Smith tells us, the analysis starts and ends at 767-27A if they're listed offenses. And there's no notice under, and this is the issue, the argument we're raising before trial. That's the objection why this cannot come in. Sorry, I'm getting off the dry mouth and didn't check my calendar. This goes to my third argument, which is one of the government's strongest witnesses, Ashley, and I'm only going to use her first name. She testified during the first trial, and she talks about the emotional harm this caused her. Well, she's a victim of criminal sexual conduct. I'm not saying it isn't going to harm her, but she made some very specific statements about how damaging it was to her self-image. She changes her clothes, wears totally different clothes because she doesn't want to be revealing. If in fact she was a victim, then that's understandable. Then the family draws to my attention, as I tried the case, that they're looking on social media that night, and there are numerous pictures, 12 of them, if I recall the number correctly, where she's wearing very revealing clothing, almost risque clothing. And I'm asking the next day at the start of the trial, I should be allowed to admit that evidence because it impeaches the statement she made. And the court said, no, we're not going to allow that to be admitted either. And that brings me to my fourth argument. And my fourth argument is, and I'm normally not somebody that argues, and I understand this is a no credibility, no corroborative evidence is necessary. But we have a situation where all these errors are compounding on each other, and does it result in him getting a fair trial? It's a cumulative error. We put all these pieces together. Normally, it doesn't make a good argument in criminal sexual conduct case, but I think under the unique facts of this case, where there's much more time spent on evidence that should have never even been admitted, or at least not the basis it came in under, it undermines the very validity of the conviction itself. Are there any questions I can answer for the court?
Any questions?
No additional
Always so
questions.
concerned the court has so little questions. So I hope I answered the court's questions.
No.
Very
We would-
thoroughly briefed.
We would ask, believe me, Mr.
Thank you very much for the court's time.
Thanks, Mr. Staley.
Thank you very much. The matter has now been submitted. We will call item number 5, docket for number 367595. Polodziecki v. Place to Be Inc. Please correct me if I mispronounce the name. Polodziecki. Sorry.
May I proceed?
See it.
Morning.
Morning.
Morning, Your Honors. Benjamin Mills on behalf of the plaintiff, Peter Tolojeski. This incident happened about 7 years ago, almost 7 years ago. And I think the court is familiar with the facts, so I'm not going to go through those. But the issues that I want to talk about today are in two main areas. One is whether Peter Tolojeski qualifies and should have been paid workers' compensation benefits from the principal or from the place to be for the injuries that he sustained while he was on the job. And the second one is whether Dwayne Vander Ark acted as a general contractor or as an owner retained control enough to subject to him to the common work area doctrine to be liable for all of Peter Tolojeski's injuries. And he did sustain serious injury. He's currently disabled from work because of the injuries that he sustained in this incident. So Dwayne, this involves a 14,000 square foot home in Newaygo County. Dwayne Vander Ark built this house for himself and he acted as the general contractor without any workers' compensation anywhere in the chain. I want to start by talking about the workers' compensation issue. And we can start with some statements that no one disputes. First, Mid-Michigan contractor, which is the level below. So you have Dwayne Vander Ark, Mid-Michigan contractor, which is Nick Mattson, and then Nick had several employees that exclusively worked on this ranch. So Mid-Michigan contractor carried no workers' compensation insurance. The second undisputed fact is that the place to be hired Mid-Michigan contractor for the ranch and for help with the construction of this house. The workers for Mid-Michigan were sort of loaned out for the construction project, but they were there doing landscaping, working on the docks, installing engines on boats, that sort of thing. The third undisputed fact is that Peter was injured while executing that work. So defendants and Eppley's entire theory below and here is that Peter was Mid-Michigan's employee and not theirs. Even if we accept that for the sake of argument, Section 171 of the Workers' Disability Compensation Act does the rest. When a principal contracts with a contractor who has not complied with the insurance requirements of the act, the principal shall, quote, shall be liable to pay to any person employed in the execution of the work any compensation under this act for which he or she would have been liable to pay if that person had been immediately employed by the principal. So on defendant's own version of the facts, this is the case. That's why the legislature calls this a shoot through or statutory employer provision. It's a safety net exactly for a worker like Mr. Tolojeski. The trial court below disposed of section 171 in a single sentence. It said the provision applies when a contractor hires another contractor. Respectfully, that's not what the statute says. It says any employer who is subject to the provisions of the act. If any employer hires a contractor and that contractor is not insured, then it shoots through back to the principal. So defendant's only argument against that is to say that the place to be had no employees at all, so it was never an employer subject to the act. So section 171 never triggers to get the liability for workers' compensation benefits back to the place to be. First, I have three responses for that. First, section 115B covers any employee or any private employer who regularly employs even one person, 35 hours or more a week for 13 weeks out of a year. Peter's tenure was in excess of that. He was there for 22 weeks and he worked 50 hours a week. And under the economic reality framework, there's at least a minimum of a question of fact as to whether the employment relationship ran back to the place to be. Vander Ark, its sole member, gave the marching orders, and that was his own words. He set the standards for the work, supplied the equipment, disciplined the crew, made Peter Tolojeski's termination decision. Mid-Michigan Contractors was merely a conduit. They took no profit from the work. Nick Matson just submitted the hours that he worked and that his crew worked, and then he was reimbursed exactly for those hours. He did not make any kind of a profit. So this Mid-Michigan Contractors LLC was merely a pass-through conduit for the employees that the place to be had or Duke Vander Ark had. Second, section 151 of the Workers' Compensation Act defines an employer as anyone who has any person in their service under any contract of hire, express or implied. The place to be, which is the owner of and operator of this ranch, had an entire crew doing its year-round service, groundkeeping, maintenance, construction. In Matson's words, doing whatever Duke asked. The act does not let a business define its whole workforce out of existence by just routing checks through a pass-through LLC that's uninsured. And third, the decision of this court in Veely versus DCMA International, 211 Mishat 458, is instructive. And in that case, the direct employer did not have insurance. And this court held that then liability shifts to the principal. Well, who was the principal in that case? The principal in that case was a California corporation with 0 Michigan employees. So they weren't subject to the Michigan Workers' Disability Compensation Act. They were an out-of-state employer that had one employee that was working in Michigan, actually directed one person to work for DCMA International in Michigan. So they were the principal, but they weren't a Michigan company. They weren't ostensibly otherwise would not be subject to the act. But the court said in Veely, this court said that the contract of hire requirement of 151 is implied by law. So there was a contract of hire with DCMA and DCMA failed to secure compensation. So then liability shifted to the principal, Southwest Marine, which again was a California company with no Michigan employees. But the court held that the plaintiff thus had a quote unquote contract of hire with Southwest Marine. So Southwest Marine had to pay in that situation the workers' compensation benefits because it was the principal and it contracted with a contractor that did not have insurance. So the claim that this court doesn't need to weigh a single piece of evidence, and neither does the trial court. Either Peter was the place to be's direct employee, and because the place to be carried no workers' compensation insurance, then section 641 sub 2 authorizes this civil action, or he was Mid-Michigan's employee, and Section 171 makes defendants his statutory employer because Mid-Michigan did not carry proper insurance. So there's two options, but they both lead back to the same place, that the place to be is liable for paying benefits that otherwise would have been payable under the Workers' Compensation Act. Part two is the common work area claim. And the court below found twice a genuine issue of material fact that Vander Ark was the general contractor for this project or an owner who retained control. And that finding was compelled by the record. Vander Ark admitted that he selected the subcontractors, he scheduled and sequenced them, paid them directly, could withhold payment if he wasn't satisfied with the work, ordered the building materials himself, supplied the heavy equipment that was used on the site, sat on top of the chain of command, told suppliers that he was the contractor, and coordinated everything through his foreman, Nick Mattson. The other thing I think that's very instructive here is that he directed the crew that worked on his ranch to help the builders. So that's exactly what a contractor does. They find people that do the work, and they have them do it. They engage them to do it. So Mr. Vander Ark was acting certainly as a general contractor. And that comes with it then some responsibilities. The trial court said, well, he's not responsible because he didn't retain enough control. That is not a standard anywhere in the common work area doctrine. It's an either or proposition. If you're the general contractor, you have a responsibility to oversee the job site, and you're liable for the negligence of the subcontractor if all the elements of the common work area exist.
Whose employee was running the machinery that was moving the fire truss?
Whose employee? It was the framers, John, the framing company, John Built Builders was doing that. So it was attached to the crane. That was the crane guy, and then John Built Builders were setting the trusses. Nick Mattson was on top of the trusses, though, installing some 2x4s on the top. And these trusses all fell because they weren't properly braced. So he wasn't installing enough, but he was on the top of the roof. And then Peter Tolojeski was on the second floor handing stuff up to the workers that were on the roof.
Thank you.
So supervisory and coordinating authority is inherent in the role of a general contractor. The degree of control that that appellee focuses on matters to whether an owner stepped into the shoes of a general contractor, but we don't even need to get there because Duke Vander Ark was acting as the general contractor. You wouldn't have a contract with yourself, so there's no document of it, but he was doing all the things that we outlined in the brief extensively. On the readily observable danger element, the court held that the danger was observable only to someone who was standing right there, and Vander Ark was not there when the trusses fell. The case of Latham, which was discussed in our brief, forecloses that analysis. Where normal safety precautions can reduce a hazard, the general contractor's duty is to take reasonable steps to ensure that those precautions are taken. And what must be readily observable is the failure of the workers to take those precautions. Here, that failure was on display for the entire project. There was not one safety meeting, no safety coordinator, no training. Nick Mattson wasn't even a licensed builder, no hard hat requirements, no fall protection requirements. And bracing that was so visibly thin that the crane operator, who is also not a licensed builder or a framer, hollered up that you should probably get some more bracing on that. So it was a readily observable failure. And then the cutting of the bracing to remove the truss it would have been even more readily observable because whatever minimal bracing was there was cut, leaving them all unsupported while one truss from the middle was taken up. So that goes directly back to the general contractor, Duke Vander Ark, or his agent, Nick Mattson, who was already on the scene. On the number of workers that have to be present there, defendant concedes. Appellee concedes that 6 workers from 3 different contractors were exposed to danger when the trusses fell. 10 of those workers were engaged all together within the installation. So there are a number of cases that say 6 is enough, 7 is enough if they're from different contractors. The Alderman case has a 1-paragraph order that involves 2 to.
Alderman said 2 to 6 wasn't enough.
Yes, but they were all from the same subcontractor. And that's an important distinction because that takes this out of being a common work area that exposes a number of different workers from a number of different trades to the same danger. This was one subcontractor, and typically the subcontractors are responsible for the safety of their own employees. But once the job description expands to now there's multiple subcontractors involved, and it may be confusing as to who's responsible for overall safety, it shifts up the chain of command, as it should, back to the general contractor. So we have employees of at least 3 different contractors, at least 6 that were directly exposed to the danger, either by being on top of the walls, being on top of the trusses, or being on the second floor. But there were 10 employees that were around, including the train operator and other individuals outside the house. So at a minimum, it's a question of fact for the jury. Bring forward on the cross appeal, appellees now say that Vander Ark cannot face liability under the retained control doctrine, and that's where an owner keeps enough control so that he could be considered a general contractor. Again, we're not arguing that here. We're arguing that Duke Vander Ark was the general contractor, but that they said that that theory fails because the place to be holds the title for the ranch, and that the complaint pleaded no direct claims against the place to be. But that wasn't an argument that was the basis for the decision below. Peter's claim, Mr. Tolojeski's claim against Vander Ark is that he acted as the general contractor, a role that has never required ownership of land. In the place to be, a named defendant that answered in this case, took discovery in this case, moved for summary disposition on the merits of those very claims, acted at all times through Vander Ark, its owner. If there were a pleading defect, and there is not, the remedy would be amendment under the court rules, amendment that relates back to the beginning, not affirmation of summary disposition. So the trial court, in its opinion, identified genuine issues of material fact and then resolved them itself, weighing testimony, choosing between competing accounts, applying standards that controlling law reject. This is why we asked the court to vacate the grant of summary disposition as to the place to be and Vander Ark on the common work area claim, and then decide in plaintiff appellant's favor on the workers' compensation count and remand for trial. Unless the court has any further questions, I will reserve the remainder of my time.
I do not.
No.
Thank you. You saved considerable time. Another council's ready.
May it please the court, Michael Cook on behalf of the defendants, appellees, cross appellants, the place to be Inc. and Dwayne Vander Ark. I thought I would start with the trial court's reason for granting summary disposition on the negligence claim, which is the readily observable danger. I think the important point on that issue is defining the danger. And Lathan, I think, speaks to that point. The danger was improperly braced trussing. These 40-foot trusses that have very complex instructions on how to brace 3 different planes on it. It's hard for me to comprehend. I hope you don't have very specific questions about that, but it goes to the point that it's not a readily observable danger. It's somebody with specific experience and knowledge of the area has to be there physically on it. Even the people who were doing it at the time and were literally on it
But the
didn't
guy in the
recognize the
truck,
danger.
but the crane operator said, "Hey, you up there, you got to brace that better."
Right. And the entirety of the crane operator's testimony was he wasn't sure. He said, you might need more bracing, but I wasn't sure because I couldn't see the interior
But
where
you
they
know
were
what?
placing it.
And this is
And your guy took on the whole process. I mean, he could have had a general contractor there, but he chose to enter into the contracts himself. He chose to run the operation. It's his 800 acres. It's his house. Everybody doing a project wants to save money. I can swear out an affidavit to that right now. We have contractors at my wife's and my house of 25 years, and I am astounded. I am so happy to have the guys and gals helping us, but I am astounded at the costs. I fault no one for trying to save money. But when you do, there are certain consequences if you choose to keep you being the quarterback of the whole operation.
I do want to address that point. I think it's
That'd be good,
it's
'cause
separate from the
you might-
readily observable danger point. The trial court's ruling was on the readily observable danger. And I do think it's important that given the complexity of the issue, that's not the type of readily observable. It's not like somebody not wearing fall protection when they're up on a hike.
Which they weren't doing.
Right.
It's not like they weren't having safety meetings, which they weren't doing.
So-
I mean, you have there in the Navy, we had there are things called the rules of the road. So the burdened vessel is the one that's powered by machinery. The unburdened vessel is the sailboat, the canoe, or the kayak. The sailboat, the canoe, or the kayak still gets out of the way of the aircraft carrier because it's called the rule of gross tonnage. You add everything together, you're getting out of the way. Your client is in control of the entire operation and chooses not to. He knows people aren't wearing safety helmets. He knows they're not having meetings. He knows that he's doing the competition to get the thing done. And how is he not responsible under this?
There's a lot to unpack there. And I'm going to try to get to all of it. Okay. So the readily observable danger, when you're defining it, it's not entire project wide. That's what Latham said. When we define the danger we're talking about, it was, how is the plaintiff injured? In that case, it expressed it in terms of this injury doesn't happen, but for him not having fall protection. Here, this injury doesn't happen, but for the truss bracing being done incorrectly. It wasn't the
If
lack
it
of
weren't
a.
for original sin, we wouldn't have churches. I mean, where do you start it from?
Well,
You know?
and that's what I'm saying. You don't start from, was there a safety meeting? Because you can't really tether that to this wouldn't have happened if there was a safety meeting. What you can tether it to was the improper bracing. And that's what the cases, I think, Funk, Latham, and the other cases from this court, it's the immediate injury causing thing, which was these 40-foot trusses falling.
But it
So
wasn't just,
that's how I think you need to define it.
but I don't think it was just the bracing, because if you're going to get into that technical point, the point is that the decision was made by the people who were there who didn't, I don't know if Duke was the one who said it, but they decided we forgot to put in the fire suppressant truss. So we've gone, I don't know, I'll just say we've gone 25 trusses. So we're going to go back to number 20. And it's like playing Jenga. We're going to take 20 out and put the fire suppressant one in because we need to have 50 trusses. And it was at that, no safety meeting. No, is it a good time to cut the braces to put this one in that we forgot to put in rather than taking out the 5, putting it in, proceeding again. And that's the whole point, right? Because the general's got to be responsible for what's going on here. And Duke was the one who was calling all the shots. So it wasn't just the bracing that was the problem. It was the decision that was made also by the people who were there to, oh, we'll just cut the bracing for number 20 and we'll lift it out and put a new one in, right? Because that was the problem that caused the collapse.
And I hear you. I understand, obviously, you've conveyed a strong feeling on this. I will say that assumes a lot of information and knowledge about what's readily observable as dangerous.
How did you win? What was the court rule that you prevailed under, counsel?
C10.
Oh, okay.
I understand.
You have just acknowledged in your oral commentary to the court, there is some evidence there. We must take the evidence in the light most favorable to the non-moving party. How on earth is there not evidence to justify this case moving forward?
In terms of just readily observable, and I do want to address the general contractor aspects of it as well. But in terms of the readily observable, the knowledge that cutting a couple of braces when you have others connected on this end, you have others connected on that end, does that make a observable danger at that point? I don't know that, other than knowing the specifications and unique bracing techniques for these 40-foot trusses. That makes it not a readily obvious danger, like in the cases that we've cited and discussed before, not having fall protection on. I appreciate you listening to my
I
argument on the
understand your
readily
position.
observable. I'll move on to the general contractor aspect of it. And I think it's sort of twofold. All the cases that I think we've seen to this point, there hasn't been any real dispute on who the general contractor was. It's usually there's a contract that just says this entity is the general contractor for this case. I think what's important for this case is there doesn't have to be a general contractor for any construction project. The general rule, the baseline rule that is the common work area doctrine is an exception to, is that you do not have liability for the negligence of an independent contractor that you hire. So if you have a project where you're hiring many different independent contractors, that doesn't make you liable for what they do. The general rule still applies. So you need to show that somebody is a general contractor. There isn't case law from this court really defining what that is. A lot of the cases, there are contracts. There's no contract here. A lot of the cases, there's somebody with a builder's license experience as a general contractor. All the testimony is consistent that Mr. Vander Ark did not have a builder's license, did not have that sort of experience.
But he was the
So-
one calling the shots all along. I mean, even Mattson said he was the guy. We just did Mid-Michigan just so he could pay through Mid-Michigan to all these people who worked on his farm, property, whatever you want to call it, for a long time.
Couple things there too. On the general contractor aspect, the Mid-Michigan aspect, I do want you to pay attention to the testimony about when Mid-Michigan was formed and why, because it does get, I think, confused in the plaintiff's brief on the timing of when certain discussions were had. Mid-Michigan was formed by Mattson. That was his company. He chose to run it basically not as a profit off of his other employees. He paid them exactly what he got
Isn't
paid.
there evidence of record, counsel, that your
No.
client instructed
No.
him to do this?
And that's exactly what I want to get to. The commentary on that aspect of them having discussions about how Mattson was running his operation was after this accident. If you go and look at the
So what?
so
So if the guy
Well-
says you're to do it this way,
no,
it
that's
doesn't,
not.
isn't that indicia, counsel, of he is the one who is absolutely making the calls, making the determination?
No, that's not.
Oh,
That's,
okay. I
that's
don't-
not, because before he had no idea that this is, and that's why I'd ask you to go look closely at that testimony. The testimony is consistent that Mattson ran his company the way he ran it. He set what these guys were going to be paid, right? Vander Ark had no idea what he was paying those guys. He had no idea how he was running his company until after the accident. They said, well, Nick, you got to be running a business here. Like, what are you doing? Kind of as a friend telling him how to do. I really would like you to go back and look at that testimony, because before this accident, it was Mattson running his operation the way he wanted to run it. That's not Mr. Vander Ark's fault, right? He hired Nick Mattson and his company to do the work on the property.
But didn't the guys do the work before Mattson created Mid-Michigan?
No.
So you're
they
saying
didn't.
it was a timing thing. So Mattson worked
No.
for Duke, and then Mattson formed Mid-Michigan, and then Mattson hired all the guys to work for
Yeah,
Duke.
throughout the entirety of this, Nick Mattson paid them through Mid-Michigan. He operated
But at
Mid-Michigan.
no profit to himself. It was just, here's how many hours that me and these other 8 guys have worked.
Yeah, and
At
if,
so many dollars per hour, please Duke, pay us this amount of money. And Duke then put that money in Mid-Michigan, right? Mid-Michigan's account, and then he paid everybody out.
yes, that's the testimony. Nick
A
would
funnel, a
get paid his
vessel.
$35 an hour. If he was paying somebody 22,
Yep.
that's what he billed Mr. Vander Ark. Vander Ark paid Mid-Michigan. Mid-Michigan dispersed the funds.
But it was
That is a independent contractor hiring the independent contractor relationship.
But it was just a vessel. I mean, it wasn't that they didn't have office, he didn't make a profit like you're
That-
saying.
that
Duke
was
told him
not-
After the fact. I understand that, but when you look at what a business is typically running, he's not out advertising to get other people to do Mid-Michigan business, to hire Mid-Michigan for business, right? Because Duke is the one who's employing them the full time. There's no overhead. I got to pay for lights. I have to pay for stationery. I have to pay for postage. I have to, pay for electric or whatever for Mid-Michigan. Mid-Michigan is literally just a vessel to go money in, money out.
It
right.
was Nick Mattson's company, and he charged what he wanted to get paid hourly.
But again,
and he
am I
did
correct
do-
though,
he
counsel?
did
Am
do
I
work-
correct that
Sorry.
there was he didn't charge a Van Dyke for,
Vander Ark.
Van Dyke, thank you, for like lighting or a business building or postage or overhead or anything else, correct?
To the extent he did, it was in his $35 an hour that he was charged.
But no, then he'd be undercutting himself. His $35 an hour was because he was skilled at what he was doing. So I'll take that as there was no real business
An important-
building and things like that.
An
for him.
important point on Mid-Michigan being its own separate entity was that in the testimonies, it didn't operate exclusively at the ranch at issue here. He said it's 75% there and he did work elsewhere. So when you're looking at the Workers' Compensation Act provisions in terms of what's an employee, what's an employer, Mid-Michigan was not an employee because it did work elsewhere. It was an independent contractor. And that's important because then the place to be has no employees. Mid-Michigan employs its employees. It is an employee under the act. Absolutely. There's no dispute on that. But it was an independent contractor hired by the place to be. And that's why the statutory employer provision does not apply, because it has to be an employer subject to the provisions of the act. And the place to be didn't have any employees. I do want to circle back to the general contractor point. I understand that this is an uphill climb for me at this point, but I do want to make the point that there's no requirement in Michigan to have a general contractor. There's no contract for a general contractor. There is no
requirement. But if someone chooses to be a general contractor, then what happens?
Which is when we get into the retained control aspect of it, right? And the standard for retained control is exercising actual authority over the substantive manner in which the work was performed. And there's no testimony in this record that Mr. Van Der Ark did that. We
really must be looking at a different record. I find it borderline incredulous to make that argument.
So I want to give you a couple points in the record. If you want to go look at them, I'd appreciate it.
We've already reviewed the record,
Sure.
but go ahead.
Mr. Tolajewski's, I butchered that name. Tolajewski's testimony, pages 93 to 95. They go through with him. Did Mr. Van Der Ark tell you how to do this? Did he tell you to do that? The one example he gives is when they're building a boathouse. And he says, Mr. Van Der Ark came and stepped on it, had a little give. And he says, you guys need to tear this out and redo it because there's give. He said, well, I took him aside and showed him that's because the sun's on it. So when you go where it's not sunny, then there's no give. That's just how these things work. And he accepted that. It continues on. Did he tell anyone else how to do these things? He says, no. That's from the plaintiff's own deposition. From Mick Madsen's deposition, pages 20 to 21, 97, 98, the exact sort of same testimony. He didn't control how this work was done. And that is the standard for retained control. I would also submit, if you're defining what is a general contractor, the retained control doctrine says is someone who steps into the shoes of general contractor. So I think you can use that same standard for deciding, is this person a general contractor? Do they substantively control how the work is done? And there's no testimony that he substantively controlled how they did the work. The things that they're pointing to, he took measurements of his yard and sent it to the irrigation company before they came out and did a site visit and decided how they were going to do it. Nick Madsen told him that I want 3/4 inch gap on the windows instead of a half, and he relayed that information. There's no instance where he told somebody, here's how you do the work. Everything's consistent with a property owner saying, this is what I want. I want a 14,000 square foot house. I want these things in it. He's not telling them how to get there. So he didn't retain control. He's not a general contractor.
So you're saying, so if he wanted the bathroom built to have retained control, he would have said, okay, the counter's got to be 62 inches long and 32 inches deep, and it has to be a sink in the middle, not on either side. I want a raised up a cabinet underneath. I want a mirror that heats up so it doesn't fog up. Is that the sort of thing you're talking about?
No,
As opposed
honestly,
to, I need a bathroom with a sink in it, one sink, and a mirror that doesn't, whatever.
honestly, is anyone who's ever had, remodeling done work at their home, that's sort of regular owner input. I want one sink, I want two. I think it's how you go about building the cabinet that's going to go there. How you go about putting down the tile. What sort of, are you going to cut quarter tile for this side?
No,
and
but
work
that's
across?
what the specific guy who the general hires to do, right? Because I'm going to hire the tile guy to do the tile. I redid my kitchen because we just sold my house. So we had the kitchen cabinet people, and then we got a list of people to come and do the tile work as a backsplash. So the tile work people came in, and then we had to have somebody else to come and do the floor thing. But you don't have one person saying, this is how you're going to do the tile and the grout and everything else.
I do think
Because-
from a general contractor perspective, they are telling, okay, one contractor is going to be doing this, so you guys need to do this way, right? I'm not going to, I don't have a really specific great example for you, but I do think from the case law, it is saying there needs to be more control over the specific way in which the work is done. Not just saying, I want one sink, I want the counter to be this height. I think that's normal work, owner input. It needs to be more specific control of how the work is done. And I don't think that's in this record.
But I think a general also has to plan how the work is performed, rolling it out. So they're the ones who schedule, okay, first we got to do this, putting up the studs. Then we have to do this. Then we have to do the plumbing. Then we have to do the electrical. Then we have to get a check. And that's what the general is doing. And the evidence, the testimony seemed to be clear that that's exactly what Mr. Van Ark was doing.
I don't deny that he's involved in scheduling and hiring the subcontractors. And I don't deny that that's part of what a general contractor does. But I do think the standard from the case law, which I've provided the court, I'm sure you've read it and you're familiar with it, requires more in terms of substantive control of the work. And that's not here. If you have any additional questions, I'm happy to answer them. I think I understand your positions and you understand mine.
Any additional questions? Thank you.
Thank you.
Thank you. I don't have anything else.
No questions. Thank you.
Thank you.
With that, we will move, and this is long, 10 o'clock session. We'll move to item number 6, docket number 373621, Estate of Cree Irwin Shepherd v. Southwestern Michigan Emergency Services. And I know there are several different endorsed parties for the appellee, so I'll leave it to your discretion for how you want to divide up the time.
We need to pull more chairs up. We can pull more chairs up. We need them.
Good afternoon. Beth Whitman, appearing on behalf of the plaintiff. In this case, the trial court erred in granting summary disposition on the basis that the plaintiff couldn't establish a genuine issue of material fact as to causation. So in a medical malpractice case, obviously you have to establish a breach of the standard of care and causation through expert testimony. And those experts also have to match the specialty of the defendant that is alleged to be negligent. So here we have 3 different sets of defendants in this case. We have the OB that performed the original procedure. Then we also have an ER doctor in his professional corporation, as well as the radiologist and his professional corporation who are involved in the care and treatment at that hospital a couple days later after she had had the procedure. So as to Dr. Castleman, who is the doctor that performed the procedure on June 30th, the plaintiff provided the expert testimony of Dr. Soffer, who is an OBGYN. And Dr. Soffer said that it was a breach of the standard of care for Dr. Castleman not to identify that there was a perforation of the uterus at that point. And then also that after diagnosing or recognizing that perforation in sending the patient then to the hospital for treatment. And Dr. Soffer said that had the standard of care been complied with, that the plaintiff would have been at the hospital and would have been observed, would have been provided additional testing, would have then undergone surgical repair of the perforation and provided additional treatment such as blood thinners that would have then avoided the death that occurred here because of a pulmonary embolism.
And that's the problem with this case. This is a horribly, horribly sad.
Yes,
situation.
absolutely.
I mean, my heart just goes out to everyone involved. But the evidence showed that even despite the postmortem report, that there were embolisms, there was blood clots
Yes,
in the lower extremities
sure.
And so nobody can say that the blood clot that eventually ended up taking this woman's life was from the perforated uterus or from the lower extremities. And that's kind of where everything begins and ends.
Okay, and I can absolutely address that issue. What we have here is we have the testimony of Dr. Spitz. And Dr. Spitz testified that the blood clot, yes, that the pulmonary embolism probably came from either or both the lower extremities or from the uterine. The uterine thromboli, I think it is.
Yes.
I'm sorry. The medical stuff is hard. But most importantly is he testified that both were caused by the perforation.
See, I didn't see that. Where is that located?
He said that is his testimony at pages 34 to 36, 54, 63 to 64, 88 to 90, and 113 to 114.
I'm sorry, 34 to 36,
Yep.
64 to what?
63 to 64. I also have page 54 as well,
Oh, actually through there.
Yep.
Okay.
88 to 90, and 113 to 114.
This is in his,
That is in his deposition
yeah.
testimony. That's correct. So
there's
both,
much made in the briefs of opposing counsel that this witness, Dr. Spitz,
Mhm.
seeks to reform his deposition testimony through post deposition affidavits.
right, right.
What
right.
is do you need the post deposition affidavits for there to be
A genuine
question of
issue of
fact?
fact. I do not, because
Why?
his deposition testimony establishes that regardless of the origin of that PE, that clot was created or it existed because of the fact that there was the uterine perforation. So because of that,
Is he qualified to make that opinion?
Yes.
Or, because
and
you
that
have,
wasn't even an issue.
you have Dr. Sofer, Dr. Patter, Dr. Gallen, and Dr. Spitz are your
Right,
experts.
Right. And there was the trial court's decision wasn't based upon the fact that he wasn't qualified to offer an opinion on that. That wasn't it. He just said that there was insufficient testimony and the trial court was frankly wrong. I think the trial court got a little bit lost in the theory and in the testimony of the experts, but the expert testimony is absolutely there. The other thing too, Dr. Spitz also, the trial court said that, Dr. Spitz said that it was, these blood clots couldn't be seen on transvaginal ultrasound, the lower extremity clots. So that's why he thought that this was important, that this could have been a lower extremity clot. Well, it doesn't matter. The entire point is that you fix the perforation, you fix the thrombolus or the thrombi, and in fixing that, you then prevent the PE from ever happening, because then the clot doesn't get thrown into the lungs. So it's not the theory that you would have seen this lower extremity clot on a transvaginal ultrasound. Nobody says that. Nobody, that's not our theory at all. What it is though, is that you would have found this perforation. You more likely than not would have seen the uterine thrombus. And had you done that, you would have gone in, you would have fixed the perforation, you ligate the thrombus that you do see, and then that prevents the PE.
But I thought that at least one of the experts, and I can't remember who it was, testified that it would be so unusual for them to do an intrauterine ultrasound and to find the thrombosis. I can't
No.
remember which doctor it was.
I think that there's very clear testimony from Dr. Sofer, Dr. Gallen, also from Dr. Patton too, that more likely than not, had you done the transvaginal ultrasound, which is an internal ultrasound that's done so that you can get a clearer view. Everybody says that it's a clearer view. And more likely than not, had you done that, you would have seen this uterine thrombus. It may be unusual, but it is definitely something that they all say follows from the perforation. It's a result of that. So you may not have been going in there looking for it, but you more likely than not would have found it had you done this proper test that needed to be done. So then that takes us to the Lockridge case, which I think is very, very much on par with this case, because in that case, it was a 14-year-old boy who came in. He had, I think, a fainting episode or something was going on. They diagnosed him with anxiety, hyperventilation. They discharged him and he ended up dying in his sleep that night of a cardiac.
Aortic dissection.
Yes, an aortic dissection, which was incredibly rare in a 14-year-old child. Everybody agreed with that. But the standard of care required the doctors, this is what the plaintiff's expert said, required the doctors to perform a chest x-ray. Not because they were looking for an aortic dissection, but because the most likely thing that they should have been looking for was a pneumothorax. There wasn't a pneumothorax, but had you complied with the standard of care in doing that CT scan, you would have in fact found this aortic dissection. Even if it was incidentally, this court said that that was sufficient to establish proximate causation. So that's exactly what we have here. It may have been incidental that you're going to find this thrombosis that's going on in the uterus, but you absolutely we're going to find it if you would perform the test that you were required to perform by the standard of care. So that's, with respect to Dr. Castleman, I think it's a little bit different, I think, with respect to Dr. Castleman and the other defendants, only because of the timing of it. Obviously it was 2 days earlier. Dr. Castleman should have sent her immediately to the hospital. It's no different, really, ultimately, the causation analysis when you have.
Why should Dr. Castleman have known?
So what Dr. Soffer said is that there's 2 reasons why she should have known. Number one, because she should have felt it when she was using these instruments. And additionally, she was performing this procedure under ultrasound guidance. So because of that, she should have seen it on the ultrasound as well. And he said there is absolutely no way that she could have missed this. This is a 4-centimeter perforation. Dr. Soffer testified this took up a third of her uterine wall. So this is a
At
huge
stage of the gestation, the uterus was 12 centimeters.
Yes, that's correct. Exactly. So this was a third of her uterine wall that was perforated. So according to him, this was a huge hole in her uterus. And it's important too, because he said the instruments that are used are very, very small. So it would have been, he said, I think nearly impossible for her not to recognize this perforation at that time. So again, we have to look at the testimony of the experts in the light most favorable to the plaintiff. This is what the testimony is. This is what these experts have said. They have created a link between, her coming in and having these complaints, or Dr. Castleman obviously recognizing the perforation, that she was required to recognize the perforation. And then the doctors 2 days later were required to then also look for, do a test in order to find this perforation. Had you done that, she would have gone to an OBGYN. There would have been a consult with an OBGYN, and Dr. Soffer was very clear that an OBGYN would have taken her in, performed surgery to fix the perforation, ligated that thrombus, put her on blood thinners, which is important again, because we're talking about a blood clot that's going to be thrown from this thrombus that's going to be thrown into the lung, and that's going to
So the
prevent that.
testimony is of these physicians, after a surgery, they're going to still put her on, they would put a patient presenting with the same conditions
Yes.
on blood thinner.
Yes, absolutely. Because of this risk, if she's got a blood clot and they find it, they're not going to risk having it thrown into her lung and causing death, which is precisely what happened here. So again, with the, looking at the evidence in the light most favorable to the plaintiff, all of this deposition testimony leads to this cause and effect between the breaches of the standard of care and the patient's death. I did very briefly, because you mentioned it, Judge Redford, with respect to that affidavit. Obviously, the affidavit wasn't it wasn't available at the time of the initial motion for summary disposition. It wasn't used with respect
There
to
were
Dr.
multiple
Cento.
post-deposition affidavits by your experts, right?
I think Dr.
Dr. Spitz
Spitz
was one.
was one of them.
And I'm assuming that's Dr. Werner Spitz's son.
I assume so. I don't know the answer to that.
I don't think Dr.
assume
Werner
so.
Spitz is
I
still
can't
alive.
imagine, but I don't know. But then, so it was only used with respect to Planned Parenthood and Bronson and the emergency services defendants. It wasn't used with the advanced radiology defendants. And that was really the trial court's initial decision with respect to the sufficiency of the evidence. So the only time also, I think it's important to note, the only time the trial court said that he wasn't going to look at the affidavit was with respect to the Planned Parenthood defendants motion. He didn't make that same ruling with respect to Bronson or the.
So we know it was Spitz and who else?
I believe Dr. Soffer had also issued one, but I believe I'm
Thank
correct
you.
on that. And then also, even with the Planned Parenthood motion for summary disposition, the trial court said he wasn't going to look at the affidavit, but then went through an entire analysis about, this is, they said I misconstrued the testimony of Dr. Spitz, and here are all the reasons why I don't think I did. So he really did kind of go through an analysis of the trial court, or I'm sorry, of the testimony. And, I think also the affidavit merely just reiterates all of his deposition testimony. So even without that affidavit, the testimony is there, the deposition is there. It's not any different than what his deposition testimony establishes. So with respect to, I'd be happy to go through the other physicians with respect to Dr. Cento, who's the radiologist. Dr. Patton testified that it was a breach in failing to order that transvaginal ultrasound on July 2nd when she came in, and that if it had been performed, more likely than not, it would have identified the perforation, would have identified that uterine vein thrombosis that followed from the perforation. And once that was diagnosed, he had to report those findings to another physician, including an OBGYN. Dr. Soffer then, and he said, I'm not going to testify as to what the physicians would have done after that, but Dr. Soffer provided that link, that testimony as to if an OBGYN was in fact consulted, what would have happened. And that's the testimony that I discussed previously, that she would have had the perforation fixed, she would have had the thrombosis ligated, and she would have been put on blood thinners, and he testified more likely than not she would not have died. And it's important too, even the defendant, Dr. Wolzine, he admitted that. He agreed with that. He said, more likely than not, if I had if we'd found a perforation, we would have consulted with an OBGYN and had the perforation been diagnosed on July 2nd and an OBGYN consulted, more likely than not, the patient would have survived. So that's one of the defendant doctors that's agreeing with the causation analysis that the plaintiff's experts established. And the other point too, even the medical examiner, her testimony is consistent with this as well, with the plaintiff's expert's testimony. She testified that the death was due to complications of pregnancy, including the pulmonary embolism that was related to the uterine vein thrombosis and the uterine perforation.
But she was also the one who said there was no lower extremity thrombosis. And the one doctor said, it's right there. There it is.
Yeah, your expert said that. Yes, Dr.
Correct.
Spitz is the one that's.
Yeah, Dr. Spitz said that he
Yeah.
didn't see it. It wasn't mentioned in the autopsy.
It wasn't.
Right, but he
But
saw it in.
But he said these are, and I think he said too, it would have, a lot of these PEs are typically from lower extremity.
Exactly. And
thrombosis.
the
Yes.
pages that you're pointing to just kind of talk about, she had to lay down so much that could have contributed to lower extremity thrombosis. But I guess after you have an abortion, they want you to lay down and things like that, but not so much that the uterine perforation caused the lower extremity thrombosis. You're freaking me out when you cite the pages and transcripts that say that the perforation caused the lower extremity thrombosis. And then when we look at it, it just says, well, her laying down so much could have contributed to it.
Okay, two things. I'll double check those sites. when I'll address it during rebuttal, but
Okay.
also oh, shoot, I can't remember what I was just going to say now then too. The laying down, he said too, she's laying down all the time because she's sick. She's sick because of this perforation. She is having nausea, vomiting. She is absolutely sick because she has this perforation. So no, after an abortion procedure, you're not going to be lying down like this, not like this. She is lying down and sick as a dog because she has a 4 centimeter perforation in her uterus. And
If you have some place where he is saying that
okay,
the fact that she had the perforation caused the lower extremity thrombosis. I want
Okay.
that page.
I will do that. Absolutely. The other thing, I think I discussed the incidental finding issue, there is also a finding by the trial court that the plaintiff would have developed a PE regardless. He said that that's what Dr. Spitz said, that she would have developed this PE regardless of whether or not she was treated or not. That is absolutely nowhere in Dr. Spitz's testimony. He didn't testify to that. He didn't say that she was going to die anyway, even if she was treated. In fact, he noted that being sedentary because she was so sick increased her risk to this PE. And Dr. Soffer and Dr. Gallen, they both testified that the diagnosis of this perforation would have prevented the death. That's all there is to it. And that was consistent with his testimony, with Dr. Spitz's testimony, that there were treatment modalities that were available that they could have used had this been diagnosed.
But did they prove that the standard of care required the intrauterine ultrasound?
Yes.
And which one was the one that said there's an obligation under medical practice to do
Dr.
that?
Soffer.
Okay, so Soffer was the one who did that.
Yes.
And that was at the clinic or at the emergency department?
Well, the clinic, I think, I don't know that he was necessarily saying that they needed to if she's sent to the hospital, she would have had additional imaging. But she would have, his point was with respect to Dr. Castleman is that she should have known that she had perforated the uterus at that point. So whether or not you do a transvaginal ultrasound to confirm that may be the case, but we already know based upon what she was doing that there was a uterine perforation at the clinic. So now 2 days later, when she comes to the hospital, it is Dr. Soffer, Dr. Patton, and Dr. Galen who say that you were required to do a transvaginal ultrasound. All three testified. So that's radiology, ER, and then the OBGYN expert said that as well. Let's see. Okay, so I think that's every point that I wanted to make. I will definitely look for that deposition testimony. And I guess one last point too. The judge also said that there is the fact that she was not exhibiting signs and symptoms of a PE at the time that she was at the hospital. Again, that wasn't our theory either. There's no claim that they should have diagnosed a PE at the time that she was at the hospital. But they needed to diagnose the perforation, and they would have diagnosed the thrombus, and they would have prevented the PE that happened later. Okay, I will reserve the rest of my time for rebuttal.
Thank you.
Thank you.
How are we breaking this up?
Your Honor, I'm going to go for about 12 minutes, and that should leave 6 minutes for the other 3 remaining counsel.
That's satisfactory to everybody?
We did talk about it in advance, yeah. May it please the court, Bill Henn on behalf of Dr. Tento and his employer, Advanced Radiology Services. I'm going to get right to the point, obviously, because I know the panel is very familiar with the record. Judge Feeney, the page that you're looking for in the deposition, I don't think exists. I think the furthest that Dr. Spitz, who is their only causation expert, the furthest that he went was to acknowledge at his deposition that the risk factors for a lower extremity deep vein thrombosis would have been the same whether the uterine perforation had been observed and had been surgically repaired, or whether, as was in this case, it wasn't observed and it wasn't surgically repaired. In other words, plaintiff is going to have a trauma. It might be the trauma from the surgery to repair the perforation, or they're going to have the trauma from, whenever the initial perforation occurred. But as far as the risk factors for developing a lower extremity DVT, they're the same either way. And so, I mean, just out of the gate, you don't have any expert testimony in the case that if my client, Dr. Cento, had done what they allege he should have done, which was, order an additional type of ultrasound, that, and even if all of the things that they're alleging in sequence would have happened exactly the way that they say they would, and I don't think there's evidence to support that, but even if you take all of that as true, you don't have expert testimony that any of those things would have reduced the risk that this patient would have developed a lower extremity deep vein thrombosis.
Isn't there testimony, counsel, that isn't there testimony of record that says if it would have been identified, they would have given blood thinners, which would have, lessened dramatically the likelihood of the deep vein thrombosis?
I don't believe Dr. Spitz said that, and he was the only expert that they offered for causation. And they expressly stated, I mean, counsel expressly stated at the depositions as to the other experts, this is Patton and Dr. Safin, that they were not being offered to provide any opinions whatsoever on causation. And in fact, I think it's interesting, Patton says he's not offering causation testimony. He also admits at his deposition that he doesn't even know that there would have been a uterine thrombosis present on July 2nd when she presented to the hospital. He says he was told that. We don't know who told him that, but it wasn't anybody who testified in this case. It wasn't an expert. I don't know where he heard it, but he's assuming that it was even there to be seen.
The best that we can find for Dr. Spitz on page 54 said, let's see. Okay, so if she really believed that she wouldn't have died from those things, it begs the question why you didn't list it as a cause of death. So I disagree with that. He's talking about the coroner's report. So I disagree with that because I do believe she died from the complications from her uterine perforation, which again are the deep vein thrombi, either uterine or lower extremity, pulmonary emboli. There's dehydration, there's anemia, there's infection, but it lists two different ones. And then on page 88, he said, let's see, talks about the fact that the other thing is Ms. Shepherd is sick. She's laying in bed, significant decreased mobility. That's the number one risk factor for lower extremity venous thrombi. So, but for the urinary perforation and but for her being sick, she doesn't develop venous thrombi and she doesn't have the pulmonary emboli. So, but that still doesn't say that the uterine perforation caused the lower extremity thrombi. Do you know what I'm saying?
Well, it doesn't. And I think on further examination from counsel for Dr. Cento, he admitted that even if the perforation had been identified and had been surgically repaired, which is what, the experts believe would have happened. We don't concede that because you don't always repair a perforation, but neither here nor there for purposes of our argument. But giving them the benefit of the doubt, even if that had happened, Dr. Spitz admitted that you would be immobile because of the surgery to repair the perforation. And so either way, your risk factors for developing a DVT in the lower extremities were the same. And so I don't think that gets anywhere close to him saying, yes, I believe that this DVT was, the result of, in Dr. Cento's case, failing to order a procedure that might have allowed him to observe a condition, not even the condition they were looking for, but might have allowed him to observe a condition that may or may not even have been there on July 2nd. We don't know that. Nobody can say that. And so, I think that's the sort of analysis that
Well, this is, I mean, let's remember, we're talking, it's July 2nd at 11:30 PM. She is discharged July 3rd at 12:20 PM, and she dies on July 4th at 12:40 or 12:50 PM. So we're not talking about it's 2 whole days. It is 24 hours and less than 25 hours later, the patient is found unresponsive at 12:40 AM, July 4th, and is declared deceased at 12:50 something. So we're not talking about a 48-hour period. We're talking about a very finite period of time after which treatment, the procedure, then the admission to the emergency room, and then death.
Well, I don't necessarily disagree with that. Dr. Spitz also testified, though, that he believed that the lower extremity deep vein thrombosis, which he said more than likely is what caused the pulmonary embolism,
5%, right?
would have developed within 2 hours prior to the death to, he said, around 24 hours prior to the death. So that's not something that's slow developing. It's something that, in all likelihood, developed after she was discharged on the 3rd.
Right, but Mr. Henn, some of the physicians for the plaintiffs have said one of the protocols of treatment would be blood thinners, which they have reached medical opinions that suggest she would not have had the deep vein thrombosis had she been given blood thinners. Is that of record?
Well, it was not an argument that was presented to the circuit court, certainly not in the way that they've argued it here to the Court of Appeals. There is some testimony that if she had surgery, that she would have been put on blood thinners. We've questioned that because,
I don't know what the result would be before a petit jury. But at a stage of the litigation where the evidence has to be looked at in the light most favorable to the non-moving party, I have some questions.
Well, let me put it this way also. We don't have any expert testimony that the treatment for it, their theory is that the uterine thrombosis would have been observed, could have been observed, and that one of the treatments for that might have been, some sort of blood thinner, heparin or something like that. We don't have any testimony that that's how anybody would have treated a lower extremity deep vein thrombosis. I don't know that's the case. I don't think that's a subject for.
I think there seems to, but my recollection of the record is there is evidence of record, which is summarized in both the many pleadings that have been submitted to the court on both sides of the V in this case, that does suggest if there had been this identification, which the plaintiffs are saying it should have been, of the perforation of the uterine wall, that in that course of treatment, they would have been ordering the blood thinners, and that someone has testified or represented to the trier of fact or the trial court that had that taken place, they are satisfied that is more likely than not that this young lady would not have expired.
I think that the testimony that you're referring to comes from Dr. Patton, who they're not talking about giving blood thinners as a result of a surgical repair. They're talking about giving blood thinners as a consequence of observing the thrombosis, the clot in the uterus. And the problem with causation in plaintiff's case is that they can't even establish that that would have been there to be observed by anybody on July 2nd. That's the first.
There is
major
testimony
gap.
that there are what I think they're just surgical remains inside the patient on July 2nd. Fair?
That there were surgical remains. I believe that was an observation of the ultrasound, right? The abdominal
okay.
ultrasound.
If that, while the patient is still living, if that radiological study shows that, why are we not admitting the patient so that the patient can have a DNC? And then in the process of that, they're going to probably see that there's a cut 1/3 the size of the uterus at that time. I mean, how is it speculation? I just.
As to Dr. Cento, as to my client, and I think, it's a fair point. I'm not here speaking for everyone, but as to Dr. Cento, who was the radiologist who was offsite, he's in a different state. He's, reading the results. He's not somebody who makes a decision to make an admission, and that's also a standard of care issue. This isn't a standard of care motion. I think if you focus on Dr. Cento's piece of it, the causal link is not there because they can't even establish, more likely than not, that the thrombosis, the uterine thrombosis, was present to be seen had the additional, the transvaginal ultrasound been performed. So, that's, as to Dr. Cento, I think that is a failure in the causal chain in the testimony. And I think, Patton is the one who gets closest, but Patton admits that he's just told that. There's no expert testimony that the thrombosis was there to be seen. And if it's not there to be seen, more likely than not, you can't maintain a malpractice action against Dr. Cento and Dr. ARS. I feel like I'm butting up against my 12 minutes and I want to make sure that everyone else has time. So, Your Honors, if there are no further questions, I would yield to my co-counsel.
That was exactly 12
Thank you.
minutes.
Literally.
May it please the court, Mark Magyar, I represent Planned Parenthood and Dr. Castleman. I'm going to try to limit myself to the 6 minutes, of course, out of respect for my co-counsel. There was a lot said in the opening about, of course, that's where the procedures were taken. The first thing I want to touch on is a lot of what was talked about so far had to do with standard of care. I feel like, even though this decision rested on causation, and we did address this in our brief, so I'll try to be short, but we do not agree that there is such a thing as standard of care as should have known. Certainly, if Dr. Castleman did see the perforation, that of course triggers obligations to act. But on page 27 of our brief and citing her testimony as well as Dr. Sofer's, I don't think there's any real dispute that she didn't. And I think Dr. Sofer even credits that she would have acted if she had. And what would she have done? I mean, we're at Planned Parenthood. We're not at a hospital. She's not an ER doctor. What would she have done if she had appreciated that happened? She would have referred her to the emergency room. And so then we look at what happened with the discharge records my client had. Decrease of pain, scant blood, tolerated food and fluids. These aren't the signs and symptoms that say, I need to act. But there were discharge papers. There was emergency room info. There was a phone number to call if you do experience intense pain. And we do know that the decedent did ultimately, a couple days later, check her into the hospital. Now, when I say this, I agree this is a terribly sad case. And so I'm not what I'm trying to analogize is to a legal principle that we as judges and lawyers use is a concept of harmless error. Now here, certainly there was nothing harmless about what happened. But when the testimony and agreement is that if Dr. Castleman had known something happened, or if there had been exhibiting signs and symptoms during the immediately after monitoring phase, that what would have happened is that this person would have gone to the hospital, and then she goes to the hospital, then whether it's Dr. Castleman that sent her there, or it was because she had Planned Parenthood's literature that said go to the ER, or if she just totally ignored that and just went to the ER, the end result is she did what the next step is if these signs and symptoms are present.
Is there testimony from Dr. Sofer that your client, because of the nature of the cut, had to have known that there was a cut in that uterus?
Well, what we
by
say,
one or multiple attempts to utilize the instrument. And I understand this is a terribly sad case. No physician or healthcare provider who's involved in this is saying, oh no, this is not sad. Everybody understands it. This is the question for this court is there a factual issue on the claims before the trial court that necessitate that the plaintiff's entitled to a trial. So that's the question. I
there
thought
is no-
Dr. Sofer said something like that.
Right, and what we cited were roughly pages 58 through about 62 of Dr. Sofer's testimony, which is he's not contending that he disagrees with Dr. Castleman's testimony, that she just didn't. And so he's really putting in a should have known standard, not some kind of evidence that she did know. And I guess in related to like the Morrow case.
If a fact finder could conclude that the treating physician for the first procedure caused a uterine tear,
Yes.
is that
Is
that malpractice?
It is not. There is
Why
no
not?
standard of care because for one, this is a known and disclosed and accepted risk of the procedure. It's not like, oh my gosh, a perforation happened. This is a known possible risk of the procedure that's disclosed and accepted by anyone who does this. So then and again, I think that the standard has to be what makes you as the physician required to act? Is it what Dr. Sofer is saying is that, well, the tear was big enough and you used an ultrasound, you should have known, but the undisputed evidence or the unrebutted evidence is that she just didn't know. Is it a should have known? And it isn't. It isn't a should have known. It's if you do know, you take action, or if there are exhibited signs and symptoms that there were not here, then you make the referral. And again, whether Dr. Castleman makes the referral or not, the result is that the decedent went to the hospital. And on pages 41 to 42 of the appellant's brief, they clarify. I'm not being cavalier when I say this. I thought maybe we would even get a voluntary dismissal of my clients because on pages 41 to 42 of the brief, they say the trial court really misunderstood our theory of causation. Our theory, plaintiff's theory of causation, is that upon going to the hospital is when the diagnosis should have happened. And I'm not sort of being cute and sort of, trying to box the plaintiff into maybe a misguided word. That is their theory now that has been clarified on the appeal briefs, is that once you got to the hospital, that's when it should have been diagnosed. And there's, many references to missing the diagnosis. That's not what should have happened or even able to be.
Just gonna warn you, you're running up.
Oh, okay. I think I've made the main points I was trying to address, so I will yield my time to the other council unless there are any other questions. Thank you.
Your Honor, Sandra Lake here on behalf of Dr. Woolsaline, who was the emergency physician. Just a few points. I'll rely largely on my briefing comments from co-defense counsel. I do want to reiterate in terms of the argument made by Dr. Sento's counsel regarding the fact that there's no testimony that there was even a uterine thrombus to be seen on July 2nd, which means if that's the case, then Dr. Sento would not have included that in a radiology report, which means that that information would not have been given to Dr. Woolsaline. So again, we get to the same result. It's important to note that when she was discharged, she was hemodynamically stable. And that's critical in terms of, and again, this kind of gets to standard of care, but to address your question, Judge Ratford, our experts have testified that you don't always have to immediately have to take a patient in this condition to surgery. It depends on how they're doing. She was stable at the time, meaning she wasn't actively bleeding, which is why it was within the standard of care to do
What
what
was
they
her
did.
pain level?
I recall 7 out of 10, something of that nature.
That's what I recall too.
Sure. And she's had a surgical procedure. She's in pain.
Right,
But
when she
they're looking
discharged
at
from the
other.
surgical, when she discharged from surgical, she was either 3 on 10 or 5 on 10. So pain's going up dramatically enough that
Sure.
this young 24-year-old says, I got to go to the hospital.
Sure.
24-year-old who's had a child previously.
But when it comes to what treatment she needed at that moment in time, with the understanding that there was materials of conception still left in her, the question becomes, what factors does the emergency room physician look at in determining, does she need to be admitted now or does she go back to her surgeon? And that's what was discussed, is the fact that she was hemodynamically stable such that she didn't need immediate surgery. There was time, they felt, to get her back to her original surgeon. The next point I want to make is on Dr. Spitz's testimony.
Can you back over just a second?
Yeah.
So that was when she was dismissed from the emergency department in the morning of July 3rd?
Correct.
So with the holiday being July 4th, they were anticipating she was going to get back. Did they instruct her to go back to Planned Parenthood on the 3rd?
Within 3 days was the instruction.
Oh, that would have been a long weekend, but still, that shouldn't last that long.
But again, that's a standard of care issue. But the point I wanted to make is that to the extent there's concern, like, why didn't she just immediately get admitted? It was based on her lab work and her condition based on examination at the time.
But they didn't do the intrauterine ultrasound right when she got there.
Correct. And even the plaintiff's experts admit that there might not have even been thrombus to be seen had they done it. The next issue I want to talk about is Dr. Spitz's testimony regarding her risk factors for a DVT. And I quoted this, I mentioned this in my brief at page 20, and it's his testimony at pages 116 through 119. He included in those factors postpartum status, sedentary status, decreased mobility, use of unprescribed drugs, anemia, infection, and dehydration. So none of those are specifically related to a uterine perforation or uterine vein thrombosis. It was just an overall her medical condition as a result of having had this procedure, this abortion procedure performed. The last point I want to make, if I can find it, here it is. In terms of the testimony that she would have been placed on blood thinners and that would have changed the outcome, that testimony was given by Dr. Soffer. And what I want to mention about that is this is not an issue that was raised in the trial court. This is something new on appeal and it's my argument that it was waived because it wasn't raised. But more importantly, during his deposition at page 178, he specifically testified that he was not giving causation testimony in this case. That was not his role. And so we shouldn't be looking to Dr. Soffer's testimony when Dr. Soffer says, I'm not going to be giving causation testimony. That's all I have. Thank you.
Thank you. Size. So I believe we have 8 minutes left.
Good morning, Your Honors. Or actually, it might be afternoon now. I'm not sure.
Yes.
Catherine Gossick on behalf of Defendant Bronson Hospital. We're alleged to be vicariously liable for Dr. Sento and Dr. Wosleyan, who are the ER physician and the radiologist, and involves the care from July 2nd and July 3rd.
Which doctors, please?
Dr. Sento and Dr. Wosleyan.
Thank you.
And so I just kind of want to go back to the basics here. This case, pulmonary embolism was the cause of death. And Dr. Spitz talks about 2 different types of blood clots, uterine blood clots and lower extremity blood clots known as DVTs. Dr. Spitz testified that, and I quote, I believe those originated, the pulmonary embolisms, from peripelvic, periuterine veins, but more likely lower extremity veins, so the DVTs. That was his causation testimony. The DVT was the cause of death. Now, surgical repair of the uterus was not going to prevent the DVTs. That may possibly prevented the uterine blood clots from traveling to the lungs, but it would not have done anything to do with the DVTs. The only connection I want to talk about, Judge Redford, you mentioned the blood thinners. On page 34 to 35, my brief discusses the blood thinners. Dr. Sofer said, but this is with respect to Planned Parenthood and right after the surgery, not after the July 2nd ER visit, that they could have given blood thinners. Could. He does not tie blood thinners to the DVTs. Now, again, as established in the testimony, uterine blood clots are much smaller than DVTs. That's why in order for that to be a cause of death, there would have had to been many uterine blood clots versus one DVT could have been the cause of death because they're much larger. Dr. Sofer does not testify that had you given X amount of whatever blood thinner on X day, that would have prevented a DVT. There's no such testimony. And on top of that, Dr. Sofer made his vague opinion on blood thinners before Dr. Spitz testified about DVTs. So I'm not even sure that Dr. Sofer actually knew about DVTs. And there's just no testimony connecting blood thinners to prevention of the DVTs, to preventing the death. And unless this court has any other questions for me, I think counsel covered everything.
Any questions? Any questions?
No, thank you.
Thank you.
Thank you, Your Honor.
I believe we have 9 minutes.
Okay,
Yeah.
I can make this work. Absolutely. Okay, with respect, I wanted to go to the deposition testimony of Dr. Spitz. He says specifically on page 54, I do believe she died of the complications from her uterus perforation, which again are the deep veins thrombi, either uterine or lower extremity. So he says that that's what caused the death. Then
Uterine or. So
Sure.
you still can't tie which one that ended up in her lung.
But it doesn't matter again, because if they're both due again to the perforation, which is what he then testifies to on page 88 and 114 to 115, they ask him specifically, how is it that there is this connection between these two things? And he says, I did. Highlighted it. He says, you'd agree that lower extremity venous thrombosis is not related to a uterine perforation, correct? Answer, no. I think it is very much related. I think it's related from a couple of different things.
What page is this?
This is page 88.
That's the one I read into the record already.
Yes. Trauma in the body increases an inflammatory response. Inflammatory response in general is a increase or produces a hypercoagulable state. So the trauma that she had as a result of the perforation resulted in this hypercoagulable state, whether it was a blood clot in the uterus or whether it was a blood clot in her lower extremities. He says it is absolutely related to that trauma, that perforation. He says he reiterates the same thing on pages 114 to 115. I have a couple other points too. I really want to reiterate to this court, this is not a standard of care motion. Yes, we have to address standard of care in order to address whether or not there's a causal link between the standard of care and the injury. But I've heard multiple comments from the other side saying, there wasn't sufficient evidence regarding standard of care. That's not even an issue, and they're completely wrong. You have Dr. Sofer, who testified with respect to Dr. Castleman and how she breached the standard of care in failing to diagnose that perforation and in breached the standard of care and failing to send that patient to the hospital immediately with that diagnosis. There is nothing, if I was unclear in my brief, I absolutely am clarifying it now that I am not waiving any claim with respect to Dr. Castleman. It wasn't the hospital that was supposed to diagnose that perforation. It was her. And that's based upon Dr. Sofer's testimony. With respect to there was like a statement as well that it may not have been seen on the transvaginal ultrasound. They testify that comment may have been made at some point in the deposition, but that all the depositions of Sofer, Patton, and Galen said, had you performed that transvaginal ultrasound, more likely than not, you would have seen the perforation and you would have seen that uterine blood clot. With respect to the dehydration, the infection, the anemia, Dr. Spitz was very clear that that was due to the perforation. So if she's laying down because she is sick as a dog as a result of this perforation, that is still caused by the perforation. That is still a factor that came into play because that perforation happened in the first instance. And if that then increases her risk of a lower body or lower extremity blood clot, that is still on them. That is still a causal, that's still linked causally to the breach of the standard of care and failing to recognize that perforation and failing to get it treated. And then again, the last point I want to make, Dr. Gallon and Dr. Soffer again, they both testified that giving those blood thinners would have prevented the PE. It would have avoided the death here. So based upon all of the expert testimony looked at in the plaintiff's best view, this established a genuine issue of material fact as to causation.
Did you raise the blood thinner issue below? I thought I heard a couple of people say.
I know,
that was not raised below.
I don't know the answer to that, frankly, but the deposition testimony is there. I don't know if, specifically it was raised in the motion below, but that testimony is there. The judge had all of that testimony in front of him. I didn't bring new deposition testimony and during the appellate process or anything. That testimony is there, and it establishes that there is in fact a causal link between those. It could have been fixed essentially. Unless the court has any questions, thank you very much for your time. I very much appreciate it.
Thank you. The matter has now been submitted. You ready to okay, keep going, or do you need we spend several hours?
Well, it's been 3 hours. I sort of 2.5. I certainly wouldn't mind a brief recess.
A brief recess, and then we only have 3 after the next topic. So
Yeah, I don't know if they break them.
I'm much older than you, Matthew.
welcome back. We'll now call item number 7, docket number 367301, Joseph D. Fail Engineering Company, the Crystal Automation Systems, Inc.
Mark Magyar for the appellant JDF. Also with me is my co-counsel, Ms. Insidis. We both represent the appellant, and if it pleases the court, we'd like to split our time if we even use it all 23 and 7. And I'll be addressing the counterclaims that my client defended, and she'll be addressing the affirmative claim for non-payment of invoices that was originally brought. And out of those 23 minutes of mine, I would like to reserve about 5 for rebuttal. So that makes 18 for me.
Oh, God. I need a
Doing math.
calculator.
Yeah, lots of them.
That's why I went to law school, not engineering.
Well, I'm a math guy, don't worry.
And with respect to the counterclaims, which
The presiding judge has a graduate degree from the London School of Economics, so he's going to be able to figure all of this
Yes.
out.
It's necessary. Yeah.
Mhm.
And so I'm only addressing the defense of the counterclaims, and we're asking that the court reverse the $1.5 million jury verdict that was entered in favor of the counter plaintiff Casser. And there are really 3 components, the rule of 3, you gotta love it, that we're addressing. And we think we should win on only the first one without even having to get to the other 2, and that's statute of limitations. We believe it barred the professional negligence claim, and that the contract claim was in fact subsumed in that. Not that you can't bring a separate claim, but that it is subject to the same statute of limitations. Only if we go on and that doesn't knock out the counterclaim, which we believe it does. And if there's some finding that there's an aspect of the contract claim that remains, we believe that the trial judge's grant of the JNOV to allow the contract claim to have a judgment was erroneous. The jury.
May I ask you a question?
Sure.
If we don't, if someone were to conclude that there's not a problem with the original verdict by the jury. So on the I
Professional
forget,
negligence.
professional negligence. Let's assume that that's the case. And for whatever reason, you're satisfied that there's enough evidence for the 1.5. Okay. Why does I don't even remember what the language it was, but why does the modification to incorporate the contract claim, why does that even have to happen? What's the relevance of it?
My belief, and I can't say for certain, it's just from being involved in the proceedings. And this is not meant in any way pejorative, but I think it was sort of a belt and suspenders that I know that the statute of limitations issue is going up because we've been at it at summary judgment, we've been at a directed verdict, and if that claim goes by the wayside, then this is an avenue for the verdict to stand independently. I disagree with that, but I think that was maybe the thought process. Yeah.
Was there a motion for it? I think there was.
There were counter motions. So I got involved in the case prior to appeal, but not at the trial level, but post judgment. I filed a motion for the statute of limitations, and there was a counter motion for JNOV, and that was granted by Cassair on the breach of contract issue.
Okay. Thank you.
Yes. Thank you. And so it's kind of the third point is if there's a claim that survives in full, and the reason I say in full is we're going to get to this sort of closing out the contract items, but if there's a claim that survives in full, we still think the judge should have granted our motion for a new trial because I've searched up and down the record and I can't make any sense other than being arbitrary, the 1.5 round hole figure for, and that's a little bit different than.
There was testimony, it was 3 million, there's testimony, it's 900,000, there's testimony, it's 700,000, there's testimony, it's 1.2, 1.3. Why can't a jury in their discernment of what the evidence is, you didn't ask for special interrogatories. I mean, you didn't propose a special jury verdict. They come up and say 1.5. Why isn't that satisfactory?
I think if you could point to where that even, I mean, I couldn't put any of the numbers together.
But is there sworn testimony of record? Here's what the damages are. And the numbers roughly approximate what I just said.
See, I think that
that's a yes or a no.
I'm sorry, what was the quote?
Is there testimony of record that somebody testifies, oh, our damages are $1.3 million, our damages are 1.2 million, our damages are 800. It's all over the board.
Yes.
Okay.
That's all there. Yeah.
So there is evidence of record that the range is somewhere between 803, 3 million, and the jury says 1.5. How is that something that a reviewing tribunal or a trial court being asked to review or grant a new trial? What?
I think the nuance we have is there's some argument you may make that say there was no evidence of damages. We're not saying that. There was evidence of damages. Then there's another school of saying there was evidence of damages, but you can't pull an arbitrary number out of a hat. And it was unpublished, but we cited that Farsgob case where it was sent back for new trial because they said the jury picked a number between 0 and 40%. And it seems like they just picked. And so I think we're really focused more on arbitrariness than there being a lack of evidence of damages, which are different issues in terms of having a new trial.
Okay, understand
it. And I think those questions are fair, and I want to give full treatment, but this is really sort of the tertiary sort of all the way down the line, because I will suggest to this panel, to your honors, that there is not a legal outcome that can include under your hypothetical that we started, the assumption that this $1.5 million professional negligence can stand. There isn't. And the reason I say that is we know what the scope of this engagement was because it was federally required. Cassair didn't want to hire another engineer. They were forced to. They were not allowed to do. So we know it was engineering services. And if we need to look any further, the contract is called engineering services contract. And count 7 of the complaint lists out all the ways in which they breached their professional responsibilities. And that count does not include anything post-project after the project's constructed, because even in their pleading, the counter plaintiff, Cassair, is making a distinction between these engineering services And then you have to look to their contract claim, paragraph 57, where it says, and a further breach, further than all these professional shortcomings, were these closing out the contract issues of getting lien waivers, getting a certificate of compliance, making sure not only is the contractor paid, but they're not going to file a lien on the property. None of that even happened. So this was additional items. And so what do you do when you have?
When your client left the project
Yes,
for the last day,
yes.
at the point in time where your client left the project, had every permit which was required to be issued for fiber optic network to lawfully operate in the areas that it had been installed, had 100% of those documents been issued by every local, state, or county governmental entity.
My understanding is that the Caceres position is that had not. And I think I think you have to look at the CFR to see if it really says that we own that, but it's not dispositive. And I'll tell you why, Your Honor.
Okay.
Because if you take every obligation that's a professional obligation from count 8, I think it's misnumbered. There's 7 counts, but it's count 8. And you match it up with the contract claim. All of those that overlap, oh, you didn't clean up. There's zigzagging lines. All the physical work that we were responsible to oversee, we weren't doing the physical work, oversee the contractors. The law says that you don't get to rope those in by coming up with a few additional independent special, what the case law calls a special obligation of the contract. We cited the DLZ case where there was an indemnification obligation that survived by itself, the indemnification. Everything that was overlapped.
How is the project complete from your professionally licensed engineers if you don't have a certificate of completion?
Because
that you can then go sell your company, do whatever it is you want to do.
There's a difference between exercising professional skill and additional contract obligations. Again, the plaintiff in their own pleading did not include these post-closing obligations in their professional negligence claim because these are not professional obligations. And
You ever try to get a certificate of occupancy? You ever try to get a statement of durable medical equipment being needed?
the certificate of completion is in the
Certificate
record.
of medical
It's
necessity,
October of 2015.
which is, sorry.
The certificate of completion is in the record and is from October of 2015.
Right, but if all of the, okay, I understand your position.
Well,
These are the pedestrian responsibilities that did not survive the contract, or if they did survive the contract, they're not part of the professional services. And so they can't be a claim because they're more than 2 years after they were completed.
right. I mean, what we've posited more than one outcome that this court could reach. We think that this falls in the line of, if you look at the UHY case and Judge Ray Orden's dissent in that, which is the law, he thought in that case it should have applied that way. Is it can be a few ways. It can be that these are just additional follow-up items for a project that was already complete, in which case they're completely subsumed and time barred. Or if you think that they are concrete enough contract obligations, they can be independently actionable. That does not mean, though, that they pull back in all of the same conduct and claims that are based on performance of the engineering services after the contract is done. I mean, that's just, I think it was Judge Maloney in the Polyflex case. That's an end run around. You find a couple of disputes about billing and you say, instead of being limited to that, I get to pull back the things from 4.5 years ago during a project that was done in 2015.
But in this project, I mean, they didn't even do Big Rapids, right? Everything was done, but not Big Rapids.
No, everything was absolutely finished.
But I thought,
There was no more work done after July 31st, 2015.
I thought I read something to the effect that Big Rapids wasn't completed.
They might have been taking issue with the manner in which, or they might have been making claims that it wasn't fully, but nobody went back to do any more work.
And I mean, we cited the testimony of the federal agent who said it was done. We cited the testimony of the president of Casser who said it was timely done. They sold the project. I mean, it was done. And it was JDF that filed a claim 4.5 years later in 2019 for not being paid that sparked this counterclaim. And if you look at the, even in the brief on page 17, there's talks about May 2017 certifications. Those are still beyond 2 years. Billing, I mean, that's just trying to collect. That's not working on the project. You know, I think I'll save my time for rebuttal unless the court wants to discuss or has any more questions.
I have one
But-
I have one question. I'm going to ask both sides, I guess. And I wrote this down. Why didn't the jury verdict form require the jury to identify the contractual breaches it found? Or if there were any contractual breaches?
Well, I think it should have, and I think that's one of the really big problems with the JNOV is that it's not such a simple matter of just saying, well, I think they intended to find breach when even by the plaintiff's own account, the count 2 encompassed what they determined were 36 different breaches. And so there was no effort to say, well, which of those, and the jury found no breach. So
The jury what?
the jury found no breach of contract. That was for my client. So I think your question, Judge Feeney, is a very good one, but it really only comes into play as if you're going to find a breach, we need to get specific. And that's what the trial judge didn't do, but the jury found that there wasn't any breach.
Who drafted the verdict form?
My understanding, and perhaps counsel can speak closer to it, would have been probably Casser if they prevailed, but as the plaintiff.
Well,
but-
yes, there was a counter plaintiff.
Right, those were the only claims tried because there was the summary judgment ruling.
Right, but at some point, is there a matter where the trial court asks these questions? Everybody review the jury instructions, any objections, corrections, requests for any additions, deletions, changes, anything. Did that happen? And everybody has a jury verdict form. Everybody satisfied with it, or any requested edits, corrections, deletions, additions, anything else?
Well, we
Did
have
that
relied
happen?
heavily on the instructions because the orally and in the instructions were that you can find for the counter plaintiff on one or both or none. And they were specifically instructed, if you find no breach of contract, then move on to see if you find negligence. That's exactly what they did, only for the trial judge to say, well, if they found for professional negligence, they must have also meant to find for breach of contract.
Did
And
your client interpose any objections to either the verdict form or the jury instructions?
if they did, I would rely on the record, but I'm not sure which instructions we should have, what we're saying were objectionable. I think we're relying on the instructions.
And the jury verdict form, right?
Okay, but
Yes or no?
yes,
Okay,
we don't
so
have an issue with the form.
all right, so if the jury verdict form and the jury instructions are agreed to by all counsel, the jury comes back, says, breach of the engineering professional responsibility, $1.5 million are the damages. There wasn't a request for in the jury verdict form. Tell us how you came up with this. Tell us, was it this much in 2010, 2011, like we see in.
I don't believe there was that. No, Your Honor. And so I guess now I understand your question, because when I'm looking at the verdict, to me, it's that they only found professional negligence. Statute of limitations is a purely legal issue that we believe should take care of that claim. And the breach claim, they found no breach. So we don't really take issue with the form.
Thank you.
Good time.
Good afternoon, Your Honor. Jamie Nasidas, also on behalf of the appellant. as council indicated, I'm simply going to address the affirmative claim, the bulk of which was dismissed on a summary disposition motion. Essentially, what the trial court did is capped my client's ability to recover on a breach of contract claim at $38,992.19. It's our position that the trial court erred, that the trial court failed to recognize that at the very least there was an ambiguity in the contract and that the contract claims should have gone to the jury on whether or not there was indeed a cap that limited the amount of their recovery. We specifically point to section 3.13 of the contract regarding compensation, which says that the compensation to be paid to my client is to be set forth in the various attachments to the contract. And those attachments, with very limited exception, all say that they're to be paid on a time and expense basis specifically. There are no caps set forth in any of the attachments with the exception of one, and that's Form 217G as to sections 1, 3, and 4. That does have a cap for those particular services under that attachment at $166,718. But despite that, the circuit court found that another provision in the contract did place a cap on recovery at 20% above what was an initial estimate listed in the contract. Now, that estimate is only discussed in section 3.19 and 320 of the contract. 319 doesn't say anything about that estimate being an indication of the amount of compensation that would be available to my client in the event or upon completion of the contract. It simply talks about they have to provide an initial estimate, monthly updates, and a final statement of engineering fees using a particular form that's dictated by the federal regulations. It doesn't place any limit on the compensation. So what the trial court relied on was section 3.20, a contract amendment section, which specifically says when the total engineering fee exceeds the initial contract estimate by 20% or more, an amendment to the contract shall be required as set forth in 7 CFR Part 1753. And again, it's our position that section 3.20 rather, does not act as a cap on compensation. Instead, it's the parties' agreement that in the event that the fee exceeds that estimate, they will enter into a contract amendment because that contract amendment is required so that CASAIR can obtain loan funding under these federal regulations. It's not a cap on their compensation for the services performed, but simply a perfunctory thing that needs to be done in order for CASAIR to be able to obtain a loan. It does not give one party a unilateral right to refuse to enter into that amendment. In fact, it says that an amendment shall be required as set forth in 7 CFR Part 1753. So as I indicated, Section 320 does not speak to a cap on compensation. It simply says that an amendment is required. It does not say that my client isn't entitled to compensation on the time and expense basis that is set forth throughout the contract unless there is an amendment. And what the court failed to recognize is that there are clearly two different susceptible meanings to this contract. One is that it is a time and expense contract with only one cap as set forth in that particular attachment that I mentioned, or alternatively, CASAIR's reading of the contract, which also ultimately was the trial court's reading of the contract, which is that there is a cap based on section 3.20. Now, I would like to say as well, though, that the contract is ambiguous both in terms of that, but also in terms of how it incorporates 7 CFR Part 1753. It's 1753.11 that governs amendments, and that provision in and of itself is ambiguous, and it's also ambiguous not just when read alone, but when read in conjunction with the other provisions of the contract. Section A2 of that particular federal regulation only requires an amendment if the amendment increases the amount to be paid under the contract by 20% or more. It doesn't say anything there about an initial estimate. So it's even questionable whether that particular provision requires an amendment under these circumstances because the language doesn't match up between section 3.20 and what the federal regulation actually says. There's also discrepancies in the regulation about the timing of any amendment. Does it have to be approved by the RUS prior to it being executed by the parties or after it's executed by the parties? It says two different things in the course of that federal regulation. So in this case, the contract clearly had two was susceptible to two different meanings. One, that fail engineering was to be compensated exclusively on a time and expense basis as to most aspects of the contract with no caps on that compensation except as specifically set forth in the contract. And then the trial court's version of that, which was that the compensation was capped at 20% or more of an initial estimate, where then one party was exclusively allowed under the trial court's analysis to refuse to enter into that amendment, even after the services had already been performed and the fees had been incurred. It's our position that the court should have denied the motion for summary disposition, that the contract being ambiguous was to be construed by the jury based on the purpose of the contract as a whole, the rules of contract construction, extrinsic evidence regarding intent and meaning, and the party's conduct and past practice. All of those things should have gone to the jury, but they did not because the trial court granted summary disposition and capped the damages for breach of contract. It's not clear if the trial court also decided this based on the statute of frauds because they didn't really explain at all the basis for the ruling, but there's no statute of frauds here issue either. We have a written contract that says time and expense basis. Unless you have any questions.
Do you have a different response to the question that I asked co-counsel with respect to the jury verdict form?
I don't know anything about the jury. I wasn't involved at the lower court, so
Okay. I thought I would ask.
yeah, thank you.
Thank you.
Thank you. Right on.
Good afternoon. My name's Dale Burmeister, at Police the Court, on behalf of Gas Air. With respect to the questions that were asked already by the court, let me just respond. First of all, I'm the only one who submitted any jury instructions or the verdict form. None were submitted by Fail Engineering in this.
Did they
trial.
interpose
What's that?
did they interpose any
No.
objections?
The only issue that arose about the jury instructions was making sure that the jury understood that it could not award damages that duplicated claims under the breach of contract theories and under negligence or malpractice theories. And as far as the verdict form itself, it was concerned, no special verdict form interrogatories were suggested or proposed by counsel for Fail Engineering, which would have said, what breaches do you find? Are these economic loss damages? Are they this kind of damages? What kind of damages are they? And so forth. So that was not requested. So
How does the trial court have this supernumerary authority to amend the jury verdict, which is specifically deliberated on, voted on, returned in open court, and say, oh, what you really meant was X, when the verdict form itself says, no, they didn't mean X?
Right,
How do you get, I don't remember that at judges school when I was a trial judge,
Well,
that we were able to do that.
It
but
happens.
maybe
It
it's
happens actually
changed.
more often than you might think. But no, it's because some of the breaches were so clear and they were unrefuted that the judge said, this constitutes a breach of contract. They
Right,
didn't
I get
close
that
out-
if you do
Yes.
it before in a C7, C8, C10, and you take it away from the jury. But when the petite jury has said, nope, sorry, that dog don't hunt, how do you as a trial judge then have the authority under Michigan law to go back? I know you can reform, I know you can change verdicts. I know remititure, I know additure, but I don't like the verdict they got. I missed that memo, I guess.
Yeah, well, it's because, as he already alluded to, I told the jury in opening statements and in closing arguments and so forth about all these different breaches that were admitted to by the president of Fail Engineering, by the former president of Fail Engineering, and by the Marion Bowman, who was the certified engineer that was supposed to run this project, but never did because because of some health issues that arose or something. They all admitted under oath that there were numerous breaches of contract.
And they said, we breached the contract.
Exactly.
They said those words.
Right.
Or they said, no, we
We
didn't.
were obligated.
Hold on,
I'm
counsel.
sorry.
They said, I breached the contract. They said those words.
Not those words.
Okay, they said, we did A, B, and C. And
Right.
your read on that, A, B, and C is, well, that's obviously you admitted the breach. Is that a fair understanding of what you're suggesting?
Yes and no. I mean, to the extent that I asked Marion Bowman at his deposition, did you know, there's all these emails that talk about not having enough people on the project. Do you agree? There weren't enough people on this project. There were way too few individuals there. And he said, yes. And you had an obligation under this contract to provide sufficient and trained personnel, right? And so that's a problem, right? You didn't comply with that provision of the contract, did you? It was those kinds of things. Or when you don't close out the contract with the owner and you don't close out the contract with the U.S. Department of Agriculture by filing suit, that constitutes a severance of the professional services and so forth. It also constitutes a breach of contract because you didn't comply with that provision. You have to do these 16 things to close out a contract with the Department of Agriculture. You didn't do any of them. You filed lawsuit instead. That's clearly a breach of contract, and the judge so found. She said there were numerous breaches that were unrefuted by any testimony whatsoever, and therefore you're entitled to JNOV on the contract claims.
Okay.
But I mean, it's hard. I agree with Judge Redford. I think I missed that part at New Judges School too, because it's pretty clear that the jury didn't find the breach of contract. So it's like the judge is saying, well, they're just a bunch of jurors, and they missed that part because they did find the professional responsibility, right? And that.
Right.
So I guess I just don't.
No, I mean, I clerked for a federal trial judge who later became an appellate judge, and that shocked me too after law school. Like he would occasionally grant JNOV on one of the theories because the verdict was so overwhelming, in addition to taking away verdicts under JOV motions.
But I mean,
because it was so clear.
In 22 years, I don't think I ever had one. And I don't know Judge Redford, if he ever had any. And I don't know. Judge Ackerman was involved in 2 different circuits that he clerked in. And
Right.
I can't imagine you guys.
I get that we have a trial judge has the authority. But
Yes.
I mean,
But when the jury speaks like this to say, oh, nope, you got it wrong. You've been sleeping. Sorry.
Yeah.
And I'll
I mean, the right to a jury trial was established June 15th in the year 1215, when King John of England, at the tip of a crossbow bolt, signed Magna Carta, and for the first time ceded from the crown the authority for individuals to make decisions in civil and criminal claims.
Right.
We have respected that since Locke's second treatise on government, all of our historical documents and the founding documents. And I just, boy, a jury says no, but oh, no, I think they're wrong.
Well,
And I understand reviewing tribunal, 7 great justices. We have the authority to do it. It's just very rarely imposed. So.
and I think the testimony was so clear and unrefuted on many of the breaches that I claimed and offered testimony both by my clients, my expert, and also admissions by their people that they breached the contract in one or more ways. That
and you
she
don't-
had to rule that
And
way.
you don't think the jury saw the breaches as that toward the professional responsibility piece as opposed to technically with the contract itself? Because as Sister Counsel talked about, the contract is, it needs to be interpreted. It can be ambiguous in certain spots. Section 320 is different what the federal regulations require.
Well, and that was disposed of on summary disposition. I filed a motion for summary disposition to limit the amount of their damages because the contract, the 217 contract plus A through H RUS forms, which stands for Rural Underground Systems, required. They say for this amount, you can do this. You can't go over 20%. For this particular section of the contract, you can go 20% over, and so on and so forth. And I calculated for the court and got an affidavit from the CFO of Casair and an affidavit from the president and showed exactly, and I think I may have even quoted part of it in the brief or showed an image of it in the brief, but it was a spreadsheet that had been prepared. Add 20% automatically. add nothing because this is the cap and so forth. The language of the contract itself is so clear. And the judge had 2 hearings on it over the course of like 2 months, allowing them to submit a supplemental briefs and everything else. But they didn't submit anything refuting it. And because all these contracts are the same, they were doing 15 other projects around the country at the same time they're doing our project. All the forms are the same. All the regulations are the same. So there was no dispute about what the contract meant, and it was clear, and it was supported by affidavits that were unrefuted at the motion for summary disposition on that issue. And that's why the judge limited it to 38,000 plus. And we then made an offer of judgment prior to trial for that amount, and it was refused. But the judge says, I'm not going to try issues that I've resolved. As a matter of law, they can't ever get more than 38,000 some odd dollars. And so let's try the counterclaim. And that's what happened. So I want to address 4 things. The first is the statute of limitations issue. And the second has to do with the JNOV. I may say a few additional remarks about that. The $1.5 million damage award was also, there were some questions about that, and I'll address that. And then the cap, if there's anything else additional I need to say about that. But turning to the statute of limitations, it's important to understand that simply because 2 of the subcontractors stopped working in the middle or fall of 2015 does not mean that professional services suddenly came to a screeching halt. In fact, just the opposite. Prior to that time, most of Failed Engineering's job was to send crews, send people following these plows and so forth to make sure they were plowing within the right of way or plowing within the easement or properly avoiding underground utilities, gas lines, electrical lines, things like that, and staking ahead of this huge equipment to make sure that they didn't sever some sewer lines, as in fact happened in this case. After that was when a lot of the heavy duty engineering was required. So to suggest that, oh, that's the stop dead date, and after that it's just a little paperwork here and there is ridiculous. I mean, it took until 2017 for them to close the contract with one of the major subcontractors, J Rank. And in fact, they had to issue a superseding order of certification of partial completion of the project completion of the project by that company. So to say, well, oh, it stopped in 2050, they were still actively involved under the contract doing engineering work to challenge the claim that this contractor was entitled to about $1 million more. They were given a contract for $4.9 million, and they wanted almost $6 million and so forth. Fail Engineering, as our representative and so forth on that contract, was intimately involved in overseeing that dispute. And in fact, issued in 2017, $100,000 or $99,000 credit because that contractor had done 4,700 convenience bores, which are you're plowing along a roadway and bearing cable, fiber optic cable 2.5 or 3 feet below the surface and so forth. And all of a sudden you come to a tree. You know what? It'll be faster for us to just do a convenience bore. Let's get the expensive equipment out here and go under the tree instead of around it or goof around that way. 4,700 of these things were done by this one contractor. And that's in part because why they were $1 million over budget. And so it got resolved, but it was because Fail Engineering was intimately involved in that whole process. Even after that, one of the biggest problems was that we didn't have permits from railroads for crossing railroads, for crossing wetlands for crossing, easements where competing utilities had underground buried things. And there's all kinds of other permits. It was in the hundreds and hundreds. And in fact, one question was asked, well, how much time was spent? Were all the permits that were required still there? Well, we submitted an affidavit from Mr. Beinhardt, the president of the company, saying in 2020, all the permits were not required. These are required to be in place before plowing and drilling and everything else is done, because otherwise you don't know if the municipality or the road commission or, Mishcon or whoever it might be will come along and say, wait a minute, your line is way too close to an existing underground utility. That's why you have to get permission to do this. Or if the road commission decides they need to lower the level of a ditch next to a road, they can plow the down and not worry about disrupting, internet service to thousands of people. So on top of all that, in addition to exchanging literally hundreds and hundreds of emails with my client about obtaining these permits and what are you doing about all these ditches and unfilled holes and cable on top of the ground and everything else, hundreds of emails were exchanged about that into 2019. In fact, 2 weeks before this lawsuit was filed, Fail Engineering is sending my client email saying, oh, we're still working on the permits. We've reached out to all the townships that haven't issued them yet, and all the municipalities and all the road commissions and the Wetlands Conservatory and everybody else. And we're working on it. We're working hard to get this done because we have to close with you on our contract. And then we've got about 16, I think there's 18 different sections of closeout that you have to comply with under the contract with the United States Department of Agriculture. So to suggest that this was, something other than paperwork or to suggest that it's something just mere paperwork is not correct and certainly not supported by the record. In short, on the statute of limitations, I think it's clear that the statute never started running because professional engagement had not yet been terminated. There were all kinds of contractual obligations that continued long after 2015 and right up until 2 weeks before this case was filed against us. And so I think when you look at that and all the literally, if you read this contract carefully, there are literally over 100 affirmative promises that are made in the contract that will be satisfied and so forth, including that will comply with engineering standards and so forth. But there's over 100 of them, and that's why I was able to identify at least 32 that were clearly breached in this case. But clearly the closeout wasn't done. The filing of the documents that say no liens exist and so on were all done or not done, and therefore the engineering services did not terminate or end, and therefore the statute of limitations did not accrue. Now, turning to some of these obligations, I mean, these are contractual duties set forth in these contracts that also incorporate two different codes of federal election. I brought one of them, section 1753, is 52 pages long. And every page on it says, this is the responsibility of the engineer on this. It shall do this, it shall do this, it shall do this, and it shall comply with this federal statute, it shall comply with this. So I just say that because there are numerous contractual promises that are not subsumed by a breach of or malpractice in in this case. I won't go through all those because my time is almost up, but suffice it to say that each separate section of the contract is littered with affirmative obligations that are always framed as the engineer shall do this, the engineer must do this, and so forth. Turning to the damages section, the $1.5 million that the jury awarded is clearly tied to concrete quantifiable harm, repair costs, diminished conduit value, and so forth. In particular, evidence was presented that it cost $227,000 for Casair to obtain all the permits that Vail Engineering failed to obtain. To build out Big Rapids, because it was not done in response to your question, Judge, cost $246,000. Casair did that itself. And by not prioritizing Big Rapids as required, about $310,000 was lost in revenues because it's a highly dense area where a lot of people are subscribers. The cleanup and repair of thousands of manholes and so forth that were improperly installed, that figure that was testified to was $612,480. There was about between $100,000 and $135,000 of consulting fees that were incurred prior to litigation because of all these, because the project was $4.2 million over budget at that point. That was, I put down $120,000. And then a lawsuit, of course, was filed because Vail Engineering blew through a sewer line and a manufacturing plant had to close down because it got flooded. And that was settled for $7,800. But those items total $1,523,280. That ignores the $3 million.
Evidence is replete with damages to fully support your jury verdict. What else do you need to tell us that we don't already understand?
Well, there were other, just being over budget, 4.2 million. And their president admitted that he believed it was at least $2.5 million over budget. So there's other additional things, but just the hard numbers and so forth add up to $1.5 million. As far as the cap is concerned, we've already talked about that, and I guess my time has expired, but suffice it to say that the affidavits and the exhibits that I used to establish that to a certainty were clearly ample. We had multiple oral arguments, extensive briefing and rebriefing at the judge's request, and she granted that motion. So for all of those reasons, we would ask that the court find that the counterclaims were timely in light of the ongoing duties in obtaining permits and the punch lists that they were mandatorily required to complete and then inspect and certify were done. And so the completion of Big Rapids and so on, that the JNOV on the breach of contract was compelled by the unrefuted evidence of same. The jury damages were supported by competent and extensive evidence, and the contract cap was enforced exactly as the parties agreed. And so we therefore request that the court affirm in all respects. Thank you.
Thank you. I believe there are 6 minutes remaining on the other side.
Thank you. First of all, there were no admissions of breaches. I'm going to rely on my brief. We cited the testimony for every time they said there was a breach. Our witnesses at trial said there wasn't, and I'll leave that at that. I did want to, Judge Feeney, not to strike fear in you, but bring up a case that you were on the panel of.
So much.
It's case number 369709. It was decided about 5 months ago in February. And it touches on subsuming, where in that case, a breach of fiduciary duty claim was subsumed into a legal malpractice claim and subject to the same statute. So it's just another case. You may find it factually applicable or not, but it touches on the legal issues that we're dealing with. But really, the heart of what I want to touch on with my remaining minutes, and I want to leave a little bit of time for my co-counsel too, is the disconnect we're having, and especially in our discussion, Judge Redford, is, whether being done with the project meant being done with the engineering engagement. And I will submit that project is a defined term in this contract, and it's construction. And what Russ required of an engineering firm who Casser didn't want to hire, they wanted to do it themselves. The requirement was that they handle the aerial, and you need to have an engineer. An engineer, you have to oversee the contractors doing the work. So without there being construction, there isn't specialized engineering work to be done. And what I want to draw the court's attention to is the contract are Russ documents. There's Form 217G. This is page 886 of my appendix, and there's the provision that's called final documents. And it says that the engineer shall prepare and submit to the owner complete and detailed final documents as specified in 7 CFR 1753. And it has to do that after the construction of the project, after the completion, and there has to be certificates. And no matter how far down the road it takes to get these certificates, it doesn't change what they say is the completion date for all time. And then when you turn to the CFR, it says that one of the engineer's certificates is that there is under subpart E, 1753.18E, that there is a statement that all necessary approvals have been obtained from regulatory bodies and other entities with jurisdiction over the project. It doesn't say the engineer is responsible for getting those. And our witnesses testified at length at trial about how much delay and other obstruction of the process, uncontrollable by them, got in the way. But their deliverable is a certificate, not going out and getting, and so that was one of the big sort of arguments that Casser pulled off, is that our deliverable was to get the permits. No, our deliverable was a certificate that the permits have gotten in. But everything is tied to end of the construction of the project, defined term, which is construction. And in fact, under final documents, under the contractual provision that I was just reading, final documents are to be submitted, quote, after the completion of construction. And their witness testified, their expert, Mr. Orphan, after he went around the sites and looked and confirmed that there was no more construction being done, that in his expert opinion, that is when JDF should have, quote, provided the final documents. Because he's saying, I've gone out, I've looked, the construction's done. So supply your contract documents. And the disconnect we're having is that providing certifications, there's the case law we presented, DLZ Inc., Polytech, other cases. You carve out what are special contract obligations versus the thing you're doing that is and this is the accrual statute, the engineering thing that you are hired to do. And for us, it was to get the project completed. So I'm not saying there weren't obligations. I'm not even saying you can't send it back to see if they have a claim on those post-project. What I'm saying is they are dissectable, and you don't get to pull back in everything done on the project by claiming some post-project breaches. And I know you understand that argument, but I think there is support in both the law and the documents for making that differentiation. If there is time for my co-counsel, I believe she wanted to address one thing on her aspect.
1 minute.
I just want to very briefly respond to one statement made by Councilor Casser that this contract is the same and we've operated under this contract many, many times. What was different about this contract is, and if you look at those attachments, which are the thing that dictates how compensation is determined, it's written in with an asterisk, time and expense, multiple times in those attachments. That's not the normal way, but that's how this contract was agreed to. That's all I wanted to say.
Thank you. The matter has now been submitted.
Thank you.
We will continue. Thank you, everyone, for your patience. You know, a lot of difficult cases today. We will call item number 9, docket number 373943, Greenwood Lodge LLC v. County of Emmett. This look like appellant's counsel's remote. So whenever you're ready.
May it please the court, your honors, Attorney Stephan Scholl appearing on behalf of the appellants in this matter. Your honors, this is an appeal under Article 6, Section 28 of the Michigan Constitution, which grants appeals of right to circuit courts of final administrative decisions. Section 28, again, refers to review of all final decisions and to determine whether such final decisions are authorized by law and whether the same are supported by competent and material substantial evidence on the whole record. This case involves the applicable appeal deadline, and in which there is no statutory deadline. And so the default is MCR 7.122B, which states that the appeal must be filed within 30 days after certification of the minutes of the board or commission from which appeal is taken, or within 30 days after the board or commission issued its decision in writing, whichever deadline comes first. That court rule MCR 7.122B, C4 also requires that the appellant attach to the claim of appeal a copy of the order and or minutes of the entity from which the appeal is taken. In this case, it is undisputed there is no written order involved, and that the minutes of the January 11, 2024 meeting of the Emmett County Planning Commission were not approved by the Planning Commission and certified by its secretary until its next regular meeting on February 8, 2024. The circuit court erroneously ruled in this case that the zoning administrator had either implied or apparent authority to issue a final written decision on behalf of the Planning Commission outside the scope of all applicable authority governing the Planning Commission's decision-making processes outside of a public meeting, not communicated to appellants, and not disclosed to appellants upon specific inquiry. The trial court's ruling is a fundamental misinterpretation and misapplication of MCR 7.122B, contrary to legislative intent and the rules of statutory construction, and does not comport with minimum procedural due process requirements, should therefore be reversed in the interests of justice and fairness. No one has argued in this case that the Planning Commission issued its decision in writing in this matter at its meeting held on January 11th, therefore starting the 30-day appeal clock. Under its governing ordinance, rules, and bylaws, the Emmett County Planning Commission has no authority to issue written decisions, but rather can only make decisions at public meetings, which decisions become final and appealable only after the approval and certification of its minutes, which then must be made publicly available within 5 days under the Open Meetings Act. Appellees argue, and the circuit court wrongly decided, that the 30-day appeal clock began to run on January 22nd, 2024, when the Emmett County Zoning Administrator, whose only legal authority is to act as Emmett County's liaison to the Planning Commission, mailed a letter to appellee Walnut Lake Country Club and not to any of the appellants or their counsel, advising Walnut Lake Country Club that its zoning application had been approved and enclosing a copy of the Planning Commission's draft unapproved meeting minutes. There's no evidence that the January 22nd letter was authorized by the Planning Commission, that the Planning and Zoning Administrator has any authority to make or issue final appealable written decisions in a case such as this, that the Planning and Zoning Administrator has the authority to act as spokesperson for the Planning Commission, or that the Zoning Administrator has the authority to communicate or issue final appealable written decisions on behalf of the Planning Commission to anyone. By virtue of...
Counsel, what day did your client file the appeal?
I believe the date was March 8th, and the 30 days
2024.
after the February 8th.
2024, correct? Is that correct? March 8th, 2024.
That's correct, Your Honor.
Okay. And then on March 8th, 2024, prior to that, on February 8th, 2024, the notes of the meeting of 1/11/2024 were certified and approved. Is that correct?
That's correct, Your Honor.
And a written notice was sent by the administrator following the vote. The vote takes place on January 11th. A written notice is sent on January 22nd. Or is that correct?
Your Honor, it's been called a notice, but it was mailed only to the applicant and did not notify anyone else, including any of appellants or their counsel, that...
All right, the document that's called a notice, which is the question I asked you, counsel, it was sent on May 22nd, 2024. Is that right?
January 22nd,
Or
Your Honor.
January 22nd, 2024. Okay, all right, thank you.
Appellees argue, and the circuit court wrongly decided, that the 30-day appeal clock began to run on January 22nd, 2024, when the Emmett County Zoning Administrator, whose only legal authority is as Emmett County's liaison to the Planning Commission, mailed a letter to appellee WLCC, Walnut Lake Country Club, and not to any of appellants or their counsel, advising the country club that its zoning application had been approved and enclosing a copy of the Planning Commission's draft unapproved meeting minutes. There's no evidence that the letter was authorized by the Planning Commission or that the zoning administrator had any authority to communicate a final written decision on behalf of the Planning Commission to anyone. According to well-established precedent, where the plain language of a court rule is unambiguous, this court must enforce the meaning expressed without further judicial construction or interpretation. Appellees in the trial court have misconstrued the express language of MCR 7.122B, arguing that the Emmett County Planning and Zoning Administrator provided, quote, written notice, end quote, of the Planning Commission's decision on January 22nd. However, quote, written notice, end quote, of a decision which is not final and appealable does not trigger the running of the court rule's alternate appeal deadline, which is within 30 days after the board or commission issued its decision in writing. As there is no provision in the bylaws of the Emmett County Planning Commission other than by approving its minutes for the Planning Commission to issue decisions in writing, there's no way that the alternate appeal deadline could have been triggered by the mailing of the zoning administrator's January 22nd letter. There is no statutory or other legal authority to support the proposition that the Emmett County Planning Commission issued a final appealable written decision prior to the approval and certification of its January 11th, 2024 meeting minutes on February 8th, 2024. All applicable authority governing the Emmett Planning Commission's decision-making process with respect to special use permit applications provides that the only manner in which the Planning Commission can issue a final appealable written decision is for the Planning Commission to approve and certify the minutes setting forth the Planning Commission's decision, which constitute the official record of the Planning Commission's proceeding. Until its minutes are approved, the Planning Commission retains the absolute right to amend its statement of findings and conclusions relative to a special land use, specifying the basis for the decision and any conditions imposed. No constitutional right to appeal existed in this case prior to the Planning Commission's approval and certification of its minutes. Therefore, under 7.122B, appellant's claim of appeal, which was filed within 29 days after the Planning Commission's approval and certification of its minutes, setting forth its final appealable decision, was timely, and the Circuit Court has subject matter jurisdiction to hear appellant's appeal. The trial court's ruling that the Emmett County Zoning Administrator's January 22nd letter, which is referred to as, quote, formal written notice, end quote, in the trial court's opinion, of the Planning Commission's decision, constitutes the issuance of the Planning Commission's final appealable written decision, flies in the face of a whole host of authority, including the Michigan Zoning Enabling Act, which requires a zoning ordinance to specify the special land uses and activities eligible for approval and the body or official responsible for reviewing and granting the approval. That is the Planning Commission in this instance, not the zoning administrator. Here, the Planning Commission's minutes, including findings and conclusions relative to the special land use specifying the basis for the decision and any conditions imposed, were not approved, final and appealable until the Planning Commission's approval of its minutes on February 8th. Under the Emmett County zoning ordinance, the Planning Commission is the body authorized to approve special land uses, including the amendment of Walloon's previously approved special use permit, which is being challenged in this case, and to review Walloon's site plan. The Emmett County Planning Commission ordinance. Under the Planning Commission ordinance, the County Planning and Zoning Administrator is not a member of the Planning Commission and has no official duties other than to serve as a liaison to the Planning Commission. Under the Michigan Zoning Enabling Act and Section 12 of the Planning Commission ordinance, the Planning Commission is required to adopt bylaws for the transaction of business and keep it a record of its resolutions, transactions, findings, and determinations, which record shall be made available to the public in compliance with the Freedom of Information Act. In accordance with Article 8, Section 2B of the Planning Commission bylaws, the Planning Commission is responsible for reviewing and acting on all special use permits pursuant to the Michigan Zoning Enabling Act and the zoning ordinance. The bylaws of the Emmett County Planning Commission establish the officers of the Planning Commission and their duties and outline the Planning Commission's decision-making procedures. There is no provision in its bylaws, other than by approving its minutes, for even the Planning Commission to issue decisions in writing.
Council, Article 7, Section 5 of the Planning Commission's bylaws identify voting as the method through which decisions are rendered. Specifically, an affirmative vote of a majority of planning commissioners, and that this is, quote, shall be necessary to approve any application or matter before the ECPC, close quote. The Planning Commission met in January. They voted contrary to the position that your clients were seeking, but they voted nonetheless. And on January 22nd, a written notice of that decision was sent out. How is that not in compliance with the statutory duties of the commission? And parenthetically, somebody filed a FOIA request on February 10th, 2024. The county replied on February 21st, 2024. So your clients are aware of everything that is the position of the Planning Commission by February 21st, 2024 at the very latest. And they chose to wait until March 8th, 2024. Why?
Your Honor, the appeal deadline is specifically governed by MCR 7.122B.
Yes.
Which states the appeal must be filed within 30 days after the certification of the minutes, not 30 days after the meeting at which the decision took place.
or when a written decision is issued, correct?
The board
That
or
correct or incorrect?
commission issued its decision in writing, not the zoning administrator. You are interpreting an unambiguous court rule, and which the trial court impermissibly did. It's very clear to me and unambiguous. The board or commission did not issue a decision in writing and has no authority to do so. That planning commission bylaw that you refer to specifically governs the decision-making procedures. And the only way for the planning commission to make a final appealable decision is to certify the minutes, approve and certify the minutes of the meeting at which the decision was made. Until that time, it's nothing more than a preliminary decision and not final and appealable.
The court rule reads specifically as follows, quote, in 7.122, large letter B. An appeal under this rule must be filed within the time prescribed by statute applicable to the appeal period. If no time is specified in the applicable statute, the appeal must be filed within 30 days after certification of the minutes of the board or commission from which the appeal is taken, or within 30 days after the board or commission issued its decision in writing, whichever deadline comes first, period, close quote. If a tribunal were to be convinced that the authorized agent of the planning commission issued a written order memorializing what the decision is, how is that deadline not controlling? Or that date not controlling?
Your Honor, no order was issued. There is no claim that an order was ever issued. There is no claim that the zoning administrator has any authority to issue an order in this case.
Okay. I certainly understand your position.
Your Honor took part in a case, unpublished case, which is Wood Creek of Ann Arbor Association et al. Versus City of Ann Arbor. And that's a 2019 unpublished case. And that decision, this court examined what time limits applied to the filing of plaintiff's appeal of the city council's site plan approval, stating as follows. And this is specifically with respect to MCR 7.122 capital B. And the court stated, there is no statutory provision concerning appeals from a city council's approval of a site plan. Therefore, for the circuit court to have subject matter jurisdiction over plaintiffs' claims, plaintiffs were required to file their appeal within 30 days of the approval of the minutes delineating the city council's approval of the site plan. So the problem in this case, and Your Honor, that is case number 342848 from 2019. The problem in this case is what letter from what administrative assistant, secretary, administrator, someone from a different department, sending out a notice that is not public, that is just mailed to the applicant with no authority whatsoever to do so. This is an extremely unfair burden to put on an appellant trying to read the tea leaves and run around possibly filing numerous FOIA requests, trying to figure out who may have communicated something in writing to someone and thereby starting the appeal deadline. I would contend that that is fundamentally unfair and a violation of procedural due process, especially when the court rule is very unambiguous. Parties, and this is borne out in case law from the state of Michigan and other jurisdictions which I've cited, confirms that parties whose property rights are affected by a zoning decision should be able to readily ascertain when a final appealable written decision has been made in accordance with the administrative decision-making bodies governing statutes, ordinances, bylaws, rules, and procedures. Procedural due process requires clear standards. Fairness requires clear pre-existing standards, either in the local zoning ordinance or court rules or statute, with respect to appeal rights and procedures. And I have cited Davenport versus City of Grosse Pointe Farms, this court, in analyzing prior versions of the applicable court rules, looked to MCR 2.602A, which provides that the date of signing of an order or judgment is the date of entry, and to applicable cases which, quote, evidence an emphasis on the date of formal entry of the order appealed from, unquote. The court stated that, quote, although the issue has not yet been addressed in the context of zoning appeals, we believe that the date of certification of the minutes from the January 27, 1992 meeting most appropriately serves as the date of entry of the order or judgment appealed from. Accordingly, the appeal was timely, end quote. I've also cited, appellees have cited the Zelasco case. And I did not ignore that case, Your Honor. There is no mention or discussion whatsoever of the issue at hand in this case, which is when the clock started to run after the board or commission issues its decision in writing. Only the statement by the court in the Zelasco case that the township board issued its decision granting site plan and special use plan approval on January 25th, 2021. I'm not sure how the decision was issued. It's not indicated whether that was in writing. But I, for that reason, I don't believe Zelasco considered this issue or controls in this case.
I would just point out, counsel, the case you cited that I had the privilege of serving on with Judges Meter and Servito on when we issued our opinion back in 2019. Let's see if I can get the date. No, it's not. Let me just see. Doesn't have the date. At any rate, when it's case 342-848, we were addressing solely, is my understanding, as I read the opinion, I have a vague recollection of this case. It's probably, anyway, it's a couple thousand cases ago, but I have a vague memory of it. But reading the opinion of the court, we were addressing when simply on the written decision aspect of 7.122B, and that it's 30 days from the written decision. And there was not a question of what is a written decision, but what was the date. I understand that our court has issued authority under this court rule, but I'm not entirely sure. I think the case, I think you correctly cite the case, and thank you for bringing it to our attention, but I'm not sure it addresses the sub issue that we've got in this one. But I appreciate you're letting us know about it, particularly in a case that I had the privilege of serving with two very fine judges of our court who are now retired. So thank you.
You're welcome, Your Honor. And obviously, I believe that court was correctly decided for numerous reasons. But again, Your Honor, you discuss when the written decision was issued. And it would be improper.
I agree we did. And these folks, I remember the litigants, the case, I mean, the opinion speaks for itself, but they were about a year later. So it's very different from what we have here timing wise. But the essential thing for me is, I mean, we don't say, and it has to be in this manner, format, or whatever. And I understand your position that what happened on when the person working for the commission sent a letter that does not meet the requirements of 7122B. Period. Stop. We're done. And that the rule we have to measure from is the certification of the vote record. That's my understanding of your position.
That's correct, Your Honor. And I have in my brief pointed to the statutory appeal deadline from a ZBA decision, which I believe is 30 days from the certification of the minutes, or 21 days from the date the decision is signed by the chairperson or members of the ZBA. Your Honor, this is very instructive. I mean, this is very formal and illustrative of the importance of having a fixed and ascertainable date upon which the appeal deadline starts.
Warn you that you're running up on time.
Okay.
So you want to keep any?
In conclusion, upholding the circuit court's decision would effectively deny appellants and others the ability to readily determine when a final written appealable decision has been issued in accordance with applicable statutes, ordinance, bylaws, rules, and procedures, forcing appellants to potentially file numerous FOIA requests after an adverse decision in an attempt to obtain undisclosed, non-public correspondence and other records which could possibly trigger the appeal deadline under MCR 7.122B would be grossly unfair and unjust, potentially result in precious judicial resources being unnecessarily utilized in cases such as this to try and determine what circumstances could possibly constitute the issuance of a written decision of a board or commission, and will constitute an invitation for all quasi-judicial decision makers to engage in gamesmanship, as I believe we have seen in this case, to deprive appellants of their valuable property appeal rights without procedural due process. I would invite the court to follow the law and simply apply the court rule as written. The court should therefore overturn the circuit court's erroneous decision and uphold the rule of law as expressed by MCR 7.122B and the statutes, ordinances, bylaws, rules, and procedures governing the decision-making process of the Emmett County Planning Commission. Thank you, Your Honors.
Thank you.
Thank you, Your Honors. Stephen Jopik on behalf of Emmett County in this case and the Planning Commission. Appreciate the opportunity to speak with the court today. We have fully briefed this matter. I didn't hear much in the argument today besides what was already in the brief submitted by the parties. Although I did hear one case that was not cited, the Ann Arbor case. I don't believe that was cited in any of the briefings in the case. So I'm not prepared to directly address that. I appreciate Judge Redford pulling it up and taking a peek at it. I didn't have that ability here at the time, and it sounds like it is in some degree distinguishable. I do not know if there was an actual issuance of a decision other than minutes in that case. If that is the situation, then it would not be the same set of facts as this case. Here we have a situation where a property owner has applied properly for and obtained all governmental approvals to use and improve its property for its desired purposes. If there's any justice or fairness to be applied to the court's reading and application of the court rules in this case, it should be in favor of the property owner that applied for and received its approvals. But the court need not rely on justice and fairness alone in this case, because the law is in favor of reading the court rule in the manner described in our briefings of the matter. The final decision was indeed at the January date referenced in the argument today and in our briefs. And following that final decision, the zoning administrator, not any employee of the county, not any sort of ambiguous person who is not involved in the process, the zoning administrator, who is at every planning commission meeting and works with the planning commission and is referenced throughout the ordinance, both for site plan approvals and for special use permit approvals as being part of the process. The zoning administrator is within the ambit of the county authorities that are and officials that are undertaking this process of reviewing the applications. Those are in Articles 20 and 21 of the zoning ordinance that has been cited to and referenced in our briefings. It's very clear that the zoning administrator is part of this process. And in fact, the communications from, again, these are non-applicants. These are not parties to the actual application. These are individuals that have other property in the area. Their communications were with the zoning administrator. They seem to accept that the zoning administrator was in fact the person to communicate with and receive communications from on behalf of the Planning Commission.
Is there a reason then why the zoning administrator didn't also send them the letter that he wrote on January 22nd?
Well, first of all, there's no requirement to issue that letter. If one were to think about any sort of license or application that's submitted by anybody, whether it be at the local government level, the county level, the state level, liquor licenses, any sort of thing that is applied for, the issuance of the decision and here the zoning permit saying, yes, you can go forward now, comes from, is sent to the applicant. It's not sent to people that live around the bar or the licensee.
I understand, but you said that they were communicating with the zoning administrator. So at least they've expressed interest in it. And I know oftentimes in local zoning commission, planning commission, those sorts of meetings, you always see the same people there, or you know that these people are really interested in it. So you'd CC them just out of courtesy. With respect to the matter, can I just ask you, when you look at 722 paren 4, it says the applicant must attach to the claim of appeal a copy of the order and or minutes of the officer or entity from which the appeal is taken, or must indicate that there is no such document to attach. Given the fact that there's that or, are you saying that 7.122C4 does not support the appellant's position? Because they could just say that the minutes haven't been approved yet, but we're still going to appeal.
Yes, I am. It's interesting that you note that, Judge Feeney, because in the briefings and even in the argument today, the entirety of 7.122C4 was not read and was not provided. The end does have that or must indicate that there is no such document to attach. And the proper time for filing this appeal was, I believe, February 22nd of 2024, not the March 8th date when it was filed. It was February 22nd, 2024. At that time, it could have been filed in compliance with C4 by indicating that there is no such document to attach. So the appeal still could have been filed in satisfaction of 7.122C4 without the approved minutes or any other document attached to it. And in fact, the appeal could have been filed the day after the Planning Commission made its decision. There is no early exemption to filing an appeal of a decision. The appellants in this case knew what the decision was on the date of the Planning Commission's decision by vote, a majority vote. I believe it was 7-1 of the planning commissioners approving the requested application here. They were in attendance at that meeting, as was their counsel. They could have appealed at any time. Now, I'm not saying that they were required to, but there is a thing recognized in the law that you all recognize as lawyers, actual notice. They have actual notice of this decision. They know it's there. They could have filed at any time. They also knew that the minutes themselves, even if they had been approved at any point in time, they're not mailed out to anybody. Even the applicant doesn't get a copy of the minutes that were approved necessarily. They become publicly available. And how do you get them? You either submit a FOIA, or if the community, and I'm speaking in the broader scope because we are dealing with planning commissions across the state here and ZBAs and how they operate, or if they don't have a website or don't post the minutes on the website, they have to do a FOIA. There's no other way to find out about those minutes. So there would not have been the minutes provided to the appellants or even the applicant in this case, if the minutes had been the only source of the decision being issued in this matter. If we didn't have that letter that was sent out, which isn't labeled a notice, it is a letter, and it says it was approved, and here attached are the conditions upon which it was approved and the decision of the planning commission in this case. And so the property owner did get that information in its hands, and most typically you see a disappointed applicant filing an appeal, right, to circuit court. Here we have others. So there's no obligation to send that letter to others. Where would you draw the line? If you miss somebody, are you violating their due process rights? Well, no, you're not violating anybody's due process rights. You just need to make sure that in that instance where you're issuing the notice or the decision, at least you probably want to get it to the applicant, even though that's not specifically a requirement. That's not stated in 122B either. It doesn't say who that has to be issued to, but it was sent to the applicant here. The appellants knew that they could submit a Freedom of Information Act request to get the information that they wanted. And in fact, they did. They submitted it on a Saturday on February 10 in the morning. It was received on February 12th. And an interesting thing about that Freedom of Information Act request is it's dated January 24th, which was, I'm sorry, January 26th, I believe it was, which was 4 days after the issuance of the decision. So if it had been submitted on the date that it was actually signed, that FOIA request, the information in this letter from Ms. Dornenberg, the zoning administrator, would have been in their hands 2 weeks earlier, actually 15 days earlier. They would have known about it and we wouldn't even be here. So I think any way that the court was to look at this, the opportunity was there. The information was publicly available. It could have been obtained, and it was not in a timely fashion. Now, I want to leave a little bit of time. I believe Mr. Turner also wants to speak. So if there are no questions, I think through the course of the questions that you've been asking, I've made my way through my argument. I know it's been a long docket for you today. If you have any other questions that you're yearning to ask, I'm here to answer them. Otherwise, I will defer over to Mr. Turner.
Any questions?
Thank you very much.
Good afternoon, Your Honors. Jack Turner on behalf of intervening appellee Walden Lake Country Club. I don't have a whole lot to add to what Mr. Jopich has already said. I think, to me, it seems a relatively straightforward interpretation of the court rule 7.122B, which I think is pretty straightforward. And is, I think, what Mr. Jopich mentioned earlier about they could have filed the appeal at any time is a really important consideration here, because I think if they had filed the appeal, say they could have filed at any time within 30 days after the date of the decision. And even if they hadn't have issued the minutes at that point, it still would have been a timely appeal. So they had every opportunity to protect their right to appeal by just filing within that 30-day period of time after the date of the decision.
Is it jurisdictionally an appeal of right at that point?
Yes.
Okay.
And I think this, to me, the court rule reads pretty unambiguously. There's no mention in the court rule of anything like a final decision. There's no mention in the court rule of anything about, the authority of the person sending out the notice.
Yeah, I mean, it reads after the board or commission issued its decision in writing, whichever deadline comes first.
Yeah. And as Mr. Jopich mentioned, I mean, a lot of the appellees or the appellants communicated directly with the zoning administrator during the course of this proceeding. Appellants counsel communicated directly with the zoning administrator during the course of this proceeding. So to say that you can provide information to the zoning administrator, but that the zoning administrator can't transmit information seems a little bit inconsistent to me. I don't really have anything more to add. Again, I think as Mr. Jopish mentioned, we've briefed all this stuff and unless you have any questions, I think I'm all done.
No questions. Thank you.
Your Honors, I don't know if I have any time remaining, but I feel I need to correct.
I believe you have 2 minutes.
Your Honors, I would direct your attention to the record, and this is to follow up on Judge Feeney's comments and all these comments about our failure to communicate with the zoning administrator. I sent the zoning administrator a letter on February 9th, specifically advising that it was our intention to appeal and specifically questioning when the appeal deadline would be and whether or not there was any written decision floating around out there signed by the chair of the planning commission with respect to the above referenced case and asking for confirmation that the minutes were approved at the planning commission's February 8th, 2024 meeting. So I sent this letter on February 9th, which was 2 weeks after this January 22nd letter.
Please, this is a court. Watch. I know it's difficult on video, but the volume is just very loud right here.
I apologize, Your Honor. This letter specifically advises of our intention to appeal and are searching for when the appeal deadline begins and ends. And I asked, please confirm that there has been no decision in writing signed by the chair of the planning commission with respect to the above referenced cases, and that the minutes from the January 11th meeting were approved at the planning commission's February 8th meeting. And then I get a response from counsel for Emmett County not disclosing the January 22nd letter. What are they hiding from me? What kind of gamesmanship is this?
You didn't ask for that.
The
You
last,
asked for, is there a signed letter from the chair of the commission? And you also asked, when does the deadline run? The response of counsel was, we have been instructed by our client and we are not otherwise inclined to tell you what the answer to that question is. I mean, you're asking an opposing party's lawyer for legal advice.
Your Honor,
how are they obligated to respond to that?
Your Honor, we're talking about the government, which is required to provide and afford my clients with procedural due process. And again, to hold that this notice to the applicant, which was never provided or disclosed to my client in response to my request about the appeal deadline?
It was disclosed on February 21st, 2024, correct?
Correct, Your Honor.
Before the deadline.
It was, and that I was asked, did they want me to mail it or did they want me to pick it up? And because I was available, I was able to go to the courthouse and get it the day before the deadline.
Or maybe the day of. Maybe the day of, if they're 29 days in February in the year of 2024.
Was this, they had until March 5th to provide the documents. Why were they provided on February 20th? 2 days before the deadline.
All right,
They could
counsel.
simply-
Thank you. Counsel, the times we've exceeded the
Thank
time.
you, judges.
Thank you. The matter has not been submitted. Thank you, everyone. We'll now call item number 10, docket number 375611, in re guardianship of LNW. Whenever you're ready. Thank you.
Thank you. May I please the court, Michael Cronkrate appearing on behalf of Tara Mathewson, the appellant in this case, who is the mother of LNW. I would like to acknowledge that my client is in the courtroom and has waited patiently, as have we all day, and I thank her for that. This case, if I may just jump in, calls the court to look at the juvenile guardianship code and determine what the standards are and then apply those to the facts of this case, of course, but what the standards are in regards to parenting time. The trial judge correctly stated in his ruling from the bench after a 3-day hearing that from his perspective, the only issue in the case was parenting time. At that time, we were conducting the annual review that the statute requires, but we were also dealing with a motion that my client had filed asking for parenting time under the guardianship code. I think a little bit of backing up and discussion briefly about how we got here and the code
We're
itself.
very familiar with the record. We're familiar that the Court of Appeals reversed the trial judge previously, that there have been continuing hearings, and that the mother has not been given the ability to have time with the minor child. So I think we're fully aware of the facts.
Thank you for that. In regards to the code itself, 712A19A does have a prerequisite, and that is that before you can create this type of guardianship, there needs to be a finding that the guardianship is in the best interest of the child, but there also needs to be a finding under the code that it's not in the best interest of the child to terminate her parental rights. I cited in my brief in Ray TK.
Can I ask a question? Has there been an intervening annual review?
I'm sorry.
Has there been an intervening annual review from the one which is now on appeal?
No, the parties appeared, counsel appeared for an annual review, and the agreement that was made. I don't recall, frankly, if we went on the record, but the agreement after a chambers conference was that we would wait for the outcome of this appeal to see what kind of guidance was forthcoming from the Court of Appeals. Yeah, unfortunately, that's about the only update that I can offer in regards to the predetermination that it was not in the best interest to terminate. I think that follows naturally from the previous Court of Appeals, which I was just told you're familiar with, so I won't go into that. But nonetheless,
nobody is seeking termination at this point, are they?
No.
Okay.
No, and my client has not asked for termination ever of the guardianship. She testified in support
of. No, but no one's seeking termination of mom's parental rights.
Oh, that is correct.
Okay.
That is correct. I raised the issue of in Ray TK because in that case, one of the assertions of the appellant was that the guardianship code itself, the juvenile guardianship code, created a de facto termination. And the court answered strongly after reviewing the due process issues that it didn't do that. But the rationale, I think, is important here. And the rationale was that it's not a de facto termination under the code because the code does not permanently separate parent and child. I will say that that's not the way that it looks to my client after several years of no contact with their child, because it does look like a de facto termination of parental rights. Her testimony was at the hearing was that she entered into this process of the guardianship, thinking that she could continue to work on her own issues and work towards some kind of a reconciliation. The motion that she filed in the court wasn't specific. It didn't make a specific request as to what kind of parenting time she wanted, what kind of step forward she wanted. But she wanted to be moving at least in the right direction, and she was asking for the court for help with that. The testimony of Dr. Hagen in the case laid out a path forward that ultimately was agreed to substantially by the other experts in the three-day hearing that we had. And so the court, in essence, adopted, or at least spoke favorably of, the sort of common agreements amongst the opposing experts, that there was actually a path forward. The court used that phrase, that there was a path forward that was articulated, which the court seemed to endorse just before it ruled that it was going to deny our request entirely and not allow any motion in the direction of any parenting time or even contact. The history of the case is that the court, after the inception of the guardianship put out an additional order that is entitled a nunc-pro-tunc order.
And where did that come from? I mean, if I have put my trial judge hat on for 22 years, I did a lot of juvenile guardianships. And I don't ever remember entering nunc-pro-tunc orders for things. So I'm trying to figure out, was that based upon a request? Was there a motion? Was it because she wasn't having parenting time in the neglect case? What?
It remains a mystery to me as why the court issued such an order. All I can tell you is that I asked for clarification at a subsequent hearing as to what that meant. And the court was very clear that that meant no cards, no gifts, no support, no nothing. You have no contact.
But was there, and did anybody ask for this?
Well, if there was any communication that prompted that, I'm not aware of that. I don't.
Well, hopefully it's not, ex parte communication. But so let me ask this. According to what I read, the last parenting time that she had in the neglect case was on July 31st, 2018. Is that correct?
I wouldn't swear by the date, but I think that sounds right.
All right. But the juvenile guardianship didn't begin until
March 1, 2021.
Yes. Okay. So we'll do that. March 21, 2021. Okay.
So I'm sorry, I don't want to interrupt you.
Oh, no,
Judge
it's
Feeney.
okay. So March 21, 2021. So between the July 8th of 2018 and March of 2021, I thought that your client was having supervised parenting time. But if her last visit was in 2018, that wasn't true. So which was it?
So I think it's sort of a combination, and I think Ms. Shear's brief actually shed some light on that, and I'll give her credit for that. But the issue was that there was a prior to termination, there was a time when parenting time was terminated by the court. So she was,
Well,
there was also a period.
Your client's parental rights were terminated by the trial court, weren't they?
Yeah, so I'm talking about, let's say.
And that was overturned by the Court
She
of
put in,
Appeals.
and again, I'm sorry if I'm talking over you, Judge. She put in a plea. The case went forward. She was in jail at that time for matters related, methamphetamine charges. And when she got out of jail, the court, by the way, the court refused to order parenting time in jail. And then when she got out of jail, she commenced supervised parenting time. There was a period of time where drug drops maybe weren't going well or something. I don't remember the details. It wasn't on the case at that time. But what I do know is that there was a suspension of parenting time and then subsequently a termination of parental rights, then the appeal, then the remand. And sort of that's where I stepped in.
So with the remand then, but that was, let's see, I thought I had that here. So once the case was sent back and the termination was undone, wasn't there a request at that point in time to begin supervised parenting time again?
I honestly don't recall. I mean, I don't recall how long it had been remanded when I came into the case. I know that when I came into the case, there was an expectation that we were moving rapidly towards a second termination hearing.
But that's the whole thing. I'm trying to figure out, I mean, is this, you hate to posit that maybe, certain courts don't like it when we reverse them. And that somehow this was just, okay, well, we're going to just take a second swing at this. We struck out the first time, we're going to go right up to bat again. But then they decided to kind of switch gears and move to guardianship. Because typically.
So I should probably keep my thoughts to myself as to whether this is a court that doesn't like being overturned on that, because I don't have anything to base it on but opinion, and I'm not here to offer that. But I will say that that the history since then seems to be a repeat of the same reaction to parenting time from the court.
Okay, but so was it what the timing? Because like I said, I apologize. Was the timing that when it came back from the remand, and was a new supplemental petition then subsequently filed so that there would be essentially no request for parenting time because you'd be facing another termination petition right away? Or was there just the case reopens and you just pick up where you left off and you have another review hearing or a permanency planning hearing?
Well, going from memory, what I can recall that once I got involved in the case, the court itself initiated a conversation, probably on the record, wanting to know whether my client would entertain a juvenile guardianship as a way of settling the case. So that happened soon after my appearance in the case. I think that I had probably appeared for a pretrial, and at the next court event, that conversation was initiated by the court. And of course, naturally, I took that to my client, and ultimately, there was an agreement that she would go for an adoption. I'm sorry, for a juvenile guardianship.
Yes, which she still retains her rights. So at that point in time, there was no parenting time, according to your recollection.
Well, I don't think that that was clear to my client, but as of the non-pro-tunc order, there was no parenting time. And
because that came pretty quickly thereafter. All right. And so that plus the testimony, can I ask why it took over a year? She made her petition for this, I think it was in March of 2023. Or was it? It was in 2023 and didn't get a response on the motion until 2025. I mean, people.
2025 or?
It took over a year.
It did.
It's over a year, right?
Yes. But I thought it went from December and then of 2023. Then in March of 2024, you guys started, and it finished in May of 2025 or March of 2025. I'm sorry. I had a busy docket. I could fit people in to not take a year for a parenting time request that took from December to March to even get in the first time.
yeah, and it was actually, that period of time was for the annual review as well, because that's essentially what was going on.
But there's nothing that says you have to wait for the annual review. You have a motion on your docket that says this person wants to do this with respect to the juvenile guardianships. Juvenile guardianships are just like anything else, right? You know, the juvenile guardian can apply to end it. The parent can apply to end it. There's all sorts of different things that can go on with these things, but there's nothing that says, oh, nope, you can only make decisions once a year. And if you blow it on that day, or you have to adjourn for discovery or whatever, you have to wait another year. That scares me because of the trial court's findings that, well, not this year, but maybe next year, maybe the year after that, without anything that was consistent with 3 different people saying, yeah, we need to repair relationships here, starting with the relationship with mom and grandma, the guardian. So what, from your perspective, why didn't the court at least order that to happen?
Judge, in the first place, don't want to just throw the judge under the bus, because there were multiple factors that were going on. And I should have charted out the history in anticipation that you would ask that question, or that somebody would, and apologize, but I didn't. But the time period, I think, had to, between the commencement of the hearing and then the resumption of the hearing, which is substantial. I don't think it's fair to say that that's the judge's fault or the docket's fault. I don't recall all of the details just sitting here. If someone refresh my memory, probably if I ask my client, she knows it intimately. But the reality is that there were reasons that were, I think my client had some health issues, and it may have been that when the docket came up once, that it was scheduled and I was in the middle of an extensive trial elsewhere. That seems to be consistent, that I had to adjourn for my own schedule, because I think I was doing a shaken baby syndrome murder trial or something like that in another county. So it's unfortunate. It's not all the court's fault. I'd like to say maybe.
May I ask a question along
Yes.
those lines? Was there any court order, case management order, or any other statement by the trial court that you or anybody else who was representing mom did not have the ability to bring a motion and ask for a hearing?
That my client essentially didn't have the ability to.
That did the courts, and if you felt it was necessary to do so, and your client felt it was necessary to do so, 3 months into this year, when you're awaiting, not while it's on appeal, I understand everybody's apparently decided to wait until they hear from this court, but before the decision was made, which is now the subject of the appeal, were you able to still, did you have access to the court? Or did your client have access to the court to say, hey, I want to revisit this? Is there any reason you couldn't have done that? And I'm not criticizing you. I'm just saying, I would like to know.
So I'm having some difficulty following your question, Judge, but I
Okay.
think that you're asking me is could I have just filed a motion to expedite the proceedings or something?
Or I want a status conference, whatever. I mean, could you have gotten into the court to have this matter moved up on the docket, or at least asked for it to be moved up?
Between the commencement and the resumption, is that what you're asking, or?
At any time?
Well, certainly there was, in the first instance, when we filed our motion, the court was disinclined to hear the motion on the theory that under the statute, this had to be heard in commencement with an annual review. And so that constraint was on the parties, that the court was only going to hear this at an annual review. And I think that that caused some delays in the proceedings. So beyond that, I think the court is always available for me to file a motion and ask to expedite and that kind of thing. I think if the question is procedurally, could I have filed a motion for an emergency hearing or anything like that, I think clearly I could have done that.
Thank you.
I know that you did file your motion of reconsideration and included the licensing violations by Miss Ledden, who was the main witness, the only witness who had testified with respect to meeting with the child. Is that correct?
Yes, that is correct. That was information that we weren't aware of when she was testifying, but it came to light later.
But there was an administrative complaint filed by her about her on March 21, 2024 with, looks like Laura, licensing and regulation, having violated 1, 2, 3, 4, 5 sections of the Public Health Code, which is under MCL 333.1101. And they stipulated there was a disciplinary subcommittee consent order and that the allegations fact contained in the complaint were true and respondent violated 2 sections of the Public Health Code and was placed on probation for 6 months. Was she testifying at the time that she was on probation and didn't disclose this?
I don't recall looking at the dates, but I think that the answer is yes. But again, I would have to go back and compare dates from what I filed and the hearing dates. She only testified on 1 day, so.
Yeah, well, and she testified to 2 different things. One that she, I believe, informed your client that it was her moral obligation to terminate her parental rights so the grandmother could adopt, correct?
I think it was moral, ethical, and legal obligation.
Yes.
When was that statement made?
During her testimony within the 3-day hearing. So I think it was on day 3 of the hearing.
Post remand from the Court of Appeals?
Yes.
Good.
Yeah, she was strongly advocating that my client would give up her parental rights in favor of an adoption.
And there was one other thing that she said, with respect to the child, and I apologize. And she was the only one, she asked the child, what event in your life, because she stopped seeing the child fairly early on, like in 2020, I think it was, but then would see her periodically and then saw her in a couple months before the last day. December 6th of 2024 was her last visit. She asked the child.
Who is she?
I'm sorry, Miss Ledden, the counselor, asked the child, anything in your life cause you stress? Because apparently this is a very intelligent, put together, great student, athlete, you know what I mean? Great things about this child. What causes her stress? And the child said to the effect that it would cause me stress to think that I would never see my parents again, my bio parents again. She testified to that as well.
My recollection, that was at one of the recent counseling sessions in 2023 that the child said that.
Okay, all right. But there was no testimony that anybody's explained to the child that she can maintain a juvenile guardianship while still having like supervised visitation or visitation with her bio mom, correct?
And I apologize, Judge, but I'm a little bit hearing impaired and I thought I was
Oh,
going to
I'm
be good.
sorry. Let me slow down. I talk fast. No one has ever explained to this child, including Miss Ledden, that the child can continue in the juvenile guardianship, even if the child has parenting time with her mother, her biological mother, correct?
I don't know of anybody that explained to the child. Obviously, I don't have access to the child.
Okay, but there was no testimony to that.
Correct.
And there was no testimony that somebody even asked the child, do you want to see your mom?
That's true.
So everybody's just waiting for this child to say, I want to see my mom.
That's also, well, not everybody. The judge
Oh.
is and Ms. Layden is.
Okay. And has any counseling between the mother and the guardian started? Or, oh, it has?
It has.
Good. Okay.
When did that start?
Well, it's occurred periodically prior to that hearing, but since the hearing and with the judge's encouragement, a counselor was selected and there has been an engagement in that.
Okay. But everybody's waiting for this child to, on her own, say, I want to see my mother.
Yeah, and of course, one of the things that I said in the brief is essentially what more do we have to do? That we have this counselor who is opposed to any parenting time reporting that the child is self-reporting that it's a stressor.
To not see her mother.
To not see my mother. We have no evidence that she has ever said anything negative about her mother, or she's not resistant. In some of the case law that we've seen on juvenile guardianships, the child was resistant to seeing the parent. Nothing like that. There's no evidence like that. So there's no resistance on her part. She is a model juvenile, and as the court indicated, just doing amazing. She's reported to be emotionally stable and intelligent and articulate. The mother had expressed in her testimony the fear that the child will start asking questions because she's very smart. And I suppose that's true. That's what smart children do. They ask a lot of questions. And the mother was like expressing her fear of that. So you have the counselor expressing in her testimony that she had a fear that mom might do something inappropriate, something non-specific if she had parenting time.
But that's what supervised parenting time is for.
Yeah, and I agree. And you have grandmother expressing the fear that if we do allow this process, that the child's going to start asking questions that I don't want to have to answer. And that was in her testimony. But I don't know, and then you have the big picture, frankly, that there's no articulable application of any standards.
That was the question I wanted to ask both of you. And I'll ask the council as well. Why in the juvenile guardianship context should the court not apply the analysis required in parenting time motions, in a custody motion, a best interest proceeding, or a child protective proceedings? I live my life by 12 best interest factors, by 14 property division factors under 722.27A, I believe it is, or B. It's the parenting time considerations that are under the statute. Why all of a sudden, because we've granted a juvenile guardianship, do all of those just disappear? And it becomes, we'll wait for the child to tell us.
Well, I think the best answer, frankly, is according to Michigan Supreme Court in 2014, you don't abandon those things. The court in Ray COH, the Michigan Supreme Court, Judge Kavanaugh decision said that depending on the circumstances, a case may more reasonably lend itself to application of the Custody Act factors or some combination of adoption code and child custody factors, or a unique set of factors developed by the trial court for particular purposes in a particular case.
But the judge here said, I'm not going to use the child custody factors specifically.
I'm sorry?
The judge here specifically said, I will not apply the child custody factors. Granted, it's a best interest analysis, but there's a best interest analysis, all sorts of them. Olive Metz for child protective proceedings and all the rest of them. I went through those constantly. So I'm trying to figure out why there was no form to the court's analysis of best interest anywhere.
Yeah, so I think the case law supports the notion that because the way the statute is written, that the judge has discretion of using any of the available standards or even creating one. I think that that's what the Supreme Court said. Instead, I think what we have is no standard. It's really hard to review this case even as to applying a standard to the facts in the case because there's no articulable standard here. I think that that the Supreme Court has mandated and NRCOH that some standard needs to be used and it needs to be articulated, and we don't have that in this case, and it's very frustrating. I think also if we look at the facts of the case, I think we see that the ruling of the court, the best interest of the ruling is just factually inconsistent in numerous ways where the application of the facts to a standard, should it exist, is difficult to follow. For example, Ms. Layden talked about her own four-step process, how she would work reunification. And the first two steps are already completed. For example, the example that Judge Feeney just raised, which was that the child raised the concept herself of meeting with her mom or not meeting with her mom. That was followed up with the counselor. And I don't know how much time I have because I've lost
a couple, 3 minutes.
That was followed up with the counselor and measured the result, which was her second step, and found that the child handled that extremely well. And even that meeting ended well. So there's no negative here other than the feelings of the adults. And I guess I should include the court in that. The only resistance to parenting time in this case is coming from the adults. It's not coming from the child. And one last point, and that is if you look at a parenting factor and then say, I'm not going to consider the interaction of the adults in this, it's convenient then that you get to repeat the mistake of the prior Court of Appeals and not give my client any credit for the amazing recovery and improvement that she's made in life. But what child support, what best interest analysis puts blinders on and refuses to consider the adults in the equation? It's always looking at both the child side and the adult side and every factor that you would rely on. Only in this case, the court didn't even give honorable mention except after the ruling was made where he said, keep up the good work to my client. He didn't give any honorable mention to any of the improvements in the life that she's made. That's not how best interest factors are applied. I don't think you forget the adults and just put tunnel vision on and look only at the child's life. But in any event, we have no standards that we can examine in this case, even though it's pretty clear to me that the Supreme Court requires that. If I have any time left, I'll reserve for rebuttal.
1 minute. Yeah.
Thank you.
Sorry.
Good afternoon, Your Honors. Lori Shear appearing on behalf of the appellees here. Judge Feeney, I've listened to some of the questions that you've asked as well. In this matter, just for some clarification on some of the facts, the child has been placed with the guardian since January 23rd of 2018. As your honors are well aware, there was a termination and appeal. It was remanded. The last contact between the minor child and the mother was on July 31st of 2018. There was an official order entered on 9/4 of 18. I believe it was at a review hearing. I was not involved in the case at that time, but from a review of the records, I believe it was 9/4 of 18. The official denial of continued parenting time was entered. But again, there had been no contact from July 31st of 18.
Was that while the NA case was still going on? Okay, yeah, because you ended the guardianship orders. We usually wait to have another hearing and then we dismiss the NA case and the guardianship keeps going on. So
Yes, the guardianship case, excuse me, Your Honor, the abuse neglect case was going on still in 2018. The termination happened. So there was no time during the appeal.
okay, yes, you're right. You're right.
Yes.
I
And
can
then
think of it
when
afterwards.
When it got remanded, I apologize. I don't know exactly what date it got remanded. But it was my understanding, again, I was not involved. This is simply from a review of the records. I was not involved at that time. It's my understanding that the NA case was just reopened. I don't believe that there was a supplemental petition filed. I didn't see one. I'm not saying it doesn't exist, but I don't think there was, I think when it was remanded, it just kind of picked up and continued with a case services plan.
But then the case service plan would have a supervised parenting time because she had that before.
Well, it was denied September 4th.
Yeah, because termination was coming up.
Yes.
So that's a different situation because we're not going to have parenting time because we're going to go to termination. It'll be too hard for the child. But now termination's been reversed and you're back. So why wouldn't people be going parenting time?
Yes, and that I cannot speak to again, Your Honor. I was not involved at that time, but it's my understanding that parenting time was not reinstated for whatever reason during that remand period. And then again, my review of the record is that it was coming up where things were not going they weren't going great to the point of reunification. So then the idea of a juvenile guardianship came up, and that is what was put into effect on March 1st of 2021. And again, there had been no parenting time ordered, from my understanding, up to that point in time when the juvenile guardianship was put in place. Addressing the parenting time under the juvenile guardianship, I believe under 712A.19A13, I believe that the only time, my understanding and interpretation of that is the only time that parenting time can be requested in a juvenile guardianship is at the review hearing.
I don't read it that way. Can you help me out with how you see that? Because I used to have motions all the time with juvenile guardians. I've got it right here on 13 or 14.
13, Your Honor.
Okay, I've got 14 here. Let me see where 13 is, if I got that too. Because 14 says, in making the determinations under this section, the court shall consider written or oral information concerning the child from the child's parent, guardian, custodian, blah, blah, blah. In addition to any other evidence, comma, including the appropriateness of parenting time, comma, offered at the hearing. So that's just saying, these are the things we consider at the hearing, not you can only decide these things at a hearing on a review of a juvenile guardian.
I believe it was under 13, Your Honor, and I don't have that.
Looking for it.
That fourth in front of me. I apologize.
And I apologize. I've got briefs and I'm trying to find it in the briefs. So anyway, so you think that 13 requires you to only talk about things at the hearings, and I was just mistaken in my practice.
I believed, Your Honor, that it was under 13, parenting time was to be addressed only at the review hearing specifically in a juvenile guardianship. And Your Honor, we had went through, and I know that the court had asked some questions about why this took so long. There was a petition filed in November of 21 asking for some sort of contact or parenting time by the appellant at that time. For reasons unknown, that was withdrawn 2 days before the hearing was set. The appellant through counsel withdrew that request. Actually, it was February of 2023. This case has unfortunately gone on for quite some time. So the original request for appropriate contact or parenting time was filed by the appellant through the juvenile guardianship, again, November of 2021. The parties, including the guardian ad litem, agreed to have Dr. Hogan conduct a psychological evaluation. There were some other things going on. The parties were not able to reach agreement. So a hearing was set for February 17th of 2023 on the original filing from November of 2021. 2 days before, I believe it was on February 15th of 2023, the petition was withdrawn, again, for reasons unknown. It was just withdrawn by the petitioner and it was taken off the court's calendar. This matter now that is before your honors, again, it was a renewed motion for appropriate contact or parenting time was filed in August of 2023 and then was not scheduled until March of 2024. And then due to some health issues of the appellant, a funeral I know that that I had in the middle of some of the days because we were scheduling 3 days at a time. And I believe, as Mr. Cronkite touched, some scheduling conflicts with attorneys' schedules. It did not conclude, unfortunately, until March of 2025, after 3 days, approximately 3 days of testimony. So,
And I want to go back to
Yes.
your, I just looked at the statute 712A.19A. It says you really can't cancel or delay the permanency planning hearing beyond the number of months required, blah, blah, blah. But it doesn't say that you can only look at parenting time at the hearing. It says that when you have the review hearings, you, under 14, the court shall consider written or oral information concerning the child from the parent, guardian, custodian, foster parent, child caring institution, relative with whom the child is placed or guardian, in addition to any other evidence, including the appropriateness of parenting time offered at the hearing. Nothing there says that's the only time that you can do this.
well, Your Honor, in I guess there was no other I mean, there was, there was a request filed in November of 21, withdrawn in 23, and then refiled in 23 and was actively, I guess, before the court. And by, I guess, stipulation of the parties, was set out for various reasons, or the other stipulations of the parties and the court.
Can you talk about the non-proton order? Because I'm sorry. Where did it come from?
Yeah, again, that was before my time, Your Honor. I know that the position, from my understanding, again, of review of the record, was that there was no contact of any nature.
But I mean, I'm trying to figure out why, because already her last contact was in 2018. It went up on appeal. They said you shouldn't have terminated. It came back again. No parenting time, but they're going to go to juvenile guardianship. There was no testimony that said that mom was doing poorly, that she was relapsing. There was no testimony that mom was doing great. She's actually becoming a parent support partner and helping other people through their addiction. There was no testimony, period. And courts typically do not just go out of thin air and decide, I'm going to enter an order in this case that just came back from the Court of Appeals to say no contact whatsoever.
Yes, and again, Your Honor, I was not involved in the case. I didn't get this until November of 2021 when the petition was filed for appropriate contact.
Okay. And then can you address, go ahead.
Ms. Hopkinson. Go ahead.
Oh, can you address briefly the fact with Ms. Ledden? So it sounds like when she was testifying in 2024 and 2025, she had been censured. Is that the right term of it? She had been found responsible for licensing violations, was placed on probation and had to pay a fine and all the rest of that. Did anybody ever ask her, or did she ever say, oh, by the way, Laura has sanctioned me?
No, there was an order issued, and again, I don't recall the dates. It's my understanding there was a case that was going, there was a person, therapist involved. It's an office with multiple therapists that she's involved in. There was a therapist that was alleged to, and I believe convicted, if I recall correctly, of having an inappropriate relationship with a client. The police came in and raided, again, this is my understanding from reading the order, or the stipulation of censure or punishment, that she had come in, or the state police had come in, raided, this person was arrested, and then the other therapist, again, my understanding was they were reprimanded for not reporting. They only learned about it, from my understanding, they learned about it when they came in and raided. So
then, I mean, she agreed to it. She agreed to the disciplinary action.
Yes, I believe it was a stipulated order.
Which is very odd. So, and, I took note of the fact that when she said that basically, mom had a moral legal obligation to terminate her rights. And yet she was the one who was supposed to be giving us non-biased information with respect to this child.
Your Honor, she had started in, I believe it was September of 18, and she was sought out, I believe, by that point. That was during the first abuse neglect case. And I believe the Department of Health and Human Services contracted her services to counsel with the child. So she's been the child's therapist since September of 18, shortly. I mean, well, it was January, she was put in care. So about 8 months after the child was put into therapy with her, during the 2018 case leading up, it might have probably bled into 2019. It was her opinion that termination was appropriate. It had been her opinion at that point based on her meetings with the mother and based on her review of the file and meeting with the child.
So did anybody ask her then, and I didn't see it in the transcript, anybody ask her at this hearing, is that still her opinion?
I don't believe anybody did ask her that, Your Honor. I don't believe that anybody did. Now, touching on that, where it has to be child-led, I believe that she clarified, because she did say that was a source of stress for the child, and they talked about it, and then I believe the child kind of shut down after that. But when she was asked further, I apologize, just had it marked. Well, the child is very mature. Ms. Leeden's testimony at the hearing on March 18th of 25. Well, the child is very mature and very intelligent. She is not quite emotionally there yet. And she believed that any contact at the time, no matter how minimal, could be harmful or detrimental to the child. And I'm sorry, Your Honor.
No, it's okay. I remember it could be. So it was all the speculation piece.
Yes,
Okay.
and she did indicate when she was asked about contact being initiated by the appellant, whether it would be a birthday card, a phone call, or a gift, she did answer that there would be concerns because it kind of should be led by the child. Now, and maybe that interpretation, maybe it's used a little bit more loosely. However, they want to make sure she is ready. Not, I don't take that as well. The child has to ask to see her. There was testimony from the guardian that there are pictures of the appellant up in their home still. It's the guardian. The guardians are the mother and stepfather of the appellant. Her pictures are still up in the house. The children, they've adopted other children. They're very open about that. And let the children, they know they're a safe space to go to the guardians and ask questions. I don't think it's that, oh, well, we don't want to answer uncomfortable questions. But if the child asks, then certainly that is something. It's just been so long since she's had contact. I mean, not that couldn't be initiated in therapy as far as how does, what do you think about that? And I don't think that is the thought, because I believe Ms. Leeden, if I recall correctly, said at some point there's going to be contact. And I think all of the experts agreed with that. At some point in her life, she's going to have contact with mom.
But it's almost like everybody wants to wait till she's 14, 15, 16, when things start getting dicey and, it's really hard to raise kids then. That was the sort of conversation. But it seems silly that we have to wait until then and put all this on a child's shoulders, because then it becomes, is the child having to pick between guardians and mom? And that shouldn't be the case. That's why we have best interest factors. That's why we have parenting time factors. So let me go to my question that I asked counsel. All right, why in the juvenile guardianship context should the court not apply the analysis required in the parenting time motions, custody motions, best interest proceedings, or child protective proceedings?
Well, I don't think that it can't, but I think looking at in raid COH, which was a Supreme Court decision, the statute requires the court to base its decision on the child's best interests and grants it discretion on how to determine those best interests, because again, it should be child focused and not adult focused.
But that's the same thing that we have.
Can I ask a question? Does the legislature specifically articulate in other areas of the juvenile code specifically where the factors and what factors have to be considered? Are there examples of that?
I don't believe so. I believe that it's really a discretionary thing with. the
So
court.
whether it's, okay, so if a trial court has to decide, is it in the best interest, who supports the religious? These are the things I'm talking about. That you're saying that is not statutorily based?
No, those are statutorily based.
Right,
Yes.
right. So when the legislature wants to require the judiciary to do a specific act as relates to children, it has certainly spoken loud and clear, and so have we and our Supreme Court on how they should be done, correct?
Correct.
There is no such statute which requires that in a guardianship situation. Is that correct?
I believe so in a juvenile guardianship, Your Honor. I
There's-
believe that there is not.
The court has to do their, okay. Thank you.
You're welcome. And like I said, I believe, and I think, Mr. Cronkite touched on that where, we don't look at it in a vacuum and have blinders on and only look at the child. We look at the adult. But again, I think the case law is pretty clear. And again, I believe that was in COH, that in Ray COH, that the Michigan Supreme Court expressly cautioned against focusing on what is quote unquote fair to an adult rather than what's in the child's best interest. So, well, positive changes in any parent's life should be commended. And we would hope for that for every parent. I think that this has got to be a child-centered and child-focused analysis as opposed to mom is ready or mom has done all these improvements. Because again, the issue with that is that's a little more, I guess, subjective as far as if there are agreements or disagreements as far as the improvements. And again, parents should be commended for making those improvements and those changes. But again, I think we can't lose sight of it's not about what's best for the appellant or the parents. It's what's the child center and child focus, what's best for the child and in the child's best interests. So again, I won't belabor all of the things. I know your honors have read the briefs and are very apprised of both positions here. But again, looking at all of the factors here, again, it is not tantamount to a termination. But again, a court's obligation is not to craft the most fair outcome for adults. It is to protect the child's welfare and stability. And again, in this matter, I think that is what is being looked at. We have a therapist that has worked with this child now for almost 8 years. And again, was brought into this through an abuse neglect situation. There has been no contact between the child and the mother, working also on 8 years this month. And again, I think that the focus again has to be what is best for the child and what is in her best interests in this matter. And if the court has any additional questions, then I would be happy to answer those.
Thank you for answering all the ones you have.
Thank
Thank
you.
you. And then 1 minute.
I just want to say that this idea that there's a ticking time bomb here is pretty compelling, because when I made in my argument, my closing argument, that we can't just take a wait and see approach to this case, the judge specifically agreed with me in his ruling that we can't just wait and see, because we have this idea that we're going to get into the teenagers and there's going to be maybe some tumultuous emotions and so forth. That's not a good time to be doing this. The court agreed with me on that and then just gave no relief whatsoever to my client. I find that very troubling. And I want to say one last thing is that the legislature could have put factors in place. They didn't, but the Supreme Court said it's now the job of the trial judge to do that. And if you don't like the adoption code or you don't like the custody code, then come up with your own standard. You have discretion to do that. What the court didn't have discretion to do is to use no standard at all. Thank you very much.
Thank you.
Thank you
Thank you.
both. Appreciate it.
You ready to begin? No problem.
Yeah.
All right, the matter has now been submitted. We have one last case for the day, item number 11, docket number 366-482, Ecker v. Ecker Nickel. We've
There we go.
Helen, person, whenever you are ready.
Thank you, Your Honors. My name is Karen Ecker Nickel, and I am the defendant and the appellant in this case. And I know you've read the brief, so I'm going to try to just hit some things that stuck out for me and try to simplify it instead of stating the cases which are in my documents, because I have so many, I probably couldn't tell you what name went with which one at this point. The first thing I'd like to address is my removal as trustee by default. For Chapter 5 of the court rules, MCR 5.501C states that trust proceedings, which removing a trustee is, those are commenced with a petition. Now, that doesn't seem like it would be a big thing, and if the court followed the rules of petitions, it wouldn't have been a big thing. However, MCR 5.119B gives the party objecting to the petition, which should have been filed instead of a complaint, the right to object through the first hearing, not be defaulted before the first hearing. So the default form was put in before the first hearing, and the judge never turned that around, even though I was present at the first hearing with an attorney and objected to what they were doing. So she never turned that around. Now, for a long time, I didn't know why I was removed, but there was a hearing on April 10th of 2023 that I had found a case in Pennsylvania that.
You knew that the case, you knew about the case 2 weeks before the complaint was filed. You received personal service of the complaint and you chose not to respond.
No,
So
it wasn't a matter of.
Lack a meaningful opportunity.
It wasn't a choice of not to respond. It was during COVID and I couldn't find an attorney. And not only that, the one we did find ended up being in over his head and he quit. So it wasn't a matter of choosing not to respond, but the fact is probate proceedings for trust proceedings gives you through the first hearing. So we don't want attorneys using court rules to game the system and cheating the other side out of their due process rights, which that cheated me out of a due process right of having a proper evidentiary hearing at a meaningful time and in a meaningful manner. I never had that. That's a violation of my due process rights. Now, had the court noticed this and said, file your document, she got notice, but she has through the first hearing to respond. If they had treated it like a petition for a trust, that would have not been a big deal, but they didn't. And the court said on April 10th, I removed you because you didn't respond to the complaint. I removed you because of the default. Had you responded, I wouldn't have removed you. So she did in fact go by the wrong court rule and removed me because of the default. So that's one of the main things I wanted to point out is we shouldn't encourage attorneys to pick wrong court rules to game the system. If they figure out, maybe somebody else won't figure it out. We don't know if it's accidental or on purpose. I don't know, but attorneys especially, and judges, I would think, are supposed to know the court rules. And they should be following them, especially when they cause harm to someone because they're not. So that's all I have to say about that. Now, I will say there is something that I noticed on the order that It didn't really mean a whole lot to me at first, but now it does. The footnote at the bottom of the order following the bench trial, there's several orders following the bench trial, but this is the order that was entered on May 25th of 2023 that has several judgments against me and against the trust. At the bottom, footnote 1, it says, the parties stipulated that all assets of the Joyce Ecker Trust and the Mark Ecker Trust are now owned by the Mark Ecker Trust, and that the provisions of the Mark Ecker Trust control. Based upon that stipulation, reference to the trust are to the Mark Ecker Trust and shall only include the Joyce Ecker Trust if and to the extent necessary to effectuate the court's order. There was never a stipulation to that. You're going to have to look through 4 days of trial. It's not there. What the suggestion was just to say Mark Ecker Trust. So you didn't have to say the Mark Ecker Trust and the Joyce Ecker Trust. I was representing myself at the hearing. I never stipulated to that. It didn't come up as a stipulation. Now that might not seem important either, but as it turns out, the trustee has used that to take away a $50,000 required reduction in one of the beneficiaries' share. So it's very, very important. The next thing that I would like to address is the section 4.4 of the trust. And I did a supplemental document based on evidence that was pertinent to this case. And I also, everything that I'm telling you was in that supplemental document. Now, what happened in this case isn't how this case has been portrayed. I was trustee initially, and my two brothers wanted to control the trust. And it started within days of the proceedings. In fact, on February 11th, I got a text from one of my brothers, and all the texts are on the record. I turned them in as an attachment, although I was not allowed to defend against anything in the complaint because of the default. I turned those in, so they are on the record. There's a text from my younger brother saying, maybe you can cool Scott down if you make some distributions, basically. Give each of us 6,000, give him 3,000. He doesn't have to know. And then in a few weeks, give him another 3,000, and every so often distribute monies that way. My father died January 29th of 2019. I got this text February 11th of 2019. Already asking for distributions. The funeral was February 6th. I had brothers coming to the house, the older one, sitting across the table from me, which was 3 feet wide. I was opening stacks of mail that were over a foot high and questioning everything I did. Why are you doing that? Well, why aren't you doing it that way? And it went on. And then a text, I'm coming back tomorrow. I'm coming back tomorrow. I can guarantee you if someone sat across from your desk while you're looking at these files and questioned everything you did, it wouldn't set well. And it didn't set well with me. I tried to give them other jobs. There were demands through those text messages for distributions. Distribute the timber money directly to us. I said, I can't. It has to go through the trust. That didn't stop. More demands. Demands from the older one, demands from the younger one. The younger one, are you selling the stocks like I said? Thought he could tell me how to sell the stocks. Have you sold the stocks yet? The stocks were individual. I had to change them out of being individually owned. There was over 60 of them. I had to call every company. Some of them didn't even call back for 4 days and didn't get the papers to me for lengths of time. And when I got them, it was a 1.5 foot high stack of paperwork just to start the process. But I kept getting these texts. And then at 6 months, have you done the 6 months accounting? There's no 6 months accounting at that point. It's a year. Then I was getting quoted with stuff out of the Michigan Trust Code. If you don't sell the stocks, you might be liable to us. You be careful. Have you sold the stocks I've asked you to sell? Then I get one. Now, this happened September 22nd from the younger brother.
Is this in the record?
Yes, it is. So all of those text messages are all on the record. From the younger one, are you going to make me a distribution? I crossed the amount out, but I wrote it on the paper of at least, it was over 100,000. This before the end of the month. That was a week. And if you're not going to make a distribution, I want 100,000 loan from the trust. Now, this is the one that was supposed to have their share reduced by 100,000. I wrote back, they're not even in my name yet. I can't make distributions of this. So no, basically, no, this isn't going to happen. I got a letter from their attorney that was dated October 8th. They didn't like that they couldn't control what was happening, and it's obvious in the text messages. So they didn't start because they were not, that I was doing something to breach the trust. They started out of wanting to control this. In fact, the oldest brother, and this is in the record, stated to my sister, and I questioned him about it, this was on May 10th of 2019. I don't want Karen to be trustee forever, do you? So I asked him on the record, why did you say that? His answer was, because I thought that. Now, beneficiaries don't choose trustees. Settlers choose trustees. There was an effort. I learned about it within days, which is why the email said, maybe you can cool Scott down on February 11th. They were trying to remove me as trustee before I even had a chance to even be trustee. Now, the reason I'm pointing this out is I know that you have a de novo review of the trust. And section 4.4 exhibit B of this trust is very explicit. If you ask for distributions and basically, I'm rewording this, but give somebody a problem because they're not giving you a distribution, that's not okay. If you threaten, if you are interested in or conspire with someone else to do anything, any of these things, you cannot remove, select, or become a trustee, and you're done as a beneficiary. Now, one of the attorneys started to try to bring this issue up, that these things were going on before any litigation started, and they were shut down. The judge didn't want to hear the arguments. It got worse. So the letter that I got, one of the main big things in the letter that I got on October 8th was they were concerned about the unexecuted amendments. I sent in a letter, if Greg wants that, if he doesn't want the unexecuted amendments, I'll disregard them. But he has to understand, basically, that makes it so he has to follow the trust, which gives him 100,000 less than the rest of us. But if that's what he wants, don't waste your money litigating. I'll just disregard them. They started litigation anyway and included those two amendments that I had said, let's disregard them and avoid litigation on that. And they included them because they wanted to use them against me to remove me as trustee. And what was basically their fabrication? That I drafted them after my father died. They had no evidence of that. That's not what happened.
I thought the amendment wasn't signed.
No, that's why unexecuted.
Yeah.
Yes.
But you shouldn't.
I didn't sign it.
An unexecuted amendment.
Right. So what had happened is I knew it gave Greg an equal share. The rest of the stuff in that was basically clarification of what's in the trust, clarification of what Dad meant by preservation. There's $200,000 in each trust that it's supposed to be set aside for preservation. That was supposed to be out of each trust, not out of just one trust, for a total of 400,000. The rest of the terms in that were clarification. Dad talked about setting monies aside, 200,000 from each trust, like I say, but it wasn't clear to help make a preservation out of the property and then do maintenance on it as well, which disinherited the grandkids. He didn't want the grandkids getting the properties. He wanted us to make our own preservation is what he wanted. And he didn't want the grandkids getting it because one family doesn't even really know the grandkids. They never came to visit him. And he was the old fashioned kind, who said, if you don't earn it, you don't get it. And but he bought the properties wanting to preserve them for farm and nature purposes. So he wanted me as trustee to make sure that that got carried out. So those were the rest of the provisions in the trust. I'll tell you, I knew that the amendments weren't legally valid, but I was concerned that if we didn't follow them, because it gave Greg an equal share, that he would start a lawsuit. He started a lawsuit saying, let's get rid of the amendments. But here's the clincher. And I still can't believe it to this day. They waited. They waited. They got Kim on, thinking maybe she'll give me an equal share, you know. She didn't give an equal share. So they filed motion after motion after motion throughout this case, this first one, trying to remove her as trustee. And they were not successful during the first case. The judge kind of indicated that should be separate. So after this case ended, well, I got to go back. Before this case ended, and this was after the statute of limitations had expired for contesting the trust, what did Greg do? He sent Kim a letter certified threatening her, I will sue you if you don't give me an equal share. So then what did they do? Just as he threatened, and Scott agreed in an email to Kim that he thought Greg should have an equal share, after they litigated to get rid of having an equal share, they both started a lawsuit to remove her as trustee with all these fabricated things that she was a bad trustee. And that was never the case. That's what happened here. And they've been gaming the system ever since. And like I say, I don't need to read all these rules again to you, but you need to know that. The next thing I want to talk about is the judgment for rent, which I just noticed something on. There's actually 2 orders about that judgment for rent. And I want to see, I didn't see it right away. First of all, they never pled the issue of rent. Now, I'm a pro se person, and as you can probably tell, I'm not savvy, right? If somebody throws something right at me, I have to research it, and I spend almost all my time doing that. I've been up, I can't tell you how many nights I haven't slept, sometimes 5 in a row, researching, trying to find out what these laws are. I had a little bit of law school, so that was what I was good at, was interpreting the law. But it was too much paperwork. I didn't want to stick with it. So here I am. All I've been doing since 2020 is paperwork. It's part of the time I've had attorneys. Most of them were in over their heads. The one that was excellent that I had to quit for a family problem. So I'm without one, and I'm also without one because of something else they did afterwards I can't tell you about that made me go totally pro se on this case after having 2 attorneys start the case. So this rental issue, it was never pled. It's not even a requirement of the trust for a family member. My dad gave gifts to the other gifts and compensation to my siblings, and he asked me to move back into the estate home. He bought them either a house or property and a house. And the one property at the time, that property, he was offered over $100,000 for it over 35 years ago. And those properties, not even in as nice of an area of that, have been going anywhere from 55 to 75,000 per acre, and it's 20 acres. So just figure it out without this across from the golf course from your earlier case today. So the Wallen Lake Golf Course. So that property is very, very valuable and was at the time. And so that's what was his way of compensating me. I took care of my mom and dad. But he asked me to move back into the house, and gave them all different properties because he knew he didn't want that property sold. He wanted it preserved. That's how I ended up in the house and taking care of my mother who had a stroke and my father who had a stroke. Now, the documents, the estate documents say family members who take care of their parents are supposed to be compensated, as are fiduciaries and as are the power of attorney. That was all denied to me, even though I figured out what it would have cost and I cut it way down. Just to give you a rough idea, my mom had been in a nursing home and they had figured it was going to be pretty close to $100,000 for 1 year for her to be in that home. I figured 3 years. I took care of dad for 3 years. I took care of mom, not over 3 years, but 3 years after he started having memory issues. Mom for ever since 18 months after she got out of the nursing home, and she was nursing home care. She was in a wheelchair. She couldn't walk. She was heavy. She couldn't talk except for to say, you know, yes, no, and certain things. She could make herself, you understand, but she was nursing home care. She had to be put on a toilet. We had to stop and buy a lift in order to take care of her. She was not an easy person to take care of. In fact, the home we took her out of threatened to get guardianship from me, so I couldn't take care of her at home. So I took care of her. And then that wasn't just the last 3 years for my dad. It was before that. If you would have added it all up, it would have been at least double that. But that was all denied. My fiduciary fees were denied. Defaulting me, my attorney fees were denied, even though 2.6 of Exhibit B of the trust, the indemnification paragraph, that says that I am supposed to be paid up front, like for right here, being here right now, because it's in any jurisdiction in the court code. I'm supposed to be paid up front without awaiting the outcome of litigation unless by clear and convincing evidence. That's what it states in 2.6, that malfeasance, and there's 3 words, are found. And that was never found for me. But yet I have been denied my attorney fees. I have been denied the fees for this and said I've had to pay for them. And it's not that I pay if I prevail, that the trust pays if I prevail. The way the wording is, it pays whether I prevail or not, because I was wrongfully removed by default. So 2.6 is protective. The other thing 2.6 says is that Scott and Greg, beneficiaries who start this action against the trustee, the legal fees, all the legal fees for the trust are supposed to come out of their share first. So that got tossed out the window. So there's been a lot of things that have gone on in this case that are not okay. So let me get to this rent payment here. Like I say, the trust does not, that doesn't ask a family member to pay rent. Just,
we've 5 minutes left.
okay, I better hurry, but because this is important. The family member, it's 6.1.5. It's only when the $200,000, or supposed to be $400,000, is exhausted, then the people who are benefiting from staying there get then they pay the expenses, not rent. So a family member's not supposed to be able to pay rent, but I got to get this down, then I'll save some of my time. It says for the rent here, included in this order and another one on this same day, it talks about a vote in accordance with 6.1.2. Well, 6.1.2, that's how the judge interpreted it. There was never any majority vote for me to pay rent. Never has been. So the trust doesn't require it. That was Dad's compensation to me. And now they're trying to stick me with this large amount of rent that my dad would be very unhappy about because I'm the one that took care of him and he wanted me to have and stay there. I should probably reserve my time, but when these things go, the things I've already talked about go, a lot of these other things like the legal fees paid to the brothers, that goes. A lot of this stuff goes because those first things need to go, because that's what happened in this case. And I'm going to stop because I reserve a couple minutes.
Yep.
Thank you, Your Honors.
Thank you. Whenever you're ready.
Thank you, Your Honor. May it please the court, Alan Telgenhoff on behalf of Applebee's Scott and Greg Ecker. This is Ms. Ecker-Nichols' second chronological appeal to this court of 6 filings in this court. She initially, while the underlying case was ongoing in this matter, filed an interlocutory appeal following entry of the default judgment. She took that after her appeal was denied here. She took that to the Supreme Court, who refused to grant leave. She filed subsequent cases, as I indicated, I think 6 in total. One has been heard by this court, ruling issued in favor of my clients. She sought leave in the Supreme Court of that. Leave was denied. I bring this up only to respond to her argument today that it's my clients somehow who are litigious and trying to game the system to take advantage somehow of a pro se party when factually it's the opposite that has transpired from the beginning. I was quite taken aback, honestly, when Ms. Ecker-Nickel agreed on the record here before this court. She said, quote, "I knew that the amendments weren't legally valid," end quote. I don't believe she's ever acknowledged that in the Emmett County Probate Court. And although her removal as trustee in this case began upon entry of a default, a partial entry of default judgment against her, certainly an admission by a trustee that they had promised in writing to their siblings, beneficiaries, that they were planned to be bound by trust amendments that they knew were not legally valid, would certainly be grounds for removal as trustee. She utilized what appears, and it's by her own testimony, I'll take her at her word, that her father wanted to or had discussions about amending his trust, and he passed away before a finalized version of those amendments were completed and before he signed them. And then despite that, she signed them on his behalf and notified her brothers and her sister that she planned to live by and administer the trust according to those. The issue of her removal as trustee has been litigated numerous times in the lower court. Motion to set aside default, motion to set aside default judgment, motion for reconsideration, motion for reinstatement as trustee. And so while Ms. Ecker-Nickel is clearly correct that the first time when she was removed as trustee, it was as a result of her not responding to the litigation, that wasn't the end of the matter, certainly by Ms. Ecker-Nickel's part. And actually, subsequent to this appeal, she's raised the issue in the lower court again and again and tried to be reinstated as trustee. And there were grounds, and there are grounds on this record to support the removal as trustee, including her new admission today that at the time she was going to administer the trust with these amendments, she knew they weren't legally valid.
Sir, can you comment just briefly? We had Miss Martincheck listed as an appellant, but there was nothing filed by her or anything else. Is she really a part of this action?
I assume that she supports her sister. She always does. Typically because she, well, at this point in the probate court case, she has an attorney. But at the time that this appeal was filed, I think she was improper. Typically what she would have done is filed just a one sentence statement indicating that she agrees with her sister's position.
Okay. Thank you. I appreciate that. Go
Yeah.
ahead.
I don't need to respond to everything that Ms. Ecker-Nickel said here today, obviously, but with respect to the issuance of the default judgment, and the default, she had indicated here on the record that she couldn't find an attorney. It was during COVID. The attorney quit. One of your honors, and I apologize, I don't recall which, had talked about the fact that she had chosen not to respond. And actually, in the affidavit that was filed in the lower court, where she sought to establish good cause, what she indicated was not that she had an attorney that was in over his head or that she couldn't find an attorney. What she indicated was that she thought that the matter could be resolved between the parties. And that's the reason why she didn't file a response. And that is on the record, and that was part of the court's ruling, was that that didn't establish good cause, especially where we have the extent of disagreement that we have between these parties. So the default was properly entered. The judge bent over backward, frankly, to allow Ms. Ecker-Nickel to continue to participate in the proceedings. Just some of the examples that she gave, Your Honors, this afternoon, talked about these text stream that she introduced into evidence, which frankly wouldn't be very relevant with respect to the issues that were raised, but she was able to introduce those texts. She was able to make these arguments. She talked on the record here today about cross-examining her brother. She participated fully in those proceedings. So this wasn't a situation where, well, you're in default, there's a default judgment against you, you just can't participate anymore. She filed the trial brief. She participated fully in the proceedings. So she raised the issues that she's talking about here today. If I'm understanding her correctly, it sounds like there are a few that she's thought of more recently, maybe even after the briefs were filed in this case. But in that extent, they're not properly before the court. But all of these other issues that she's raised are things that either she raised at trial or she could have raised at trial, and they were rejected by the trial court. Just looking to see. With respect to the issue of rent not being pled, one of the things that was pled from the very beginning was that my clients were seeking removal of Miss Ecker-Nickel from real property that was owned by the trust. And that was clearly pled, and that was a part of the proceedings. And the court issued a pretrial order to clarify the issues that would be determined at trial. And one of those was, in fact, the occupancy, potential occupancy of Ms. Ecker-Nickel of the property, and the terms upon which that would occur, which would clearly indicate rent. All the parties tried the issue of rent. Ms. Ecker-Nickel argued about rent in her post-trial closing argument brief that she filed. This was not a situation of surprise where somehow it turned up in the order. She actually admitted on the stand that she should pay fair market rent for the property. So there were no findings of fact that were clearly erroneous in this case. The default judgment and the attorney fee awards were within the court's discretion. And with respect to the interpretations of the trust that Ms. Ecker-Nickel has raised, the court was correct in those interpretations of the trust. So for those reasons, we'd ask that the lower court ruling be upheld.
Any questions?
No, thank you.
Thank you.
Thank you.
We appreciate your patience. I know it's been a long day.
I'd like to continue how many minutes?
I think you have 2 minutes, yeah.
First of all, I never did agree that I should pay full fair market value of rent. That's not true. Mr. Telganoff was not the attorney of record at that time. Mr. Breitner was. He did come on before just towards the end, but he doesn't know all the facts of this case as I do. And as I said, I didn't sign my father's amendment. I signed a separate piece of paper saying we would follow it because it benefited Greg. And as soon as I got the letter, before any litigation
How would you have
started,
authority to do that, since upon the incapacity of the settlor, the trust is irrevocable?
that's why
How do you have the authority to do that?
that's why I signed a separate piece of paper saying we'll follow it for Greg's benefit because
So you're entering, even though you're the trustee, you are specifically entering into an agreement which is contrary to the settlor's specifically articulated purposes and goals, correct?
No, I'm saying I'll follow it for Greg's benefit because
But the settlor, your father, didn't formally adopt that before his incapacity,
But he
either by
never-
death or by incapacity. Is
He
that
didn't-
correct?
He didn't change his mind on it. He was having it drafted by his attorney. It was the only, and as soon as I found out that somebody objected to it before any litigation and found out that he didn't want to get an equal share, I said, fine, then we won't. It was just a courtesy to him, that's all. And it was,
It's a courtesy you did not have the authority to extend.
well,
Under the
I
law-
wasn't, it
under the
wasn't,
law.
it wasn't authority I was exerting. It was kindness to give my brother a share so we wouldn't have to sue. And the point, the reason it was,
Are we at time?
Yeah.
the reason it wasn't authority is immediately when I found out that that's not what he wanted, I said, I'll get rid of it. But then what'd he do? He threatens to sue my sister who's sitting back in court if she doesn't follow the amendment that they just sued to get rid of. That gave him the $100,000 equal share, and then they sued her, and that's a violation of 4.4. So they should have taken my offer. They've spent thousands just litigating those two amendments that I said, I'll get rid of them.
We will review the case. Thank you. The matter has now been submitted. And that's it for today.
All right, thank you. Your Honor.
Court's in recess.
Thank you.
Court's in recess.